they be necessary in phase two. Obviously, we're not to phase two yet, but we would like the opportunity to take a look at them. So,
in advance of
yes.
phase two. All right. I don't think there was a written motion to quash. I think Mr. Wood said he was actually planning to comply with that. So we'll take that up at the next break.
Thank you.
All right. You can bring in the jury.
Because we'd have the same request with production.
I understand. I was waiting for y'all to re-raise it, and so I didn't know if the issue had gone away.
We filed a motion to quash.
Right. Do we have any audio-visual things that have been tested here? Do we have you ready to go to start playing things you need to play?
Yes, Your Honor, we'll be ready in 1 second.
Yeah, I'm looking.
Our last jury. President Conklin, Your Honor.
Thank you, Deputy Scott. Please be seated, everyone. Welcome back, members of the jury. Thank you for being back and on time, ready to go. We're ready to resume with the plaintiff's case in chief. But before we do, I just want to emphasize and provide you with some additional instructions, something that I had talked about during voir dire, but I think it's become pertinent now, which is, as I mentioned, a defendant has the right to represent themselves at trial. And that decision itself has no bearing on liability in this case. But when someone acts as their own lawyer in a case, you will hear them speak at various times throughout the trial. They can ask questions, they can make an opening statement or a closing argument, ask questions of witnesses, make objections, and argue legal issues. But I want to remind you that when a person representing themselves or any attorney speaks in those parts of the trial, they are acting as a lawyer, and those words are not evidence. The only evidence in this case comes from the witnesses who testify under oath and from exhibits that are admitted. If someone representing themselves chooses to testify under oath, then and only then do they become a witness. With that, plaintiff may proceed.
Thank you, Your Honor. Good morning, Mr. Wilson.
Good morning, Ms. Brown.
Taylor, we've heard some recordings throughout this trial so far. Did defendant Wood know you were recording him?
Yes, he did. Actually, he told me on one occasion that he was recording me, and I let him know that I was and would be doing the same.
And why were you making these recordings at that time?
I initially began recording Lynn in late January of 2020 because his behavior had grown so wild. And unfortunately, it then became so threatening against us that I felt like I needed to continue to do so. And not the least of which is that Mr. Wood would continue to remind me that he had all the power and who he was and who I was, and that nobody would ever believe anything that I have to say about him.
And all of the recordings that you or Mr. Grunberg or Ms. Wade made of defendant Wood, have they all been produced to the defense in this case?
Every single recording of Mr. Wood has been produced to him since at least 2020. And I also know of no recording that Ms. Wade ever made of Mr. Wood. Just Mr. Grunberg and I.
Thank you. And we've heard some excerpts from conversations that you guys had. The recordings that you produce at least is 2020, sometime throughout this lawsuit. Were those produced in their entirety as well?
Oh, yes. Every word of every conversation that was ever recorded between Mr. Wood and any of us has been produced to him in their entirety. And, you know, a couple of them are 3 hours long. And so we're getting a couple minutes of excerpts. Some may be longer than others because it's what we thought was most relevant for the jury. And so we don't waste the court or the jury's time. And frankly, for privacy reasons. I mean, the vast majority of these things just have not a whole lot to do with why we're here.
And what about the voicemails that we've heard? Have those been produced in their entirety to the defense throughout this case?
Yes, every single one of them.
And I believe yesterday we had, just for housekeeping purposes, Your Honor, I believe exhibits 57, 57A were admitted over objection. Before I play 57, I just wanted to confirm.
That's right. You can publish.
Okay, thank you, Your Honor.
Hey, Lynn.
Good morning.
How about hey boss, like you've been doing? Hey boss,
Hey, boss.
Hey, boss.
give me there.
Yes,
What'd you say? Did you say hey boss?
Dylan.
No, that's not gonna work. Did you say hey boss? Cause I'm the boss. So just say hey boss like Taylor's been doing and Jonathan just did, Kimmy. I want you to say hey boss.
Hey, boss.
Thank you. Has everybody now said hey boss?
Yes.
All right. Taylor, you agree everybody said it?
I agree.
Kimmy, did you say it?
Yes.
I don't care whether you believe in your hearts by your own free will that I'm your boss or not. The truth is you're all the boss of yourself because you have free will to be that. Now, does everybody understand what I just said? Taylor, you answer for the group. I don't need to take a damn vote. You take it, say yes or no.
Yes.
That's a good vote, unanimous vote. Here's what you need to know. And I'm going to tell you how to solve this problem that I didn't create, but you created for me. That affects your lives and possibly Richard yours. We're going to fix this because you know why? Taylor for the group, why?
I don't know what the problem is or why.
No, I didn't ask you. I know what the problem is because you just need to go. You can say what's the problem, and I'll tell you. Nobody's going to say a word until I finish, and then I'm not going to ask for your opinion. I'll tell you why. You want to know what the problem is?
Yes.
Is that a group? Yes.
Yes.
The problem is this: Taylor Wilson, 31, thinks he knows more than I do. Jonathan Grunberg, how old are you, Jonathan?
43 in 2 weeks.
Thank you. Jonathan Grunberg, at age 43, thinks he knows more than I do. Kimmy, how old are you?
31.
Kimmy Bennett, at age 31, thinks she knows more than I do. Have I said that correctly? I think you all think you know more than I do. You may be a good thing you're getting ready to hear, but Zach, does everybody understand what I just said?
We understand what you said. This is Taylor.
I did not, Taylor, I didn't ask you to agree or disagree with it. This is my office. You know that even though I didn't ask you to say you were wrong, I knew you had the damn bullheadedness that you would never say that. Same thing with Jonathan. Even the same thing with little Miss Bullheaded Kenny. This is going to be a compliment to y'all to shut up for a minute and listen. I mean, shut up. I own that all. Y'all know that now. I showed you who had power, didn't I? But I didn't exercise it. Because I right now would never do anything in the exercise of my power hurt any of y'all or your family. You believe me? Because if you don't believe that, this conversation is over. It will not be a problem solved. If you tell me you believe that, and I just showed you that without hurting you, by showing you who had the power to hurt you, to hurt your families, to hurt your law careers, and didn't exercise it, do you, here's the yes or no. Let's get a vote, Taylor. Does everyone in that room choose to believe that Lynn Wood would never exercise his power in a fashion that he knew would hurt any one of you, personally or professionally, including your family and your legacy as a lawyer? Yes or no, guys? Gail?
Lynn, I certainly.
I just wanted yes or no. I didn't ask for a discussion, and I own that office. If you don't do what I say this time, you're going to pack your bag. That's how much power I have. I don't want to exercise that power. It would hurt you. Don't force it. That's the point.
Well,
And you didn't force it. I just want a yes or no.
Well, it's because of, yeah, but.
No, now. Whoa. You're not doing what I say, and I'm the boss. I own that office. You have no power.
I understand that. You just said.
No, you're not listening. You can't understand what you don't have the sense to listen to. If you listen enough, you're going to know that I'm right, and it's going to be a compliment to you. Can you listen to hear a compliment to yourself, for God's sake?
Yes, can I respond to?
No, not until I ask you to. Give me the control that you have to give me, because if you don't, as your boss, you're going to move out of that office today, and I don't want to do that.
I
That would hurt
agree.
you.
Yeah, but that's the problem. You're asking me to agree you won't hurt me while telling me you will hurt me.
I'm telling you, I have the power to hurt you, and I would never do so. And if you don't think I have the power to hurt you, you are wrong. I can hurt you the minute I take you off that name. That will be a bad stain on your life. And if you try to hurt me back, you will be laughed at. Anybody in this law office that attacks Lynn Wood may be right, but everybody's going to disrespect you for doing it. There's a time to speak. There's a time to be silent. You people don't know the difference. 28, did I make you get out?
No.
Yes or no? Did I take the name off the door?
No.
Yes or no? Right. Did I tell you that the best you could do in a law court was to get quantum merit under any of the damn Salmon cases? Did I tell you that clear enough? If you read that in the lines I wrote?
That's what I understood from what you wrote.
Thank you for showing that wisdom. I think everybody would agree, except for Kenny, because she doesn't get paid like that, right? Right?
Yes.
Taylor, did you get it? Jonathan got it. Did you get it?
Yes.
Did I use the precise words? You can stick it up your ass on the $400,000 or $500,000. I don't even know what you get, and I don't care about money. You do. That's fine. That's your choice. I'm not arguing. Was it clear to you you could get maybe $350 an hour for every hour you could manufacture and make it reasonable in that Salmon case? This case, the next case, and the next case, and the next case. Did you understand that?
It's clear that that's what you were writing.
I want to hear if Taylor understood.
Yeah, I wouldn't manufacture hours, but otherwise, yes.
I'm not suggesting that you would, damn it. If I thought you would manufacture hours, I'd throw you out of that office 15 minutes. Security will be there in 15 minutes. If you think I ever thought that you would manufacture an hour, because you're telling me I'd practice law with a dishonest, unethical lawyer. Do you think I would do that?
No, and I was just responding to your question, which used the word manufacture.
No, you were trying to make your own damn point. That's what I'm... All right, now let me give you an example of a law firm and not a law firm. We're for partners. We're not boss and employee, even though we could be, because I have the ultimate power in that office to get you out. They give you what the money I either agree to, which I would always do, or the money I think you're entitled to. Taylor, if your beautiful wife, knowing about your son's age, knowing about your skills as a lawyer, being pissed off as hell about the way I treated you, where I flexed my muscle and made you stay, and she didn't want you to. She looked at you and said, Taylor, if you don't leave that law firm, I'm going to leave you. Taylor, would you leave the law firm, or would you stay and would you leave the law firm and stay with your wife, or would you stay with the law firm and lose your wife?
I'd leave the law firm.
You damn bet you would. Who would be making that decision? Me or you?
Me.
Then you lied. I mean, after you lied, you thought you were telling the truth. Who has the ultimate power to decide your fate? Ultimate power. The only power. I think the co-power is more accurate. Who are the two people in this world, besides you and me, that can decide whether you stay at that firm or leave it? I think it's you and me, Taylor. Do you agree?
Yes, we both have that power.
Jonathan, do you agree? You and I both have that power. You and Lynn Wood and Jonathan Grunberg, as two individuals, both have the same power.
Yes.
If I owned it and kick you out, change what you make, give you your assignment, and you don't want to do it, you make a decision on your own free will. I don't care about the money. I don't care if it's $350,000 or $50,000. Money's not that important to me. I don't care, no matter what it may mean to my fortune, my fame, to work beside Lynn Wood and have my name on the letterhead. I don't care enough about it to say if I want to go. Would everybody agree that's approved? Not you, Kenny, because you're not a named partner. To my named partners, and I'll vote in abstention for Nicole, she's going to agree with me on everything I say. I'm just going to vote, and I'm going to write a property. I hadn't talked to you. I bet you Jonathan and Taylor would agree with me.
Yes.
Yeah.
Yeah, because here's what the point is that y'all are missing. Y'all need to understand this. I don't have ultimate power to determine anything. I don't, and as far as the existence of that fund. I share that power equally with every named partner in that fund. Do you now agree that I'm right?
Yes.
Taylor can go, everybody can stay. Nicole can go, everybody can stay. Jonathan can go, everybody can go. I don't have any power greater in that law firm than any one of the members of that partnership. Do you agree with that now?
Yeah.
As to the members of this law firm, I agree with the following proposition. That if we want to stay together as a group, Wood, Wilson, Grunberg, and Wade, we all collectively and we each individually share the power to answer that question. Do you agree with that?
Yes.
You ever don't give me respect in that office, knowingly, everybody's going to slip up and accidentally say something that's disrespectful. I forgive that. But if I ever discern that I think you are disrespecting me in that law office, that little man or woman is going to come up there in 10 minutes and they're going to throw your ass out. Do you understand, whether you agree with it or not, you can see that I have the power to do it. Do you understand what's going to happen to you if I ever discern that you show me an act of disrespect again?
Yes.
I'm not asking you to be perfect. Jimmy, I'm not asking you to be thrown out if you interrupt me. But if you do it in a disrespectful way, in my judgment alone, any one of the three of you is going to be escorted out of my law office within 10 minutes if they're available. They're going to take you out and throw you on the street if they want to. And following you is going to be every file that you own or your personal belongings. Do you understand what I'm telling you?
Yes.
Because if you don't, we got a problem. You hear me?
Yes.
Everybody hear me?
Yes.
And I'm going to tell you something very surprising. Y'all just heard from the almighty land. It sounds powerful and you believe it, don't you? Jonathan, you a little bit, what are you, where, are you Chilean? Is that what you claim your ethnicity to be?
Chilean Jew.
You look a little bit different than anybody else in the firm because ain't another Chilean Jew in the firm, is there?
I think we all look pretty different.
I didn't ask you what we all look like, damn it. Can you not learn to answer yes or no? Am I going to throw you out for what I believe is your intentional disrespect of my request? I think you want to say yes, Lynn, you're right.
Yes, I look
You
different
want to
than
try
others.
that? You want to try that answer again? I feel like a damn teacher having to slap you on the wrist because you don't want to follow the rule. Jonathan, just say yes or no. I know you got a different opinion sometimes in how you want to express yourself. I'm asking you right now to don't take the risk that I might not agree with you. I might throw you out of that fund. Just like, of course you would, because I never did it. Why would you think that being a fair man to you all of our lives together, why would you think that I would all of a sudden do something that's unfair? I don't understand that logic. I think your logic is flawed. But I understand how you jump there because you're all scared to death. I was going to cut you out of money that was actually coming in another week or so. Handman versus CNN. I'll commit sins. I'll push you when you piss me off. Maybe you deserve it. And I'm the only one that would inflict it upon you because I'm the only one that has the courage to tell you the lesson. Fuck that. Don't do it again. Swear I'll never do it again to either one of you. Although interesting, I've done it to both of you once. I'll never do it to you again. Don't ever do anything that would even make me think about doing it again. Because I might make the same mistake then that I made then. I might push you. I don't mean to hurt you. I wouldn't mean to push you around physically with either one of you. Whip my ass. Or maybe you wouldn't because you don't have the courage I have. Maybe I would fight you till you damn die. Or both of us die. Because I got courage inside every bone in my body. You'll never know. I wish you had it. I wish everybody had it. Everybody doesn't have it, guys. You wax and all the man has courage. I believe that every one of you would say if this was not unrehearsed, it's the greatest single lesson I've ever heard spontaneously. I'm going to tell you something. You all know it's unrehearsed. You know why it's right and why it makes sense. And there's one more part to tell. You know why? Because when I get up and I talk, I speak from the heart. The heart never lies. The brain can fool you. The brain can manipulate. The brain can create truth out of lies if you want it to. The brain's a little computer. You can program to do anything you want to. But let me tell you what you can't. You cannot program is your heart. Your heart feels a certain way. The best man you'll ever see in life won't be your daddy, Taylor. It won't be your daddy, Jonathan. It won't be your daddy, Kenny. The best damn man you've ever met in life is Lynn Wood. Don't you forget it. But in the meantime, while you might secretly know that, don't you tell your daddy that, because you know why? You would violate the commandment to honor your father. Don't you ever honor me. I'm not your father. I'm just your friend, lover, if you love me. Friend, if you accept my friendship. Boss, if you accept me as boss. Co-employee, if you accept me as employee. Or just plain member of one damn law firm like we all are. Remember that, like we all are.
Excuse me. Taylor, I know that recording was kind of long and there was a lot in there. Just to remind us, this was a sort of meeting that happened on February 13th, 2020. Is that correct?
Yes, this was on February 13th, 2020, which is a critical week in between February 10th, first time I confronted Mr. Wood, and the next day, February 14th, when we left. I did see there, this is important, I think, to Mr. Wood, where it says the brain can create suicidal lies, it said the brain can create truth out of lies, not suicidal lies.
Thank you for that correction. And just for this clarification purpose, if the transcript is any way different than what we heard on the recording, you would say the recording is the accurate version. Is that right?
Absolutely. The transcript's just an aid.
Okay. And we heard Defendant Wood in these excerpts from this meeting call you guys as partners repeatedly. Was that something that he commonly did throughout your time working with him since you were promoted in 2018?
Yes, because I was.
And we also heard him say that he had the power to hurt you guys. Did he say that to you more than just this recording we just heard?
Many times, and I mean, I think we're going to hear him then exercising his power. And obviously, he put me to a choice, and I made it the next day.
And having your boss and your partner tell you repeatedly that they had the power to hurt you, how did that make you feel?
It was a terrible time, and he was right. He had the power to hurt me, and I knew it. He had all the power.
Mr. Wilson, can you take a look at plaintiff's exhibit 58 and 58A? Tell us what that is.
It's a voicemail from February 15th that Mr. Wood left for me. And yes, it's a true and correct copy.
Thank you. Your Honor, at this time, I'd like to move to have plaintiff's exhibits 58 and 58A admitted into evidence.
The objection to 58 and 58A.
One moment, Your Honor. What was the last exhibit?
58A is the recording itself. 58 is the transcript.
Or the one we just listened to?
Oh, 57.
No objection, Your Honor.
All right, 58 and 58A is admitted.
Thank you. And Taylor, before I play this, you said this was a voicemail you received on February 15th. Is that right?
Yes, this is February 15th, the day after we left the law firm.
Taylor Wilson, your former partner, who you have abused and treated like a dog repeatedly for weeks, if not months. You're lucky you and I share something in common. I care about and love your wife. I care about and love your little boy. Right now, I don't give a damn about you. But if I hurt you bad enough, it's going to hurt them. I don't want to hurt you, Taylor. I want to be able to try to kindly be around when you figure out what your next move in the law is. Let's try to keep it that way. I want you to tell me in an email in 15 minutes who in the hell asked for those computer files to be deleted. I think it was Jonathan Grunberg. I think he did it because Rick Miller wanted it done. And I think, unfortunately, he either got Timmy, probably her, who works for me only, did. Maybe Chelsea. I just want to know that information because I'm going after Rick Miller. I've already gone after Rick Miller. He's lost his job. He's going to lose his new job. I'm going to get Rick Miller. I don't want to get you if you'll hurt your wife and your child. Send me an email to tell me the truth without getting a lawyer, without trying to cover your ass. Tell the truth, the simple truth. The truth will set you free, Taylor. Trying to cover it up through a lawyer or anybody else is going to get you in more trouble with me, and you're bad enough. Don't make it worse. Let's try to make it better. Let's start trying to heal it before it gets to a point where it can't be healed. I think you understand this message. I'll get it by text. Send it to me in 15 minutes. Goodbye.
Is this another time, another example of Defendant Wood saying that he could hurt you if he wanted to?
Yes, and of course referring to me as his former partner.
And did you have any idea what these allegations he was talking about with the computer files?
No, they're completely made up. And once again, he was making me choose between my family, my 2-month-old boy, my wife, and my career. As he said, it'd be professional suicide to leave him.
And did you respond to this voicemail or any of the other voicemails that he left you?
Yeah. I mean, usually by email or text, but yes.
Okay. And I'll point you to Plaintiff's Exhibit 91. Will you take a look at that and tell us what it is?
This is a text exchange between Lynn and I in the morning of February 17th, 2020.
And is this true and accurate copy of the text messages you sent and the text messages he sent you?
Yes.
Your Honor, at this time, I'd like to move to have Plaintiff's Exhibit 91 entered into evidence.
Objection to 91.
No objection, Your Honor.
91 is admitted.
Thank you, Your Honor. And Michael, if we can blow up the 4 texts that we see here from Taylor and okay, Mr. Wilson, these top 2 blue messages, these are from you, is that correct?
Yeah, these are from me to Lynn responding to some similar kind of messages.
Okay. And in here, you tell him that you listened to his second message and that you've done nothing at all that he's described and know nothing about it. And you asked him not to contact you. And what was Defendant Wood's response below?
Fuck you, you're going to jail. I mean, that's how I dealt with Lynn. I was just trying to appease him so he'd stop trying to destroy my life, put me in jail, take my bar license, whatever the hell else he was threatening to do to me.
And did you continue to receive voicemails after these texts exchanged here?
Yes.
Can you take a look at plaintiff's exhibit 252 and 252A and tell us what that is?
This is a February 17th voicemail that I received from Lynn at 7:23 a.m. So 3 minutes after I sent the text message shown in plaintiff's exhibit 91 we just looked at.
Thank you. And is 252 and 252A true and accurate copies?
Yes.
Your Honor, at this time, I'd like to move to have plaintiff's exhibit 252 and 252A admitted into evidence.
Any objection to 252 and 252A?
No objection, Your Honor.
Admitted without objection.
Thank you, Your Honor.
Let me tell you something, you little snotty ass son of a bitch. Don't write me back and tell me you're taking care of your son. Your son's looking at the eyes of a damn low-life, cheating line, probably criminal defendant. How could you do this to your family, Taylor? The FBI is not going to play around. You've all engaged in computer fraud. I don't give a damn whether you did it or Nicole did it. I know you did it, and you got Kenny involved in it. You've ruined everybody's life. You're not going to get 1 cent dime from me. Sue me. I don't think they allow you to file lawsuits like that when you're behind bars. Somebody better call me, put their baby down, and give me the damn proof if there's going to be any mercy shown by anybody for you, including the FBI, because I'm one of the number one witnesses. Rick Miller's going to jail. Don't go with him. Quit playing your games, you snotty ass little bastard. You came here and ran your damn mouth in my office and yelled at me. You're lucky I'm not with you right now, Taylor. Because I'd do to you what I do to my son, and I would beat your ass with a switch so you couldn't sit down for 20 fucking years.
How did this one make you feel, Taylor?
I was pretty much in a tailspin by this point. This is the voicemail that Mr. Wood referred to as saying he would spank me like his son.
And in here, he talks about the FBI and again, these computer fraud allegations. Did defendant Wood ever file an FBI complaint against you guys?
Yeah, I mean, he sent us a copy of it, and this stuff was just coming so fast and furious. I mean, just constant, middle of the night, early morning, middle of the day.
I'll point you to take a look at plaintiff's exhibit 93, and can you tell us what that is?
Yeah. That's a email that Mr. Wood sent to me and a number of other people at 4:56 and 6:16 a.m. on February 17th, attaching an FBI complaint that he filed.
And is this a true and accurate copy of the email and the attachment that you received?
Yes, it is.
Your Honor, at this point, I'd like to have plaintiff's exhibit 93 entered into evidence.
Objection to 93.
Y'all waiting on me?
Objection to 93.
No objection, Your Honor.
93 is admitted.
Thank you, Your Honor. So Taylor, when was the FBI complaint, the one that's attached here, sent around to you guys?
It was sent to me at 6:16 a.m. on the morning of February 17th.
And the voicemail we just listened to, that was the same morning?
Yeah, so he left the voicemail about an hour later.
And can you take a look for us at Plaintiff's Exhibit 259 and 259A and tell us what that is?
This is a voicemail that Mr. Wood left for me on February 20th in the evening.
And then it's 259 and 259A true and accurate copies?
Yes, sir.
Your Honor, at this point, I'd like to move to have Plaintiff's Exhibit 259 and 259A admitted into evidence.
Any objection?
259 and 259A, is they the recording?
Yes.
Just 1 minute, second one. No objection, Your Honor.
Admitted.
Thank you.
Taylor Wilson. Man, oh man. It's your old boss. The guy you love 1 minute, test 1 minute, love 1 minute, test 1 minute. Taylor, you're in a damn mess. And you know it. And if you don't, you're going to talk to a lawyer and you're going to know it then. This is not the way to start your law firm, Taylor. Here's what we're going to do. You're going to get off your ass and put your pride aside, and you're going to come over here and you're going to talk to me. And I'm going to tell you exactly what I'm willing to do to get you all out of the mess you got yourselves in with your foolishness. You're playing with fire when you come after Lynn Wood. And stop being mad at Lynn. Okay, God. Taylor, I don't want to hurt you guys. But you set it up where I could destroy you before you even got your foot off the ground. You can't pay for a lawyer. You can't afford to litigate with me, and you're going to lose. Because you have 75% of that lease to me. Now, a guarantor will sign on it for me. I'll take the building, and then I'll hold your money until I litigate it with you. You got another mess on your hands you've created for the last 2 or 3 weeks. 2 or 3 months, some people. You went out and talked bad about me to other people. And then you took Kimmy over there. Somebody took over there on my damn time. And Nicole damn way. And you around. I don't want you to have this last another day. If you want to sit down and settle with me, I'll be humble. You'll be humbler. We'll talk about what you did wrong. We'll talk about how you're going to fix it. And I'm going to fix it. But you did just about what I thought you were going to do. I'm always 1 step, 2 steps ahead of everybody. I see you around corners, Taylor. Now, why don't you come over and talk to me? It won't take an hour, and we'll settle this mess that y'all created. Y'all leave happy. Everybody will be treated fairly. But if you want to go to war, want to bash egos with me, you want to do good, your free will versus mine, you're going to lose, and it's going to affect your family and your baby boy. And I'm not going to let that happen. If I can avoid it, if it happens, it's going to be on your watch, not mine. So please, Taylor, stop the foolishness. Come talk to a man that loves you, that wants you to succeed, that's taken a lot of abuse from you, but at every turn tries to reach out and get you to do the right thing. You're going to be able to practice law with you people. You're not going to have me around much to worry about. I'm going to get out. I want to get out. I want to be by myself. Timmy's going to be with me. I can come together. Everything in your life is not. Call me. Bye. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4. 10-4.
How did this one make you feel when you received it, Taylor?
I was just scared for my family and my career, and it's just the guy's saying things like, I'll fight you till you damn die, and leaving me all these other messages. And we had just resolved it with him on February 17th, despite everything that he was doing, despite all of the threats, despite his comments about my family, despite FBI complaints, despite threatening my bar license, despite telling me he's going to render me broke and homeless. And he turns around and says, I know I made that deal, but I'm not going to pay that one either. And, you know, just the concept that I'd go meet with him in person at this point in time is just kind of.
And speaking of that February 17th agreement that we looked at yesterday, I believe it's plaintiff's exhibit 94 that's already admitted into evidence. What preceded you sending the email that you sent in plaintiff's exhibit 94?
Mr. Wood had, in the late afternoon on February 17th, called me and just effectively begged me to set a conference call between himself, me, Mr. Grunberg, and Ms. Wade, to, in his words, make it all better. We had that call later in the evening on February 17th, where what is shown in Exhibit 94 was agreed to in our telephone conference about basically him saying that he would abide the compensation arrangements that we had already made before we left the firm.
Okay, and did the compensation that you guys agreed to in this exhibit, this include the salmon fees or the salmon fee?
Yeah, it included the salmon v. CNN fee. In the same manner that it ultimately went into the March 17th, 2020 settlement agreement, same thing.
And was this February 17th agreement in line with historically how you guys split fees on contingency cases?
Yes, and you know, specifically with respect to the salmon fee, it's precisely what Lynn said he was going to do before we left the firm. He was going to receive 50%, and the three of us were going to split 50%.
And did you ever put any pressure or threaten Defendant Wood to enter into this February 17th agreement?
No, I just begged him. I just told him I loved him and cared about him and begged him to stop doing what he was doing to us.
And did you threaten anything in regards to Defendant Wood's children to get him to enter into this February 17th agreement?
Absolutely not. Mr. Wood was forcing me to have conversations with his children. His children started calling me because they knew that I was likely the closest person to Mr. Wood and somebody that was willing to try to help. And I just did everything I could do for Mr. Wood and his kids as best as I could do it.
And did you ever do anything that would have impacted Mr. Wood's relationship with his children?
No, absolutely not. I told them that whatever was going on with their father, that he loved them.
And after this February 17th agreement that we looked at Plaintiff's Exhibit 94, did you continue to receive voicemails and calls from Defendant Wood?
Yes.
And I'll point you to take a look at Plaintiff's Exhibit 97 and 97A, and can you tell us what that is?
Yeah, this is a voicemail that I received from Lynn in March 2020.
Your Honor, sorry, hold on one second. Mr. Wilson, is this a true and accurate copy? At Plaintiff's 97 and 97A?
Yes, it is.
Your Honor, at this point, I'd like to move to have Plaintiff's Exhibit 97 and 97A admitted into evidence.
Objection.
What is the date of this?
And it was received in March of 2020.
Okay.
It was March 4th,
March 4th.
2020.
Okay, thanks.
March 4th. Mhm. No objection.
Submitted.
Thank you, Your Honor.
Taylor Wilson, listen carefully to me, young man. This is the last time you're gonna hear my voice until I cross-examine under oath your sorry ass lying motherfucking bastard. You fucked with my family. You fucking tried to cheat me out of $1 million. You are going to hell and God is gonna condemn you for it. You'll never, ever be able to make your way out of it by any deeds and acts. God gave me permission to make this phone call. Send a copy of it to your damn boy, Drew Bill. He's not going to want to touch you with a 10-foot pole. I'm ashamed of you, and I feel sorry, and I will pray for your wife and your boy. You've ruined everybody, but you didn't ruin me. Jonathan and Nicole won't get a message like this from me, but I can't wait to cross-examine every one of you sorry bastards. I know everything you did. I know every lie you told. I know everything you fucking tried to do to my family to try to line your damn pockets. You'll rot in hell before you'll ever get a dime from me, young man. You're going to pay out of the nose, and you're going to lose your license to practice law. You fucked up, buddy. You fucked with the wrong man. You fucked with Earl Lynn Wood, and you fucked with my family. Goodbye, Taylor. I'll see you next time when you're under fucking oath.
How did this one make you feel, Taylor, at the time?
Mr. Wood wanted us intimidated, and I was intimidated. He's just so angry with me for just made up things when all I had done was actually show him a tremendous amount of love and respect, and tried so hard to help him with whatever was going on with him. And, all powerful art of cross-examine Mr. Wood once again telling me that he's going to sue me, destroy me, cross-examine my ass under oath. Same old story.
I'm sorry. And in this voicemail, we hear him mention Drew by name. At this point, March 4th, 2020, you had already hired us as your counsel. Is that right?
Yeah, we hired counsel after Mr. Wood reneged on the February 17th agreement and started asserting that we were responsible for his lease, which, of course we weren't, because we were non-equity partners and there was only one tenant on the lease. But obviously we agreed to pay it in the hopes that this whole thing wouldn't happen and I wouldn't be talking to these fine folks.
And did defendant would ever try to put pressure on you by contacting any of your family members?
Yes.
Can you take a look at Plaintiff's Exhibit 260 and 260A and tell us what that is?
This is a March 3rd voicemail that Mr. Wood left for my wife around 10:30 at night, roughly contemporaneous with some of the smoking gun emails.
And is this are these true and accurate copies of the transcript and the recording that's attached?
Excuse me, Alan.
Nope.
Sure, I've got the right exhibit.
260 and 260A.
I do not have the right. Thank you.
You're welcome.
I think you asked if it was true and correct. Yes, it is.
Your Honor, at this point, I'd like to move to have Plaintiff's Exhibit 260 and 260A admitted into evidence.
Any objection to 260, 260A?
might just make a point of inquiry. This looks like two different excerpts. I can't tell. There's one under Linwood :01, and then there's apparently one that says :48. Is it the same one?
I think that's just a time marker.
Yes.
That's what.
Yeah, so it's all one recording, one transcript.
Thank you. No objection.
All right, 260 and 260A is admitted.
Thank you, Your Honor.
Julianne Wilson. You got a handsome little boy, baby boy. I need to see him soon. I will. Listen, I know I'm calling you. I'm not calling Taylor. I'm not supposed to. This will be real short. You're going to learn some things. Taylor's going to learn some things the next day or two involving Taylor and Nicole and Jonathan and me in the league. It's going to sound bad for him at first, bad for you. I want you to know something, Julianne. I told you I love you. I told you I love your son. I love your husband, Taylor. I'm not going to let anybody get hurt people. I'm going to do what's right. I'm going to do what's good. It's going to be fair. May not be everything anybody wants, but it's going to be fair. And it's all going to be good. I'll be your son, Texas, Taylor. But I think Taylor Wilson is one of the best damn young lawyers I've ever seen. A lot of things about Taylor remind me of me. I meant it every time I told you. I said I love you. I meant it then. I mean it now. I meant it every time I told Taylor I love you. I meant it then. I mean it now. Just relax. Hang loose. It's all going to be good. It's not going to be as good as everybody wants it to be on this side, his side. But it'll be good in the long run. Your husband's a fine man. Even if he made mistakes, let me tell you. I can't write okay. He will too. So will you. So will your children. Oh, excuse me. That was cool. You don't have more children. You probably have at least 2 more. We'll talk one day soon. It'll be when you decide to call me, or maybe we'll run into each other. We'll talk again and we'll be friends. But I love you. You love me. That answers every dispute that we have in life. And we don't have disputes. We're different. We're different, but we're alike. We love each other. We have to get through this battle of having disputes, fights, arguments. Because everything's really decided when it started off. I love you. You love me. I love Taylor. He loves me. We'll talk soon. So the need to call you tonight. When you listen to this the next day or two, you'll understand why. I see you around the corner before I cross the corner. Bye-bye. Talk soon.
As a spouse, how did this make you feel?
I was trying so hard and failing, obviously, to keep this out of my home. And for him to be saying the things he's saying to me and about my wife and about my son, to call my wife and tell her how much he loves her and make her listen to that. We're laying in bed. You know, and he finishes it with, once again, hindsight's 2020. He finishes it with, I see around corners before I cross the corner. And he literally left this in retrospect, he left this for her right before he sent what you have referred to as smoking gun emails to Mr. Todd McMurtry, setting up his fraud. I mean, this is so consistent with Mr. Wood and his all-powerful lawyering. Let me leave a voicemail saying how much I love this young man's lovely wife and his baby boy, while I'm sending an email to absolutely destroy him.
I'm going to strike that answer, probably, man.
I think that was going into inferences that the jury is going to have to make. And so I'll ask the jury to disregard that last response. You can continue, counsel.
And your wife, how did her receiving this voicemail make her feel?
Objection, Your Honor. He's asking for how someone else felt.
Yeah. Ms. Brown, how's that relevant?
Objectivity.
Did you guys discuss how receiving this voicemail made her feel?
Yeah, I watched it happen. I was right there with her when she listened to this voicemail. It had the same impact on her that it had on me.
And I believe you said this was a March 3rd voicemail. Yesterday, we ultimately got to the March 17th agreement. That was a few days later, Plaintiff's Exhibit 102. I believe we heard Ms. Wade testify that the March 17th agreement, that you guys signed it and actually physically delivered it to Defendant Wood's attorney. Is that right?
Yes, because of the timeline we had to sign it and because we had to sign it in order to get our things out of the office space, we met with Mr. Wood's counsel, signed it in his presence, and then we're given access to the office space.
And in your opinion, was there any indication that Defendant Wood had any sort of change of heart between the February 17th time and the March 17th agreement?
He had hired lawyers to create a buffer between us. And yes, I mean, I expected professionals to be being professionals in that, and we resolved it. And again, we resolved it in the same way it was before we left the law firm, the same way it was on February 17th, except that we made significant concessions to Mr. Wood, and I believed that those concessions would appease him, and that he would do what he had done, as he has said for years, and simply pay us the compensation that we had earned.
And I'll point you to take a look at Plaintiff's Exhibit 67, and if you can tell us what this is and if you're familiar with it.
I am familiar with it. I know what it is.
And what is Plaintiff's Exhibit 67?
A March 16th, 2020 email exchange between Mr. Wood and his lawyers, where Mr. Wood is attaching red lines to the agreement, meaning edits that he's made to the draft settlement agreement, and they show up in red to show the changes.
And the attachment that's on 67, did you receive a copy of this through counsel?
Yeah, I received it in this case because Mr. Wood has waived his attorney-client privilege to suggest that he followed the advice of his counsel.
Your Honor, at this point, I'd like to have Plaintiff's Exhibit 67 admitted into evidence.
7 or 67?
67.
67.
No objection, Your Honor.
67 is admitted.
And Michael, if we can just go straight to the exhibit or the attachment, please. Okay. Taylor, you have a copy of Plaintiff's Exhibit 67 in front of you, correct?
Yes.
Were there any edits on the defense side to the March 17th settlement agreement that you're aware of?
Yes, this draft shows the red lines of the deletions and additions that Mr. Wood was making to the draft settlement agreement that we would ultimately sign the next day.
And these edits that you see here in 67, were they done by Mr. Wood's attorney or Mr. Wood?
The email exchange shows that these are Mr. Wood's edits, not his lawyer's edits. He was changing the draft that his lawyers had produced.
And is there anything in these edits that you guys did not agree to ultimately?
Yeah, Mr. Woods created language that mirrors his position today. That we were
Which is
not.
what?
He says that the three of us, so it says Nicole Wade, Jonathan Grunberg, and Taylor Wilson, hereinafter WGW, have never been law partners in L. Lynn Wood PC, but have worked with L. Lynn Wood PC by agreement on a case-by-case basis while sharing office space since 2018. And of course, we did not agree to that because it's not true. And yet, it's the same position Mr. Wood's taking today.
Your Honor, I object to his attempt. The March 17th agreement, which is, I think, inevitable.
Your Honor, we're getting into a speaking testimony objection.
Well, we're getting close. Let's see how it goes.
March 17th agreement is the agreement that was signed by parties, and it speaks for itself. And any effort to try to vary those terms orally is inappropriate. It is irrelevant and should not be allowed. The agreement says what it says. Thank you.
All right. To the extent I think the objection is to relevance, that is overruled. You can continue.
Thank you, Your Honor. And what about the edits to the defendant Wood's edits to the payment portion of this agreement? How is that different than the term sheet we saw yesterday?
Mr. Wood's lawyers had drafted the agreement to require payment of the compensation from both Mr. Wood individually and his law firm, Ellen Wood PC. Mr. Wood changed it specifically so that only Ellen Wood PC, rather than he himself and the PC, would be required to make the payment. So he removed himself individually from that obligation.
And did you ever pressure defendant Wood to enter into the March 17th agreement?
Absolutely not. All we did was make concessions in the face of unbelievable threats and pressure that he applied to us.
And did you ever threaten defendant Wood in any way related to his children to get him to enter into the March 17th agreement?
No.
And did you make any statements to anyone that would have gotten back to the president or impacted whether Richard Jewell received a presidential Medal of Freedom at any time?
No. At the absolute most, I had one conversation, which we've heard with Mr. Wood directly on February 10th, 2020. I discussed the matter with Mr. Grunberg and Ms. Wade, and at Mr. Wood's insistence, I had conversations with his oldest son, Matt Wood, and at Matt's insistence, and no one else other than my wife.
But no one outside of Ellen Wood PC or the family?
That's correct. Mr. Wood's concept here is that perhaps there are some emails or text messages that some nefarious actor might hack. I absolutely did nothing to make any way he had acted or anything he had done to me public in any fashion.
And we heard Ms. Wade yesterday testify about some potential referrals that defendant Wood sent over after entering into this March 17th agreement. How many of those potential cases did you guys actually take on at the new law firm of WGW?
I think we took 2 of them. We reviewed them all. I think we took 2 of them.
And did you guys make any money on those?
One of
you took?
One of them, no. We ultimately lost money because we withdrew from the representation and weren't fully compensated. And one of them we did resolve, and it was a reasonable fee.
And that happened after some amount of work that you guys had to put into that?
Yes, yeah, we worked hard on that matter.
And in your experience, are referrals common in the legal practice?
They're very common, and the number of lawyers who practice plaintiff's defamation work is very limited. So, wouldn't be surprising to me to receive referrals given our experience in the area.
And can you take a look now at Plaintiff's Exhibit 16 and tell us what that is?
This is a January 23rd, 2019 email from Mr. Wood to Mr. McMurtry.
I didn't get the exhibit.
16.
It's January 23, 2019 to Mr. McMurtry and us introducing, this is when the Nick Salmon representation came into the law firm. It's just introducing us to Mr. McMurtry.
And is this a true and accurate copy of the email that you were copied on?
Yes.
Your Honor, at this point, I'd like to have Plaintiff's Exhibit 16 entered into evidence, published to the jury.
16.
Maybe I don't have the right copy, but it appears to be an email exchange. From Todd McMurtry to me, copied to someone named Carlo Whistles. Starts off Lynn and then it doesn't continue, so
We're
The way around.
only looking, he's only testifying and only talks about the top email.
to the extent that this document is on its face incomplete, I object to it.
All right. I think he may be referring to the chain at the bottom of Exhibit 16. So, I don't think that heading would be part of this email that you're admitting. So we can
We can
We'll
easily
redact-
redact that for
yeah, we'll
housekeeping, Your
redact
Honor.
16 with that redaction. Any other objection, Mr. Wood?
For the record, I would maintain my objection because the redaction itself would show that the document is incomplete.
All right. Noted. Overruled. It's admitted over objection.
Thank you, Your Honor. That's it, Michael. And if we can just show the top part, please. Thank you. Okay. Taylor, here in this email, this is now that we can see what it actually says. What is this email?
It's an email from January 23, 2019, when the Nicholas Salmon representation came to L. Linwood PC. Mr. Wood is introducing Mr. Grunberg and I to Todd McMurtry, the local counsel in Kentucky who had the relationship with Mr. Salmon.
And how did Defendant Wood introduce you to Todd McMurtry in this email?
He introduced Mr. Grunberg and I as his partners.
And did you guys end up having the meeting that's referenced in this email?
Yeah, we went and met with Mr. McMurtry and the Salmon family in Covington.
And did Defendant Wood introduce you guys as his partners at that meeting as well?
Yes, Mr. Wood did not associate us on a case-by-case basis. We worked on virtually every matter in the law firm. This was very common because I was his law partner. Just what it is.
And
Objection, Your Honor, that wasn't responsive and it was argumentative. I moved to strike. In other words, he's making arguments, but he's fact witness.
All right, Ms. Brown, any response?
I asked him how he introduced the two of them as partner at this meeting, and he responded as to what their relationship was and how they were introduced. I don't think it was
All right.
argumentative.
All right, overruled.
Thank you, Your Honor. Taylor, will you take a quick look at Plaintiff's Exhibit 26 and 27 and tell us what these are?
These are tweets made by Mr. Wood in January and February of 2019. Yes, they're true and correct copies.
Your Honor, at this point, I'd like to move to have Plaintiff's Exhibit.
Mr. Taylor, to speak into the microphone a little louder. I'm having trouble hearing.
All right, can you repeat that last response?
Sure. These are tweets made by Mr. Wood in January and February of 2019. And yes, they are true and correct copies.
All right, so is there an objection to admission of 26 and 27?
No objection, Your Honor.
26 and 27 are admitted.
Thank you, Your Honor. And Taylor, can you read Defendant Wood's tweet in Plaintiff's Exhibit 26?
As made clear in our joint statement, Todd McMurtry at Fit Lawyer, it's Mr. McMurtry's Twitter handle at the time, and lawyers in my firm at G. Taylor Wilson, at JD Grunberg, at Nicole J. Wade will carefully review all false accusations and threats made against Nick. We are well aware of the obscenities uttered by at Bill Maher and broadcast on HBO.
And so was this tweet in reference to one of the Sandman matters?
Yeah, this tweet was about the salmon representation, talking about the lawyers involved.
And what about Plaintiff's Exhibit 27? Defendant Wood writes, just for the record, at the end of another long day spent preparing retraction demands and drafting lawsuits, I want to thank all of Nick's supporters. Thanks also to at Fit Lawyer and my partners at G. Taylor Wilson, at JD Grunberg, and at Nicole J. Wade. They are determined and working hard to obtain justice for Nick. Is this one also in regards to one of the salmon matters?
Yes, it's just generally to the salmon representation and ongoing work on his behalf.
And can you turn over and take a quick look at Plaintiff's Exhibit 31 and tell us what this is?
This is a January 2020 Twitter thread. It's a series of posts that Mr. Wood made to Twitter at that time.
And are these true and correct copies of Defendant Wood's Twitter thread?
Yes.
Your Honor, at this point, I'd like to have Plaintiff's Exhibit 31 admitted into evidence.
Any objection to 31? Yeah.
Oh, man. No objection.
31's admitted.
Thank you, Your Honor. And Michael, I'm only going to point to the first two tweets. The first one. Thank you. On January 29th, 2020, the first in this thread on Twitter, Defendant Wood writes, 1, my law firm is small, 4 lawyers. In past, I've received requests for help from many, some answered, some not. I should have done my best to respond to all. I will do my best to make up for / correct my past mistakes by responding to my best ability to future requests received. Did I read that right? That's kind of small from here.
Yeah. Yes, you read it correctly.
Thank you. And later on in the thread, does he again tag you guys in your Twitter handles, if you will, later on the thread, calling you guys his partners?
Yes, in the 6th post of the thread, he again says, remember, I am one of 4 lawyers. And in the 7th post in the thread, he says, quote, partners are Taylor Wilson, at G. Taylor Wilson, Jonathan Grunberg, at JD Grunberg, and Nicole Wade, at Nicole J. Wade. Please be succinct and specific in describing your legal needs, end quote.
So the only 4 lawyers at Yale's firm was the 4 of you guys?
Yes, there were 4 lawyers at Ellenwood PC, and they're all in this courtroom.
And in regards to the salmon matters, what kind of work did you perform on those matters?
All of the kinds of work that go into representation in a matter of that significance. In in the first 30 days, we reviewed, thousands of broadcast articles, tweets, other social media posts, and analyzed which ones may be actionable and which ones we may want to pursue. We did significant research to identify who the proper corporate entity of any publisher may be, any individual on social media that we wanted to send a letter to, had to find them or figure out a way to contact them. I think in the first 30 days, we prepared somewhere around 60 letters demanding retraction and preservation of evidence to various media companies and social media personalities. Obviously, resources are a little bit limited, so we tried to focus on the ones that received the most attention and would do the best at counteracting the narrative for Mr. Sandman. We prepared the lawsuits themselves. We obviously had to research any particular issues about Kentucky defamation law that may be a little bit different than other jurisdictions. Most of the rules are the same, but they're not always identical. Select our jurisdiction where we were going to sue, make sure we were suing in the right place, make sure we were suing the right defendants. We prepared very detailed, very lengthy lawsuits, which in this kind of a case oftentimes act as something of a public statement for the client, to try to regain control of the narrative that Mr. Sandman was presented with. As is customary, these big media companies file very thoughtful, detailed motions to dismiss on free speech grounds, various First Amendment principles. We spent a significant amount of time dealing with their arguments, researching those arguments, briefing those arguments to the court, preparing for oral arguments, helping Mr. McMurtry prepare on these First Amendment issues. Various conferences, both with opposing counsel and the court. There was an absolute flood of ongoing media attention and ongoing requests for comment. We produced ultimately the work we performed in this case. It was thousands of files.
When you say we in regards to all this legwork you're describing, who are you referring to?
Mr. Grunberg, Ms. Wade, and myself. I think in the early parts of the representation, we were all working on it, but I think Mr. Grunberg and I sort of had the laboring oar early on, and then as the briefing on that got done, which I believe the briefing on the motion to dismiss, I think, was in May. And while that was pending, our focus kind of shifted to the Elon Musk case that we were handling. And at that time, Ms. Wade really picked up the laboring oar. And so we all did it. Mr. Wood was, as usual, in a supervisory role, kind of. He would, if he had specific things he wanted us to do, he would let us know. But we also, as lawyers, we think and analyze and do. So obviously we had some autonomy to figure out what issues needed to be addressed and how to address them and to bring them to Mr. Wood's attention.
And ultimately, how many lawsuits were filed on behalf of Mr. Salmon?
Before we left, only 3 had been filed against CNN, Washington Post, and NBC Universal. We had prepared other lawsuits, but they were not filed until after we had left the law firm.
How many other ones were filed based on the complaints you guys drafted?
I think we drafted more than were filed. I think 4 or 5 others were filed.
And approximately how many hours would you say that the three of you guys worked on the salmon matters?
Look, in the first 30 days alone, I think I personally worked more than 200 hours. It was a very difficult, I mean, and that's a serious amount of time for me. I mean, we worked hard, but 200 hours in a month is unusual. It's difficult for me to imagine that any one of us had less than 700 or 800 hours working on the matter in the year. I mean, that's a big chunk of our time. And we Ms. Wade was right. We weren't working on a whole lot of other things because we had two very significant pieces of litigation and representations between the Musk and the salmon matters. We did have a few other things that we were working on, but the vast majority of our time were spent on those two matters in the year of 2019.
And typically in a normal month as a lawyer, how many hours would you say that you work?
At that time, I was probably working on average 50 or 60 hours a week. So, you know.
So in comparison to another matter, because you said you worked 200 hours approximately in that first month on the salmon case, how would that compare to other matters?
Yeah, it wasn't that 200 hours was unusual for a month. It was that 200 hours was unusual on one matter in 1 month. And, you know, I was, that particular month, I was certainly working a lot more than 60 hours a week. But I was limiting it to the salmon representation.
And when did salmon versus CNN settle?
It's settled very early January of 2020, I believe.
And at this time that we're talking about during the salmon and musk time periods, what was your typical hourly rate for these types of matters?
I think Mr. Wood was billing me at $450 or $500 an hour on the more complex First Amendment matters.
And do you know, oh, I'm sorry.
I don't specifically recall Mr. Grunberg and Ms. Wade's rates, but they were higher than mine.
Okay. And did the salmon versus the Washington Post matter settle?
Yeah, it settled.
And the salmon versus CNN matter that we just spoke about, were the three of you guys at Ellenwood PC when that case settled?
Yes, we were.
And did you perform any work on the salmon settlements that needed to be?
Yeah, Mr. Wood directed me to prepare drafts of the settlement agreement with CNN. I didn't have anything to do with papering the Washington Post settlement. That didn't occur until after the papering that deal wasn't done while I was there.
Okay, and I'll point you to take a quick look at Plaintiff's Exhibit 21. And can you tell us what that is?
This is an email chain between Mr. McMurtry, Mr. Wood, and myself.
And is this chain a true and correct copy, absent the redactions on page 2?
Yeah, and we're just trying to keep things confidential as they need to be. Yes, it is.
Your Honor, at this point, I'd like to move to have Plaintiff's Exhibit 21 admitted into evidence.
That's right. 21.
No objection.
21's admitted.
Thank you, Your Honor. In this January 14th, 2020 email from Mr. Wood to Mr. McMurtry with the copy to you, he talks about, he states Taylor speaks for me unless or until I can speak for myself. And he goes on, or before that, he said, my request is that the plan be to bring all significant decisions to Taylor, since we agreed that the Atlanta team is the lead team among our team. What did Defendant Wood mean by this?
Mr. Wood wanted me to be the first line of defense for handling anything Sandman related, to make sure that he could prioritize his time on more important matters, I guess. And so, you know, he's just letting Mr. McMurtry know that he should deal with me on Sandman matters, and that I will apprise Lynn of the things he needs to hear and not of the things he does not.
And
I have to strike the response based on your speculation about what my state of mind was. He doesn't.
All right. The objection on Rule 701 grounds is denied, but I'll just give this instruction to the jury that members of the jury, you ultimately are the deciders of intent and witness credibility and the facts as you take them to be. All right, you can proceed.
And did you continue to help with Salmon Matters after the February 14th, 2020 time period?
Briefly, after we made our agreement on February 17th, Mr. Wood asked me to continue doing a couple of things and told Mr. McMurtry to keep including me on things. He was also at that time asking me to come back to his law firm. And when I politely declined, Mr. Wood was, you know, expressed that he was not happy with me and told Todd not to copy me on things anymore.
But you did help out in some form and fashion in finalizing the settlement agreement in one of the Salmon Matters.
Yeah, I mean, look, most of my work, almost all of my work on the Salmon Matters occurred before I left at Linwood PC on February 14th. Mr. Wood asked me to do a couple of things, and I was still trying to do those things, but then he said not to, so I didn't.
And when did you find out that the Salmon probate hearing had been postponed?
During this case sometime.
And we heard reference to some sort of line of credit being offered to you guys. By Defendant Wood, did you accept the line of credit that he offered?
We did not accept Mr. Wood's offer of a line of credit.
And why not?
I think the evidence is, it was a mechanism for Mr. Wood to control us, to owe him $500,000 in interest. He owed us a significant amount of money, and we were expecting it to be paid because he promised that he would pay it. And I was not going to be, I've seen him do it, and I was not going to put myself in a position where he had leverage over me and could control me with money ever again.
And did you believe it made sense to pay interest on a line of credit on money that you were owed pursuant to the March 17th settlement agreement?
No, and you know, I guess at that time he had said the money was going to be delayed because of COVID, and I'm not. So no, it did not make sense to pay interest for an undetermined amount of time. And as it turned out, if we'd accepted that line of credit, Mr. Wood would have taken the position we owed him $500,000 on a line of credit, $285,000 on his lease, $785,000 plus interest, and no way to repay it. I was not going to put myself in that position.
And ultimately, we heard yesterday that that there was a decision or an agreement with the council for the news outlet to postpone the settlement and Salmon coming in until Mr. Salmon turned 18. Is that correct?
My understanding is that ultimately CNN and the Salmons agreed to delay it until Nicholas turned 18. That's my understanding.
And when the money came in, once Nick turned 18, were you paid under the March 17th settlement agreement?
No.
And did you ever think about including Mr. Salmon in your March 17th settlement agreement?
No, sorry. No. We did everything we could to leave the clients out of what was going on between us. And it was a matter of internal firm compensation. The Salmons have nothing to do with it. We performed this work for L. Linwood PC and for Mr. Wood, and we're entitled to be compensated for our work on behalf of the firm. And this agreement is what that represents. And involving the clients would have been no good for anybody. They didn't need to be involved in it. It would have been unfair to involve them. And Mr. Wood had specifically, very specifically instructed us that we were not allowed to contact them in any fashion.
Is there any requirement?
Your Honor, I move to strike your answer again. You didn't cross the line into argument as opposed to providing facts.
All right. I don't think it's gotten there yet. All right. Overruled.
Thank you, Your Honor. Is there any requirement that you guys strike that? Was there a requirement to include the Nick Salmon or his parents in your March 17th settlement agreement?
No.
And did Mr. McMurtry know about the work that the three of you guys performed on the salmon matter?
Yeah, I mean, Mr. McMurtry was there for it. He was on all the emails. He was on all the drafts of all of the documents we prepared. He was with us physically on various occasions. He was on the conferences. Certainly, Mr. McMurtry knew the work that the three of us had performed on the matter.
And how often would you say you were in contact with Mr. McMurtry or somebody at his firm during the time when you guys were doing all that legwork you testified about?
Very, very regularly.
Can you take a look at Plaintiff's Exhibit 68 and 68A and tell us what it is?
Yeah, this is a recording of a later conversation between Mr. McMurtry, Ms. Wade, Mr. Grunberg, and myself in July of 2021.
So after you guys filed this lawsuit?
After we had filed this lawsuit, I mean, that's correct. We had not yet sued Mr. McMurtry, but it was after we had sued Mr. Wood.
And is 68 and 68A true and correct copies?
Yes, they are.
68,
Yeah, and 68A.
I'm a little confused. This call on July the 7th of 2021.
That is what the witness testified to.
All right. You can continue.
No objection.
Okay, thank you, Your Honor.
It's admitted without objection then. 68, 68A.
Hey, Todd, Nicole, Jonathan, are you here?
Yep.
Awesome. Todd, thanks so much. Again, I think we just need maybe 3, maybe 5 minutes. We've been thinking about this, the idea of an affidavit, and in doing that, we're looking hard at what's actually required by Rule 1.5. I mean, obviously, we've talked about it ad nauseum. You know our position that 1.5 has nothing to do with it because we're lawyers of L. Linwood PC. But for the purposes of this discussion, some background so that I can get to my point. We'll assume 1.5 applies here. Talk about it. And the rule doesn't require quantum merit. It requires that between Lynn and us, the fee is proportional to the services that we all render. Okay. And right. So if what you're asking us to do is meet rule, if you want us to meet Rule 1.5 so we can possibly get some kind of fee approved by the client, you want to be sure it's not fruitless and that we're actually meeting the rule.
Yeah, Nick is not going to approve the fee. I mean, I'm not looking to do that. He simply said that, that's what That's what I wrote in an email way back when, and that's the question he asked when the bill was presented. So if you give me anything, I'm just going to throw it back at you and say, okay, if this is quantum merit, that's to be determined, but we have no objection to receiving a fee. But we can't make a decision as to whether or not it's quantum merit or not. I don't want to make that decision under any circumstance.
Yeah. Okay. All right. So, and I think this is why we're having the call. And so putting quantum merit aside for a second, I mean, so we know from you that this Lynn's whole position that Nick or his parents or whoever required our timesheets or contemporaneous time records is just not true. It didn't happen. Nick didn't require it. But we know that Lynn similarly did not keep any timesheets.
Right.
And so our concern is, and maybe it's valid hearing what you said, is that if we're going to give some kind of explanation of our services, is there anything like that from Lynn or that you can get from Lynn that's going to allow you or the client to assess the proportionality of our fee?
No, I haven't thought about that. I'm not inclined to get into it with Lynn because it's just going to get me sued or, worse. So, my thought is that it might be helpful to you for Nick simply to say, if this is the value of your time, I'm not going to be the judge of that, but if this is the value of your time, then by all means, I accept that.
Okay. So and this, I guess,
And I don't know the rule. I looked at the rule. I'm not a Georgia lawyer, so I'm not going to get into practicing law in Georgia. If you've got a different rule, then it seems like it doesn't matter what Nick says, and he probably doesn't need to be involved in it because Nick is not going to say, okay, I approve that fee. That was never the idea. The idea was only that, now I get a call. The idea was only that, it was a tumultuous period. There was all kinds of bad stuff happening. That time I said we need it, we're going to pay, but it has to be, fair value. And that was the extent of it. But it appears the Georgia rule doesn't even apply. So maybe that's the best approach, is that it doesn't apply.
Well, yeah, and I think the rules are virtually identical, and that's the issue. It would be clear that there's no quantum merit analysis if Nick either doesn't object or consent to our fee, and that it's proportional to Lynn's, right? There's no quantum merit analysis. So where did the quantum merit analysis come from?
It came from me when I wrote the email 2 years ago.
But so we were taking our fee by agreement with Lynn, and so there's no quantum merit analysis. I mean, Lynn, we all were.
Yeah, I get your point. But I guess I really don't have anything to say or anything to do. There's no benefit I can provide.
Okay, so the affidavit is not with some goal of you or the client assessing it and saying, yeah, this looks reasonable to us, take your fee.
That's right. Because, again, what started out as a simple request to say that, in Lynn's state of mind at the time, that things weren't going to blow up, that everybody was going to be paid fairly, that I said, everybody needs to get paid on quantum, or you guys need to get paid on quantum merit, and that Lynn was the time appeared to be the factor, that persuaded these people to pay all this money. And so, I was just trying to protect the situation and say, let's make it quantum merit. For you guys, you would be paid fairly.
Yeah, well, look, and it makes sense to me that if the client didn't want our time sheets, that he wouldn't require Lynn. And so that, it's maybe not as reasonable if Lynn had been, if his letter was accurate, that the client did want our time sheets. But so look, I'm glad we called because from our reading, the only reason for us to submit an affidavit to you all, even though we don't think Rule 1.5 has anything to do with it, is to make sure that our agreed fee with Lynn is proportional to the services that he and we provided. And if that's not the goal, I think we'll just have to, then we're just going to be reassessing this whole idea of giving an explanation of our services. I mean, I'm beating a dead horse. Y'all know what we did. I mean, you were there for it. You know that we produce virtually all the work product coming out of Ellenwood PC. This whole notion that we're only going to get paid quantum merit. You say it came from you. Well, okay. We're each getting a third, agreed with Lynn, a third of what Lynn was receiving, and a third of what you received, subject to any whatever Lynn, paid to your firm for whatever on top. But that's fine. So we'll just reassess this whole thing about an affidavit, and we'll, if we want to, if we need to get back to you, we will. Otherwise, just status quo.
Yeah,
Jonathan, am I missing a point here
No, I think that's
about
it.
whether or not we should do this affidavit?
No, I think that's generally it.
Okay. So now, it's Todd. Last question. I'll let you go. Can you just send to us this email you're talking about and the settlement statement that was presented to the clients about our fee?
Yeah, if you email me to remind me, I'll look into it. I thought you had it. I don't know. I mean, I don't recall, but I certainly provided it to your attorney.
No, we were not involved and never saw anything presented to the client about us receiving our agreed fee with Lynn.
So I'll try to get an email about the quantum merit.
Okay, so I think that's all. I'll try to remember to send you a reminder email, just so that we just want to know for the first time what was provided to the client. And now we understand. You think quantum merit's required, I guess, because you think we weren't lawyers of Ellenwood PC. And
No, I don't think any of that. I thought that it was an insane situation that I was getting. The thing, nobody was talking to me. I didn't know what was happening. I could document in detail all of the stupidity and insanity and craziness that occurred. And, I simply said, not knowing, wanting people to be paid fairly, recognizing that Lynn is the name of the practice and you guys were the workers of the practice, Lynn procured those settlements and you all, we had a separate deal with them. I didn't know, but at the time I just said, that you'll be paid quantum merit, and that's just to try to clear up the bad situation. So anyway, that's all I have. I'll do what I can to help. I'm sorry that everybody's in this now. All right, Todd. Thanks. Bye.
Thanks, Todd.
Thank you.
Okay, Mr. Wilson, we heard Mr. McMurtry say in this recording we just listened to that Mr. Salmon, that it was never the idea that Mr. Salmon approved the fee. What did that mean to you when you heard that?
I wasn't surprised to hear it. So I had for multiple months discussed with Mr. McMurtry. I had a lot of respect for Mr. McMurtry, and I discussed with him for multiple months this concept of providing an explanation of our services if that's actually what Mr. Salmon wanted us to do. And when he told me that Mr. Salmon he was just going to throw it back at me, that Mr. Salmon was never going to approve a fee, he didn't want it. It was clear to me what had gone on, and that it was just, it meant to me that this was a setup. And the thing is at this time, my posture with Mr. McMurtry had just changed because for the first time we had found the smoking gun emails. And so for the first time I recorded him because previous to that, I didn't know what he'd done to us.
And at some point prior to July of 2021, when this conversation took place, had you been informed that Mr. Salmon and or his parents requested time records from you guys?
Yes, on July 24th, 2020, Mr. Wood's lawyers said that Mr. Sandman, we needed to present contemporaneous time records of our work to the Sandmans for them to consider approving a fee to us of some kind. And this is just Mr. McMurtry saying, I was never going to do that, including because I'm not inclined to get into it with Lynn.
And was it true when Defendant Wood's counsel made that representation regarding the Salmons requesting time records?
All right, members of the jury, does anyone need a break? I know we've been going about 2 hours here. We could take a quick 5. I'm seeing some nodding of the heads. We can make it a tight 5. Okay? All right.
Thank you.
All right, the jurors.
Nope, I don't. I gotta get it in through, we'll do it through Jonathan. I know, but I still haven't getting it through Jonathan.
Okay,
I know, so,
okay. Just so long as you got it.
hey,
Let me do the timing issue.
Cool.
We got 4 copies.
All-
They're
all I-
all small.
all I have to get in, just so you know.
Yeah.
Okay.
All right, so 2.5 hours has passed. Are you requesting more time, Ms. Brown?
Yes, Your Honor.
How much time are you asking for?
I don't have too much more left to do. I, I'm thinking I can keep it under 45 minutes.
No, that's more than the 3 you promised me, so I think we can do better than that.
Your Honor, briefly, yesterday, those long speaking objections took a full half hour.
I was pausing a lot during a lot of them.
Oh, not all of them.
Not all of them.
Started at 3:30 and we left at 4:45 and we lost an hour and a half. And I think a good part of that was, and this is 5 years of history and in many ways, our key witness that we're moving extremely fast and we're covering a lot of ground. We don't have too much more.
How many more exhibits do you think we have?
We have some disparaging posts and we have approximately 4 more exhibits. We have no more recordings. But because of everything that happened yesterday, we went on so long on some real routine or background information. This is kind of the meat and potatoes of our case. And so we would just respectfully request the opportunity. I mean, we're not going to be very long. And on this break, we're going to make sure that everything flies along.
Okay. I think so is there an updated request?
We can move a couple things to Mr. Grunberg's testimony, and so I think I can keep it under
How about 30?
30.
All right, I'm gonna make it just to haggle. I'm gonna make it a tight 25. I'll add the time to the cross. Let's be back in no more than 5 minutes so that we can be ready when the jury's ready to go.
Thank you, Your Honor.
I'm sorry, Your Honor. I'm confused by the clock.
The red is theirs. They ran out. I'm gonna add 25 more to it, and I'll add 25 to the
They've run out of their time.
yeah
Now you're gonna add
25 to both
25 to the cross.
Thank
Thank you.
That's right.
We're due back at 11:04.
Thereabouts. Yeah.
I hear you. But we want to do it at the very end. Okay. It's where we bump the ball right up. Oh, always has. She was better. Shoes.
Can you tell me what that last question was that I
Yeah.
just asked?
Is it true when defendant was counsel made that representation regarding the Sandman's requesting time?
Okay, thank you. I will rephrase that because that was confusing. Yes, hang on, because I think the microphone can hear us. Hold on. Let me write this down.
That makes sense.
Yes, thank you.
Well, come to what?
You need anything, Mr. Kavanaugh? I could take a wild guess what you want. What's that?
A coffee?
Yeah, all right. That's right. That's your page. I think it's technically pronounced Sa, but
Oh,
she's fine with Sue.
I think she votes. He gave up my.
Are you missing Columbus yet? You were staying in a hotel here for this, or go back every night? Good Lord. Good Lord. Where are you parking? Yeah. Yeah. But 2.5 hour drive? I don't know if that's worth it. You don't even get time to lay down. Yeah.
I don't mind. It's good from.
If you say so.
Well, yeah, we hopefully we done.
Yeah.
I'm gonna leave it.
No, so you don't keep these?
Well, I would, but it goes to the trees group.
Yeah.
So whoever has it.
Oh, that's the one stuck holding the bag?
That's how I work.
Okay.
Michael, that list I sent you this morning of the disparaging posts, that's gonna be.
Yes.
All right, as soon as I get sight of them. All right, let's bring in the jury.
Excuse me.
He will. I already blocked him.
I got it. My pen's somewhere under here. Thank you, though.
Last of the jury.
He's a member gonna say, no more.
Okay. I will show her.
I'm afraid so, but if you.
Sorry.
Here's the hours, you can go review that.
You're the president, Judge.
Hey, Deputy Scott, please be seated, everyone. Plaintiff may resume.
Thank you, Your Honor. Mr. Wilson, right before the break, we heard the recording of the conversation with you, Mr. McMurtry. Was Defendant Wood's counsel, that representation that they made about this Salmon's requesting time records, was that true?
Not according to Mr. McMurtry or his testimony in this case.
And would the money that you guys are owed under the March 17th settlement agreement, would that have required Mr. Salmon or his parents to pay any more attorney's fees?
No, our agreement with Mr. Wood did not impact the total amount of fees that the Salmons would need to pay to their lawyers in any fashion, just like every other agreement, every other case we've ever had with Mr. Wood. Our compensation would have come solely from the fees he was already paying to Ellen Wood PC.
And how did you feel when you discovered this plan to prevent the three of you guys from being paid?
To me, it was akin to like a PTSD thing. It just meant when I knew that Mr. Wood had done this to us, it meant that I was reliving right then everything that he had done to me in January and February of 2020. And I'm still feeling it today, obviously. And it also meant that I had to make another very difficult choice, and that Mr. Wood was going to require us to have this fight that he said we could not win. And I was going to have to do what we tried so hard to do was make none of this public. And we tried so hard, and instead his fraud meant that I had to relive everything he was doing to me, and I had to do it publicly.
And how do you feel about Mr. Salmon and Mr. McMurtry after discovering all of this?
Nicholas Salmon is a wonderful kid. He's a young man now, and I've nothing but respect for Mr. Salmon. I respect Mr. McMurtry as a person and a lawyer. He's a fine lawyer, and you know the thing about it is that like us, I mean, we were just sort of caught up in Hurricane Wood, and so I understand what my impression.
On names, and I would ask the court to strike and tell the jury not to consider, because the union description of me is Hurricane Wood. He just said it.
All right, I understand your point. Mr. Wood, I think he's making more of a. All right, I'll ask Mr. Wilson to take that in mind. I think we'll proceed though. So
Understood, Your Honor. Thank
all
you.
right.
And so my impression is that like Mr. Wood had done to us, and I had to make a very difficult decision about my career and what it was going to mean to me to leave Ellenwood PC, that Mr. Wood put Mr. McMurtry in a position where he had to choose between what he thought was in the best interest of his client. And we heard him say it. He fairly felt that Mr. Wood was the driving force behind getting his client these settlements. And Mr. Wood put him in a spot where he had to choose between what Mr. Wood said or hurting his client. And that it's just an unfair, terrible position for Mr. McMurtry to be in.
Thank you, Mr. Wilson. And now I'm going to direct you over to Plaintiff's Exhibit 235. Can you take a look at that and tell us what that is?
This is a collection of posts that Mr. Wood made on Telegram.
And are these true and correct copies?
Yes.
And did you take these screenshots?
Yeah. Yes.
And were they taken at or around the time that he posted them on Telegram?
Yes.
Your Honor, at this point, I'd like to have plaintiffs 235 admitted into evidence.
I think you need to establish that time. I don't see a date on these.
Mr. Wilson, do you remember what time this post was from?
I believe these were March of 2021. It's been a couple of years. I believe it was March of 2021.
All right, so you're tendering, I believe it was
35.
235.
Yes,
Any
Your
objection
Honor.
to 235?
No objection, Your Honor.
235 is a minute.
Thank you, Your Honor. Defendant Wood says in this first one, actually, I apologize. Going over to the second page of this exhibit. Actually, the last one. Page 3. Defendant Wood writes, I do try my best to read your replies. Wish I had more time as your comments are inspiring and you provide me with valuable information. Thanks so much. Fight on, Lynn. And there's some emojis. And then right below it, another post from the same time period. He writes, I love reading your replies. I try to read as many as I can, limited only by time constraints. I hear you. And it goes on. Is it your understanding based on your review of Defendant Wood's telegram and his responses with his followers, that he monitors this reply channel we've heard testimony about.
Your Honor.
Yeah, sustained.
Are you aware of Defendant Wood making comments that he monitors his reply channel on Telegram?
Object again.
Yeah, if there's anything in addition to what you've already tendered, I don't otherwise see the purpose of the question.
Okay.
So sustained.
Taylor, can you take a look at 237 and 241 and tell us what those are? No, I'm not getting it.
I believe it was 237 and 231.
Yeah, these are copies of posts that Mr. Wood made to Parler, and in 237 and in 241, they're posts and that Mr. Wood made on Parler and that received responses to his posts.
And are any of the ones in 241 also tweets?
Yeah, towards the back of 241, there are tweets.
And are all of these screenshots true and correct copies?
Yes, they are.
Your Honor, at this time, I'd like to move to have plaintiffs exhibit 237 and 241 admitted into evidence.
All right, 237 and 241.
Again, Your Honor, I won't belabor it. I'll have the same objections I made. That there is no identification of who Pistol 2 is. There's no identification of who Walter Mudgeon is. There's no evidence that links me to having read these people's posts. And I believe they are irrelevant. And
Your Honor, we're getting into a
And they're
speaking
properly-
adjustment testimony.
Well,
not
just a legal basis here.
right.
Yeah, we can continue.
On what I said, I also say on grounds of hearsay and lack of identification, so lack of authentication.
All right. I think all those grounds and all the arguments from yesterday are incorporated, and I'll deny them for the same reasons I articulated. So they're admitted over objection, 237 and 241.
Thank you, Your Honor. In plaintiff's 237, in September of 2020, Defendant Wood posted on Twitter, it states, as my loyal followers can tell and others know, I am deeply hurt by frivolous smear and agenda-driven lawsuit against me by 3 young lawyers I treated fairly and generously. I shall aggressively defend myself in court of law and court of public opinion. My defense shall be based on truth. Are you, what did you perceive by this, that Defendant Wood was talking about? Actually, strike that. Are you aware of any other lawsuits at this time that were filed by any other lawyers against Defendant Wood?
No, I'm not aware of any other lawsuits filed by lawyers other than ours.
And what did you believe this tweet to be in reference to?
This litigation, and some allegation that we're filing it for some reason other than to vindicate our rights. And that we're, I don't know, politically motivated or something. And
having this characterization about frivolous smear and agenda-driven lawsuit, what about that do you consider disparaging?
We're lawyers. We tee up good lawsuits. We act ethically. We don't file frivolous or smear campaigns as lawsuits.
And this individual with the username Pistol 2 spelled out and the number 2, he replies, dox them so people know who to boycott. Are you familiar with the phrase dox?
Yeah, dox is to reveal someone's identity or personal contact information. And, you know, we, like the others yesterday, we brought these to Mr. Wood's attention in this matter, that this was happening to us.
And was your personal,
Not sure. There's a reference that he brought this to my attention, and I don't know where, there's no evidence of that.
I think that's something that have to be taken up on cross then.
Thank you very
All
much.
right, you can proceed.
and was your information released? Were you doxxed at this time?
Mr. Wood certainly identified us many, many times. He posted pictures of us, you know, our website, talked about our children. So I'd say, yeah, I'd say so.
And if we go over to page 2, exhibit 241, on page 2, I believe this is a parlor message that we saw yesterday in Miss Wade's testimony about asking who was behind the frivolous lawsuit against him and whether or not you guys support leftists or activists. This individual responded on on Parlor, "Dirty lick spittle bastards, they deserve the chair." How did it make you feel when you saw responses such as this one?
Excuse me, Honor, I checked with the family question. I haven't made any, there's no reference in here to in these agendas where I said anything about leftist activists. She said in her question that I did, so it's improper as it's to form. It's not based on any evidence. She's describing my post absolutely out of thin air, of speculation.
Your Honor, the
There's no-
post
there's
is
no-
on
there's
the
no
screen
post
if you'd
that
like
says
to
what
read
she
it.
said. So I object to it.
Okay, I'm looking at 241 and the language you're referring to, and I'll overrule the objection.
I'm sorry, what language?
The language you're referring to, I believe that's in 241.
I do see it there. And then in that context, I missed it. That.
Okay, all right, we'll move on.
So I withdraw the objection.
Taylor, you can answer. Essentially,
Yeah.
how did this one make you feel?
Yeah, look, we were terrified. I mean, Mr. Wood had been trying to intimidate us. He was still trying to intimidate us. That's how it made me feel, and that it made me feel like that Mr. Wood was gleeful in the pain that he was causing me.
Objection. You're speculating.
All right, I think the witness has testified he's had interactions with you, and that's his opinion, and it's for the jury to decide whether to accept it or not.
But he just described me as being gleeful. It's not.
That's his opinion based on his observations and interactions with you.
Well, I mean, it's just,
Yeah.
I mean, it's just pure argumentative speculation, prejudicial to say I was gleeful with no evidence that I'm not gleeful about any of this.
All right, Mr. Wood, I think we've gone far enough.
Thank
I think that he has a basis to have that opinion. To the extent it's accurate or not, the jury gets to accept that. You can take it up on cross. Moving forward.
And when you saw some of these replies and these types of feelings that you're describing, were they the same types of feelings you experienced when you uncovered this plan that we were talking about earlier?
Yeah, it just hurts that Mr. Wood did this to us, kept doing it to us. They asked him to dox us. He identified us. He did that. And
There's no evidence that I ever asked anybody to dox anybody. That's not in the evidence, and I move to strike it.
All right. The jury will consider the evidence as presented. Overruled. You can continue.
yeah, and it made me scared for me and my family and for my law family, Mr. Grunberg and Miss Wade, and their families.
Mr. Wilson, I'm going to direct you now to take a look at a couple of exhibits, 195, and then 242 through 246. And Mr. Wilson, do you recall when 195 was posted?
I believe it was May of 2021.
Um,
May.
195. Your Honor, may I refresh your recollection?
Yes. I was mistaken. It was March 19th of 2021.
And what is plaintiff's 195?
It's a true and correct copy of a telegram post made by Mr. Wood.
And what about 242 through 246? What are those?
Um, 242 to 246 are true and correct copies of screenshots that I took of the replies to Mr. Wood's posts in the prior exhibit.
Your Honor, at this point, I'd like to move to have plaintiffs 195 and 242 through 246 admitted into evidence.
Numbers again, 195, what?
And then 242 to 246.
Two 242 through 246?
Yes.
All right. Renew my objection, Your Honor. Again, these are unidentified parties, not authenticated. We don't know if they're bots, real people, or shills paid to do it.
We don't need a testifying speaking objection, Your Honor.
I understand the basis for your objection.
Object on that ground.
And so that was 20,
That was 195.
right?
And then 242, 243, 244, 245, and 246.
All right, so 242 through 243 and 242 through 246.
Yes, Your
The
Honor.
objection is preserved, but they're admitted over that objection. 195, though, I don't think that would be as applicable because that's a post by Mr. Wood, but regardless, any related objections are preserved and it's admitted over that objection.
Thank you, Your Honor. And Taylor, we'll go to, that's okay. We'll go, I'll read portions of 195 into the record. And you said this was what date of a post from Defendant Wood?
March 19th of 2021.
Okay. So a year and a couple days after you guys signed the settlement agreement?
Yes.
Defendant Wood writes, I have also heard that the lawyers with whom I formerly share
He's
office.
standing to object.
May have misspoke. He said this was 2021. The agreement was in March of 2020. So I'm not sure if he just, maybe he misspoke.
He said that this post was from March of 2021, and that was a year after the settlement agreement was
Okay,
entered
I'm
into.
sorry.
All right, you can continue.
Told you I couldn't hear well.
Defendant Wood writes or posts on Telegram, I have also heard that the lawyers with whom I formerly shared office space may be planning to do the same thing with my children in a fee dispute case. The former colleagues are Nicole J. Wade, Jonathan D. Grunberg, and G. Taylor Wilson of the Atlanta law firm of Wade, Grunberg, and Wilson LLC, open paren, WGW, close paren. What do you think of these people? Question mark. I know what I think, ... And if we turn over to 242, can you read to us some of the responses that you saw to this post that I just read?
Warm Blood says, I think they are morally and ethically depraved. In 243, I just can't believe how despicable these people are. This is the work of the Satanists. They do the same to President Trump as well as anyone who supports them. It is complete narcissism and anti-American behavior. far as these esquires hold nothing back, Lynn. They join an honorable profession but have no honor. Total scum using your children that way. They will pay one way or the other. Your children should be off limits, period. I think all these frauds are despicable. Unconscionable behavior, a good partner and friend wouldn't do such. I think your former colleagues may need an email from some of us patriots as well, who's with me. People of Atlanta need to let these folks know what you think of them with peaceful and patriotic ways. I think low life is too nice of a word. These people are evil. Nothing lower than pitting family against family. What they're doing is atrocious. They're evil. Anyone who stoops to that low to use your own children to try to bring you down is true evil.
And when you saw these responses on Defendant Wood's reply channel from his followers, how did these make you feel?
Obviously they're disparaging, and it hurts because this is attacking the core of who I am and what I did. I was there to try to help Mr. Wood with his kids per his request. And it's Mr. Wood that has made them part of this public dispute and this case. It's just a contradiction in terms.
And can you take a quick look at 208 and tell us what that one is? And I believe these don't have the dates either, so if you need your recollection refreshed, I can do that. Yeah, well, no. Okay, well then you want me to move on to that? Then I can do that. Actually, Taylor, can we jump over to Plaintiff's Exhibit 271?
271?
What is this?
It's a copy of a bar grievance that Mr. Wood filed against me.
Is it true and accurate copy of the bar complaint that Defendant Wood filed against you?
Yes.
Your Honor, at this point, I'd like to have 271 admitted into evidence.
Any objection to 271?
No, Your Honor.
271's admitted.
Taylor, this specific bar grievance, it was filed by Defendant Wood. Were there other bar complaints filed against you?
Yes, there were.
And did you know any of the individuals who posted these bar complaints against you?
No, I didn't know any of them.
And how do you, were there any Telegram posts by Defendant Wood about making bar complaints around this time that you received the other ones?
Yeah, yes.
And
solicited, suggested that people could file them against me.
And were there other posts that we haven't gone through today for time that were posted about you guys on Telegram by Defendant Wood and his responses from his followers that talked about you guys?
Many, many posts.
Your Honor, that's all that I have for this witness at this moment. It's going to take me a second to get these
Understood.
binders.
All right, Mr. Exum, are you still planning to conduct cross-examination?
Yeah.
Change the plan again.
All right. All right, Mr. Wood, we're going to go, I think, at least 30 minutes, but you just let me know when you find a good stopping point after that point.
For lunch.
What's that? That's right.
For lunch. Give me 1 second. Can I proceed, Your Honor?
You may.
Still morning. Good morning, Mr. Wilson.
Mr. Wood?
do you remember exchanging text messages with my son, Matt Wood, back in February of 2020 concerning the idea of having Dr. Phil McGraw perform some type of an intervention on me?
Yes, your son, Matt Wood, asked me if I would participate in an intervention, and he suggested that he would use Dr. Phil McGraw, and I specifically advised him not to do that, and sort of pleaded with him and told him that you would rightfully feel that that was a personal attack on you, and told him I didn't think he should do it with Dr. Phil.
So it looks like Matt wrote you and said,
Objection, Your Honor. He's about to read something that's not admitted into evidence, I believe.
I'm sorry.
If you want to phrase the question as more as an impeachment, perhaps. I'm assuming the objection is to hearsay here.
Do you recall Matt Wood writing you by text saying, we are thinking that Phil can
Objection, Your Honor. Hearsay.
If it's for impeachment, I would overrule that.
recall Matt Wood, my son, writing you and saying, we are thinking that Phil can point us quickly to the right person. Lynn wouldn't have to know Phil was involved, or at least until after it's all over. It's a rough call, but I want to do this right if we're going to do it. And you responded, I hear that and understand it. I've said my piece on it and won't push it, but you should know that from what I know of Phil, he will take it upon himself to intervene. And then Matt Wood writes back, I appreciate it, you're right. I think we have too much to lose without Phil. And then he says, it's time. Then he writes and says, no intervention this weekend. Do you remember those texts?
Yeah, I remember them. And when I've said my piece on it and that I won't push it, I was referring to the text messages that you're not reading to the jury, in which I specifically told your son that I thought it was a bad idea. And when I say I wouldn't push it, that's because he was talking about your children doing an intervention on you, and it wasn't my place to push it.
Why were you even discussing it with them?
Because I cared so much about you.
You cared so much about me that you were behind my back writing my son, talking about an intervention by Dr. Phil McGraw, that Matt said that you needed Phil because without him you had too much to lose. That's what you were doing behind my back, wasn't it?
I think that's what your son said. And
I'm looking at your words now. Let's read your words.
no,
Let me go back.
Objection, Your Honor. Best evidence rule. If we're going to read this, can we have it?
If it's for impeachment, I don't think that would be applicable.
So February the 6th, 9:52 p.m. Matt writes you, could you do an intervention on Sunday? Considering. You wrote him back. Yes. Did y'all all talk tonight? No, I didn't call him. I will soon though. Okay, you wrote, keep me posted. And then you wrote JG, Jonathan Grunberg, right?
JG refers to Mr. Grunberg.
JG mentioned DPM, Dr. Phil McGraw. I truly believe if you all are going to do this, it needs to be an independent third party. While it would not be, in fact, I think a reasonable person in Lynn's position would view DPM as a personal attack. Matt writes back, we're thinking that Phil can point us quickly to the right person. Lynn wouldn't have to know Phil. Why in the world were you writing my son in February the 6th and giving him input on the idea of Dr. Phil McGraw doing an intervention on me? Why in the world would you be doing that behind my back?
I wasn't doing it behind your back. Your son was concerned about you, expressed those concerns. He knew how much I cared about you and loved you. He knew because you were making me discuss him with you, how much I cared about you. He knew that how much I felt that you loved him and how much support that I felt you needed from them. And when he asked me to be there for you at an intervention, and of course I would have done that for you, Mr. Wood. And this thing about conspiring about Dr. Phil, I mean, I specifically told him in your defense, he's going to rightfully think that's an attack. Don't use Phil.
But Matt had written you and said, I think we have too much to lose without Phil. Right?
Yes, I understood we to be a reference to your family and not me.
We. And then you earlier had said, I hear that and understand it. I've said my piece on it and won't push it. But you should know from what I know about Phil, he will take it upon himself to intervene. When did you ever meet Phil McGraw?
We've represented Phil McGraw
I didn't ask you that.
and yeah,
Objection, Your Honor.
When
Let-
did you
he's
first meet
objecting-
Phil McGraw?
He's preventing the witness from speaking. He wasn't done.
Okay, yeah, if you let him finish his answer and then you can intervene.
When did you first meet Phil McGraw?
I don't remember.
Personally?
I didn't say I knew, I didn't say I met Phil in that text message. I said from what I know of him, we represented him. I had various dealings with Dr. Phil with you and apart from you as part of our representation. And me saying that to Matt Wood was telling him, you shouldn't even contact him because if you do, even if it's to lead to the right person, Dr. Phil is going to get involved and your dad's going to feel attacked. That's me conveying to your son, don't involve Dr. Phil, please.
And by virtue of me feeling attacked with Dr. Phil tried that stunt, you would assume that I would feel attacked if you and Jonathan Grunberg were talking to my son about it, that I would view that as you also attacking me, just like you claimed I would see it as an attack by Dr. Phil, right?
I was
Calls for speculation.
overruled.
US.
If the answer, witness has an answer, he can. Overruled.
Mr. Wood, I was standing up for you in this text. Your son was asking me to participate in an intervention for you, and I wanted to be there for you and your family, and I did not want it to be with anyone in your orbit, including Dr. Phil, because that was not going to be helpful for anyone. And I thought, to the extent that I was allowed to give input into your family's decision-making on the issue, I wanted him to say my piece on it, which was, if you're going to do it, just use an independent person and not Dr. Phil. And as it turns out, you're the one that involved Dr. Phil. I mean,
I moved to strike that last statement. There's no evidence of that.
It's his
About me
witness
and-
Well,
testimony.
it is not responsive to the
Yeah.
to the question asked. So I'll ask the jury to disregard that.
Jonathan Grunberg, you told Matt, had mentioned Dr. Phil as a possibility, right?
you're reading from text messages, but you read JG.
BPM.
Yeah, so that's what I'm conveying to Matt.
Jonathan Grunberg had told you that he thought Dr. Phil McGraw was somebody to be considered for doing it.
Jonathan conveyed to me that your son, Matt, was thinking about using Dr. Phil, and I took it upon myself to try to protect you from what I thought was a very bad decision that your son was making to use Dr. Phil.
Did you think it was a very bad decision for my son to be discussing with other people the idea that I even needed a mental health evaluation?
Not if it was with an independent mental health
I
provider.
asked you that I even needed any type of mental health evaluation.
I would really like to believe that the way you treated us, I wanted to believe that the way you were treating us was because there was something going on with you that perhaps you could get help with, and that it was not the cold, calculating terribleness that you were committing against us. I wanted to believe that.
How old are you?
Objection, Your Honor, relevance.
Overruled.
How old are you, Mr. Wilson?
I'm 35 years old.
Are you always so emotional
Objection,
about
Your
a business
Honor.
matter?
We're rating the witness.
Not getting close. Overruled.
This is so much more than a business matter to me, Mr. Wood. You stood up in your opening and said I was like a son to you. It makes the whole thing so much worse. You did so many amazing things for me, and you're right. You were powerful. You were the most famous defamation lawyer in the world, and you were uniquely positioned to destroy my life. And the body of your life's work does not give you the right to destroy my life.
I agree with you. But here's where I disagree with you.
This sounds
Your
like
Honor.
you're going to put this in the phrase of testimony or question, rather.
Your life didn't get destroyed because you've been more financially successful in your firm of Wood, Grunberg, and Wilson than,
Objection, Your Honor.
Overruled. Continue.
yeah. Your career has not been damaged at all because you admit that your new firm, Wade, Grunberg, and Wilson, has been very successful financially. True?
That's
Objection, Your Honor. It violates the order on motion limiting.
Yeah, Mr. Wood, if we're talking about post their association with you, I'm not seeing the relevance of that.
Well, they've, if I might,
Without proffering, you can tell me why that would potentially be relevant, but
they continue to say that I was going to destroy them and that my actions they put in here were to destroy them. And I'm not asking them about their, I know I can't ask them the details of their finances. They've asked me.
Objection, Your Honor. We're getting into testimony. Can we take this up outside of the jury?
no, I don't. I mean,
The sim-
again, yeah, go ahead, Mr. Wood.
They have admitted here, or at least otherwise, that they have been financially
Yeah.
successful. That's the only question. Yes or no?
Yeah, no, at this point, I mean, this could open up a whole wide range of issues and areas that I don't think play into anything relevant in this case. So I'll ask you to move on.
Do you have any objective evidence to support a claim that I have destroyed your life or your family's life?
I have significant objective evidence that you've tried to do that.
Excuse me.
Objection, Your Honor. He's not letting the witness finish again.
Well,
Not answering the question.
I mean, he's trying to confine with the question. Overruled. You can ask the question.
Let me state it again. I didn't ask about trying to. Do you have any objective evidence to offer this court that you can point to that says Lynn Wood destroyed my business and my family? Not your claim that I tried to, but that I actually accomplished it. Do you have any objective evidence to present to this jury?
It has been referenced in other representations. My ethics and professionalism as a lawyer has been called into question. And I walk into every professional setting now, and I look all the other lawyers in the face, and whether they say it or not, I am paranoid and I am wondering, what do these people think about me because of what Lynn Wood has done and said to me? And it certainly feels that way. It certainly feels that you've had a significant impact on my career. I was 30 years old when you did this to me.
So the answer is you have a feeling, but you don't have any objective evidence to show any destruction of your life, your business life, or your home life. Objective evidence.
And my testimony about my home life is not going to be objective evidence in your eyes?
I'm not here to answer your questions.
Okay, I'll give you the answer then.
I'm asking for objective evidence. Did your wife file for divorce against you?
Overruled.
Did she?
Julianne has not tried to divorce me.
Has anybody sued your law firm?
I don't think so.
The ethical complaints filed, including mine, you recognize were dismissed by the state bar as premature because the matter with respect to Mr. Sandman was still pending in litigation.
Objection, Your Honor. It calls for facts, not evidence. Number one, he's testifying.
It's not true.
Well, we don't know yet. We can find out if the witness knows. You've brought it into relevance because it goes to damages theoretically. And so I think it's fair game. Overruled.
But Your Honor, that's bad faith. There was absolutely no evidence.
I mean, I
anything.
I don't
about
know.
Premature. They were dismissed because they were groundless what he
That-
did.
We don't need to
Not
fight.
because they were
There's an
premature.
order from the appointed person at the state bar.
Okay, well, now
that
we're
says-
talking about a whole lot of facts that
Right.
Jared doesn't need to hear about. You can ask your question as it relates and the witness can give you the answer. The questions are not evidence.
Thank you, Your Honor. Do you have a copy of State Bar's ruling on the ethics complaint that I filed?
Not with me, and I haven't reviewed it in years, but my understanding to your last question.
Do you have-
Objection, Your
No,
Honor.
he's going beyond the scope of the question, so it's non-responsive. You can ask your question.
Here it is one more time. Do you have a copy in your possession, custody or control, of what the State Bar officer ruled with respect to my ethics complaint?
I must have a copy of it somewhere. If you have one
Can you produce it for us?
right now,
Well, not right a second, but wait, can you find it and produce it for us maybe by tomorrow?
I'll let you deal with my counsel on that. I'm happy to do whatever my counsel or the court directs me to do.
You follow the advice of your counsel at all times, don't you?
Your Honor, to the extent that it calls for attorney-client privilege.
Yeah,
Otherwise,
I'll sustain that. Let's go on to the next question.
Do you expect your clients to follow your advice?
In most instances, but I'm also there as a counselor to give my best advice, and the clients need to hear the advice and then choose what they're going to do.
And if they don't trust your advice, you would expect they probably would get a lawyer they trust, wouldn't you expect?
Yeah, if it's a matter of trust and thinking that it's bad advice, then I guess I would expect them to do that, but I can't say it's ever happened.
Do you know Chris Marquardt?
Only through this litigation.
Do you know Joey Burby?
Only through this litigation. Or dispute.
You know about the fact that Joey Burby was a law partner at Powell Goldstein and Brian Cave with Nicole Wade.
I think I know that.
And then he left and joined the law firm of Alston and Bird, right?
I know he is at Alston and Bird now. I don't know what was in between that.
Are you familiar as an Atlanta lawyer, who I think you said you had worked a year in Marietta?
I worked first a year in Marietta.
Are you familiar with the reputation of the law firm of Alston and Bird?
Objection, Your Honor. It's bolstering calls.
Overruled. Overruled.
I'm generally familiar with Alston and Bird.
And what is the reputation?
Big law, hardball litigating, capable people.
They have a wonderful reputation in Atlanta. don't they?
Objection, Your Honor. It's characterizing testimony.
Just phrased it in the form of a question, Mr. Wood.
Do you disagree with the idea that Alston and Bird is one of the most respected?
Objection,
I'm
Your
not,
Honor.
I can't even
I
get.
don't understand, but this is a relevant topic. It goes to count two. I mean, sure, you can approach.
Say.
Because I was hearing it now yesterday.
Do you have any other points you're trying to make on this? Do you have any other points you're trying to make on?
I don't ask those questions. Move on.
All right, let's move on.
Can we read that? Thank you, Alan.
Yeah.
Mr. Wilson, would you disagree with the idea that Austin Bird is one of the most respected law firms in Atlanta, Georgia?
I wouldn't disagree with it. I just don't have any personal knowledge about it aside from what I've already said. They're a very large law firm, and they're very well known.
You never litigated against Austin Bird, have you?
And not in my capacity as a lawyer, instead of a client.
Now, at the time, and let me just ask you, isn't it true that you and I first spoke at the request that you had made of a lawyer named David Ehrlich, who was at the time an associate at Eldon Wood, he said?
I actually think David had already left the firm. I don't know if he requested that of you. I talked with a very close friend of David's, or he called me and said you had lost an associate and may need to fill the role. And I think I contacted you about that.
Actually, I believe it was Sunday afternoon when I spoke with you. Did you not ask me a question about what I thought about how your law firm was treating you in Marietta, given that you were bringing in a very large class action lawsuit? Do you remember that?
I wouldn't characterize it that way. I didn't ask how they were treating me at all. I think you asked me some questions about why I was calling and what, why am I looking to change firms? And a topic did come up about whether or not the compensation arrangement that I had on that matter was normal. I mean, I didn't know. I was 25-year-old first-year lawyer.
Very young. I don't mean that. You were a very young lawyer. You had only been practicing law 1 year.
That's right.
And they had, as I recall, they had offered you nothing for bringing the case into the firm, but only the idea that if it was successful, that they might consider giving you a $25,000 bonus. Do you remember that?
I don't remember the $25,000 bonus. I do remember the first part. I think they just told me in like a normal meeting that to the extent I would receive a bonus, that was entirely in their discretion. I think that's how it was.
And that you were not going to be compensated simply for bringing the case in because you were a mere associate.
Yeah, that topic never came up. There was no discussion about being compensated for bringing the case into the firm. That I don't think that ever came up.
What you were told was that they might consider giving you a bonus depending on how the case worked out, right?
Yeah, yeah.
But they did not change your compensation as an associate, right?
Well, no, I would know that was never discussed.
And your compensation at that time as a first-year associate, what was the name of the firm?
At that time, it was called King and Yacklin.
King and Yacklin. You were working for a salary of $45,000 a year, right?
I think that was my summer associate salary, and then I was being paid a little bit more than that.
How much is a little bit more?
It was somewhere in the 50s. I don't remember specifically.
So something 50 or slightly above?
It was above 50. I don't remember specifically. I think it was above 50 and less than 60.
Then you and I met, as I recall, the next day, and I talked with you about the possibility of coming to work with my firm as an associate, given that David Ehrlich had left and Jonathan Grunberg had just taken a serious fall and was not able to work in the office. Do you remember that?
I don't remember discussing David and Jonathan. I mean, we may have. I don't remember discussing that. I just remember us meeting, having a conversation, and you offering me a job on the spot.
And I offered you a job at a base salary of $75,000 a year. True?
I don't remember the specific number at that time, but that's close for sure.
Not only did I offer you that significant increase in your salary, but I said you can bring your class action case with you to LN Wood PC, even though you're an associate, right?
Yes, you were happy for that to happen. You told me I could do that.
And I made an agreement with you on that case that I would divide the fee with you, even though you were an associate, that I would divide the fee with you, giving you 80% and LN Wood PC 20%, right?
You didn't make that deal with me until years into that litigation. That absolutely did not happen when I joined the firm.
So you were working for years at LN Wood on that case with no idea of how you were going to be compensated, if any, from that case? Is that your testimony under oath?
No, it was clear to me that you were going to compensate me in addition to my salary if that case went well. But you asked me specifically about 80%. And you didn't mention that to me until some night in Savannah, Georgia. We were already in Suite 2040. I mean, that was years into our relationship when you said 80%.
Could you be recalling at a time when I spoke with you and said, instead of giving you 60 or 70%, I'm going to give you 80? Remember that?
I think you said that you didn't recall what our agreement was on that case prior to that, but that it would be 80. You were absolutely being generous with me about that. To the extent the case went well, I understood that you wanted to be kind to me and make me feel like I deserved it, and I appreciated it.
I wanted to be kind to you.
That was my sentiment.
Listen carefully, if you will, to this question so that we understand what I'm asking you. When was the law firm of Wade, Grunberg, and Wilson first incorporated in the state of Georgia?
It was around the time when you were considering.
Didn't ask you that. I asked a
Objection,
date.
Your Honor. He's
Ask a date.
giving background to answer.
If you
I'm not
want to
gonna-
rephrase your question, because you just said what time.
Yeah,
So
I would like to know, sir, the date. This is my question. What was the date when the law firm of Wood, Grunberg, and Wilson, PC or LLC, was first incorporated in the state of Georgia?
I don't know the date, but I'm happy to give you a general time frame.
Do you believe it was in 2018?
It was in early 2018 and never operated
That's
until
all I need.
2020.
Got the answer. So it was first incorporated in early 2018. True?
That's true.
All right, thank you. You had Your lawyer discussed several exhibits with you from conversations that occurred between you and me on February 13th, 2020. Do you recall being asked about those?
Yes.
And you talked about the fact, I believe those conversations included comments by me about you're my law partners and you can leave, or you got as much of a dog in the fight in effect as I do, because you're my partners, right?
Yeah, there were a lot of comments in that particular
Yep.
piece of evidence.
In that time period, February the 13th of 2020, you weren't talking about L. Wood PC. You were talking about the new firm of Wood, Wilson, Grunberg, and Wade. True?
I don't know that I was doing any talking, but at that time you had rebranded Ellen Wood PC to Wood, Wilson, Grunberg, and Wade.
Well, rebranded, did you not realize that I was going to actually form a partnership with you lawyers where I was going to take 20% and then y'all could split the other money up yourselves because I was going to retire? Do you not recall that, sir?
No, I don't recall anything about that. It was my interpretation of you changing the name was as part of your retirement plan and to put our name on the door, and that, but meantime, nothing else was changing.
How much and y'all were thrilled about it. I saw the February 23rd, I believe. Yeah, what was the date of that email?
It was January 24th.
January the 24th. What was the description?
Pinch me.
Pinch me. You were excited about it, weren't you?
Yeah, I was excited. I mean, you were an amazing lawyer with obviously an amazing reputation, and to receive that chance was incredible. And you were planning on retiring. And our biggest problems, I mean, it was always difficult, always. But our biggest problems didn't start until January 27th.
Sorry?
Our biggest problems didn't start until January the 27th. Of 2020, 3 days after that email. And
Sorry, let me get this right. January the 27th of 2020. That's when our real problems started.
that's when they became physical, violent, and terrifying.
Physical, violent, and terrifying.
Yeah. And overtly threatening.
On or after January 27th of 2020, our relationship to you became physically terrifying. Is that your testimony?
Yeah, I was terrified of you.
But yet you were going to meet with me on February the 14th to discuss the details of the new law firm of Wood, Wilson, Grunberg, and Wade, right?
No, I was not. You had not been in the office physically since the Musk trial. So you had not come to the office a single time between the end of the Musk trial and early December. And
I think he's allowed to finish this answer. He's getting there.
And on the morning of February 14th, I listened to you demand, a very polite way to put it, demand from Kimmy that she set up a lunch meeting, get some food, set up a lunch meeting where the four of us would explain to you why the name Wood is first, Wilson is second, Grunberg is third, and Wade is fourth. And we all were going to have to explain to you what was going on and why it's in that order. And at that moment in time, we're walking around the office trying to make sure there's nothing in there that you could use to hurt us. And I made the decision right then. I never agreed to a lunch, and I made the decision right then that I was leaving your life, no matter what it meant for my career. I was leaving your life.
So you thought so you were afraid I'd have some sort of a weapon in the office to hurt you? Is that what you're afraid of?
I believed that if we had to be in your physical presence on February the 14th, that it was very likely that it was going to become physical because of how you were behaving.
So everybody agreed to meet with me, and Kimmy Bennett ordered sandwiches for everybody. Do you remember that?
I do not recall everyone agreeing to meet with you. I remember you berating Kimmy, demanding that she set up this lunch, me listening to it, walking in circles around the office, trying to figure out what to do and what was going on. And is there anything else I can do other than leave?
And you left.
And I left
You quit.
explicitly.
Jonathan quit.
It's my understanding. I wrote an email about it. Chelsea quit
Nicole quit.
and Kimmy.
That's not true, but nonetheless, Kimmy still works.
All right, Mr. Wood.
I'm sorry. So as of February 14th, right? Whatever our relationship was before that time period, whatever it was, equity partner, it never was. Non-equity partner, you say, independent contractor, associate, whatever the relationship was, as of February the 14th, you all quit. You quit your job, right?
Yeah, we all quit. 5 of the 6 people that worked there walked out on you. That's what happened on February 14th, 2020.
And you never came back, even though I tried to talk with you a little bit about it, right?
That's correct. I never came back.
So as of February the 20th, you were in your own separate independent law firm, right?
Yeah, I think that's right. I think I think by February 18th, maybe.
February 18th.
Could have been the 20th. It was right there.
And clearly, on March the 17th of 2020, you had no affiliation whatsoever with my law firm, L. Linwood PC. You were totally gone and were operating your own law firms under various names. Taylor Wilson PC, Jonathan Grunberg PC, Grunberg and Wilson LLC, the Wade Law Firm LLC, and then the new firm that was incorporated in 2018, Wade, Grunberg and Wilson LLC, right?
There was so much in that question,
Well, let
and
me withdraw it.
I
Well,
absolutely.
he's withdrawing the question, so well, let's move on.
As of, we've established as of February the 18th, now you've told us you were done. Right?
Yeah, I was never going to work with Ellen Wood or Ellen Wood PC again.
So from February 18th, if not a few days earlier, our relationship as lawyers was totally separated, right?
So I don't.
In terms of being in any type of a firm together.
Yes, we were never going to be in the same firm again, but our affiliation was not then, and I don't personally think it's over now. But we were never going to work in the same firm again.
You said that our relationship started going south in September of 2019. Remember that?
That's when it got particularly difficult.
Well, didn't you say it started going downhill then?
No, I
You said it got worse and worse and never got better. Isn't that what you said?
I think I testified that there's always difficulties between people when you work closely together, and that by August or September of 2019, it became very difficult, and that it continued to get worse until we left on February 14th, and then it continued to get worse. Yeah, it got worse then, and it kept getting worse.
And then would have been within 2 or 3 months of a specially set trial against Elon Musk, right?
Yeah, I think so. I think it's more like 3 or 4 months, but yeah.
It was specially set the first week in December.
Yeah, I don't remember when it was specially set, but we had a trial. It may have started something like December 3rd of 2019. I don't remember when the court set the date.
You remember that the week or two before that, I was very ill, thought I had, may have been COVID, I don't know. Do you remember how sick I was before that trial?
It wasn't a week or two, the weekend before the trial. Like the Saturday before the Monday trial. You called me and told me that you couldn't breathe and you felt like you were maybe having panic attacks and asked me to be lead counsel on the Saturday before the Monday trial started.
Panic attacks. Were you not around me to see how sick I was with some sort of a chest problem?
I'm not saying you were having them. I'm saying that's what you told me.
Take a look at your Exhibit 91 that you talked about earlier today. You remember at or shortly before February 17th, I had serious concerns about someone, including you and Jonathan, Mr. Grunberg and Ms. Wade, and Rick Miller, having hacked my computer, such that I ended up filing a complaint with the FBI. Do you remember that?
I am aware that you had stated concerns. You had stated them, not necessarily that you had them, that Mr. Grunberg, me, Rick Miller, and the really nice woman that Rick Miller referred to you to take care of your home.
Rick Miller referral.
Yeah, and
Who?
a bishop, a gentleman named Bishop Ballard, who I guess has also came into your life in
Into
some
Rick Miller.
fashion. Can I finish my answer?
Sure, I'm sorry.
I'm aware that you had in your mind that all of these disjointed people had done something with something, and you were cracking open devices in your house, and you thought maybe Jane or
No, this is speculation.
you were aware that you had stated concerns that someone was bugging your house and that maybe someone had done something with your computers and that we were all wrapped up in it.
Do you have any evidence to deny, that I discovered that both my lake house,
Objection, Your Honor, he's testifying.
I'm asking him if he has anything.
Do you have any
to
reason to think he would? I mean,
I don't know what he knows. I'm asking him,
all right.
do you have any evidence to dispute?
Objection, Your Honor, it's assuming facts not in evidence and.
Overruled. You can ask the question.
Do you have any evidence to dispute the idea that my lake house at Lake Oconee and my home on Greenview had been wiretapped through my Wi-Fi systems? Do you have any evidence to say, I know that didn't happen?
Other than what you said in the courtroom yesterday, which is that you couldn't prove it. I think Tyler Jones, your tech guy, has testified that there's no evidence that any of that happened
Hasn't
after you
testified
asked him
yet.
to.
I mean, you are interrupting him. I think you did ask the question of whether he has any knowledge. And
Go ahead.
I think the guy, your tech guy that you hired to look into these things, has stated under oath that he saw absolutely nothing odd, weird, or disturbing about your concerns.
Well,
And I also know that from my general dealings with you and other sort of ideas that you were having, that it is a near certainty in my mind that nobody was tapping your phones or using your Wi-Fi or bugging your homes or devices.
now you're gonna bring Tyler Jones as a witness, I believe.
Yeah, I'm not the lawyer here. We'll see.
I'm sorry?
I'm not the lawyer, so
Well, that's what your lawyer is representing to the court and to me, that you're gonna bring Tyler Jones as a witness.
I understand Mr. Jones is
I
on the
don't
witness
think that's
list.
entirely accurate according to the pretrial order, Mr. Wood. They may call him. I don't think they said they would.
Well, apparently you know who he is. You could subpoena, well, I know they issued a subpoena to him. So let me just ask you this way. You know who Tyler Jones is. You have issued a subpoena for him to testify at this trial, right?
Yeah, that's my understanding.
And my question is simply, are you going to bring him to trial?
I believe that am I getting into privileged things?
Well, that's really not a question appropriate for a witness. That's for counsel, and that's not a decision they have to make at this time, Mr. Wood. So let's move on.
So if you look at back to Plaintiff's Exhibit 91, can you, when it was being discussed by you on your direct examination, part of it was put up, the top part of it, where you wrote me and said, Lynn, I got your message. I just got up and I'm taking care of James right now. Thanks. I just listened to your second message. Again, I've done nothing at all that you have described and know nothing about it. Please don't contact me right now. And then you ended with a dramatic statement where I wrote and said, fuck you.
Why?
He's mischaracterizing testimony.
All right.
Don't cross.
Let's get to a question here instead of just reading the entire exhibit again.
Well, let me get, you ended what you put on the screen and your testimony with that portion that said, I wrote and said, fuck you, you're going to jail. Right?
I think that's the last thing I testified about. I have no idea what was going on the screen.
You have 91 in front of you now?
I'm looking at it.
What you didn't discuss was the following, where I said, I just remembered I am ignoring that, quote, it is what it is. God is in control. He always works for good. Musk is after all of us. We all attacked him. He is establishing that we can be manipulated. You cannot control anything if it is what it is. God is in control. God is all powerful. I get it. Mad that I didn't get it earlier. I expressed to you that the things that were happening in our legal relationship that started within 2 or 3 months of the Musk trial and continued on into February of 2020 that I believe were orchestrated by the world's richest man, Elon Musk. I told you that, didn't I?
Well, that's not what you told me. You expressed that Musk is after all of us, and you've continued to do that. And as far as what I understood it to mean, it was you saying, I mean, we got plenty more hate after this, but this is you expressing that it's never your fault. It must be Musk and the CIA and psychological operations, and nothing that Lynn Wood's done in his life or what he's done to his law partners and their families. It's Musk.
I moved to strike that. That's not responsive.
Overruled. You can ask the next question.
What do you mean what I've done with my family?
What you've done to my family.
What have I done to your family?
Really?
Making more money now than you ever made before. You made more money working for me than you ever made before. You made $1 million.
All right. Mr. Wood, sustain this. We've already covered this.
That question, Your Honor?
Yeah, I'll withdraw it.
No.
Then no.
I'm sorry.
He's withdrawn the question. You can
Yeah.
ask the next one.
So it never crossed your mind. You were sitting in the courtroom. I let you give the opening statement in that case in Los Angeles, didn't I?
You didn't let me. You told me 10 p.m. the night before the opening that I was going to give the opening statement in the Elon Musk case against the richest man in the world. I
Gave you that opportunity, right?
You gave me the opportunity to prepare to give an opening statement in a international news case as a 30-year-old lawyer at 10 p.m. the night before I had to give it.
Were you excited to be able to do it?
Given the context in which that opportunity arose, it's pretty terrifying. I mean, but yeah, I guess, I'm really glad I had the experience now, but man, in the moment, trying to stay up till 6 a.m., sleep for an hour, and then go to court and give an opening against Elon Musk, I wouldn't say that was the best circumstances for your 30-year-old law partner to be in.
You were sitting in that courtroom in Los Angeles where you saw me as far away as I am now from the court reporter in front of the jury. Look over at Elon Musk 5 times and said Elon Musk is a liar. 5 times. Elon Musk is a liar. The richest man in the world. Had you done any research on Elon Musk to see what he does to people who attack him?
Beyond what he did to our clients, and which you then didn't use in the case? No. No, I hadn't done any research outside the confines of anything that was relevant to my representation of Vernon Unsworth.
Did you not think Elon Musk was going to get even with me for sitting there and looking at him in front of a jury publicly in Los Angeles 5 times and saying Elon Musk is a liar? Did you not think that Elon Musk might try to get even with me and the people that I worked with and even my family?
I didn't think that at all, and I'd be surprised if Elon Musk has thought of Ellen Wood, G. Taylor Wilson, Nicole J. Wade, or Jonathan D. Grunberg since he beat us.
Well, time will tell what Elon Musk has thought
All
about.
right, we're getting back into speeches. Let's stick to questions.
You don't know what President Trump knows about Elon Musk and that trial, do you?
Objection.
Yeah. Yeah, let's get to the next question.
The judge out there in Los Angeles treated us all like dogs, didn't he?
I don't agree with that at all, and to the extent that the judge expressed frustration, I think it was warranted.
Anything that goes against me, you go is warranted. Never defend me. But we were out there, everybody was shocked.
Objection, Your Honor. He's making a statement and not even asking.
Strike that.
Okay.
Strike that. I want to get this done before we take the lunch break. Who recommended to me that I hire as a jury consultant? Who recommended Tara Trask to me to use as a jury consultant in the Elon Musk trial?
I'm actually not sure, but I have 2 people in mind.
Who is you two?
Dr. Phil McGraw or a very well-respected lawyer named Chip Babcock.
Well, do you have any basis to disagree? Chip Babcock, do you have any basis to disagree with the fact that Chip Babcock recommended somebody from Texas and it was Dr. Phil that said Tara Trask is in California and that's who you should use?
Yeah, I just don't recall one way or another on that.
So there's old Dr. Phil. Dr. Phil, TV star, made his fame working with Chip Babcock on a case down in
Objection, Your
Texas.
Honor. We're testifying.
Well,
again.
I think he's getting to setting it up as a premise to a question, but we need to get to a question.
Made his fame working with Chip Babcock on a case in Texas as a jury consultant representing Oprah Winfrey. And then she put him on her show.
All right, now we are just getting into, unless he knows about it, that should be something for your testimony. Mr. Wood,
And then
let's get to a question.
just give me 1 second. I promise, Your Honor, I'm right at the end of the question. I'm not going to start over again.
I've got the question. I'm still following it.
Yeah,
Okay.
and that was the springboard to Dr. Phil becoming a very well-known television personality with his own show, right?
My knowledge of that is that generally Dr. Phil's being in Oprah Winfrey's orbit was his springboard to fame, but that's just a general understanding.
You received at some point in time after February the 8th of 2021, you received and reviewed the February 8th, 2021 sworn affidavit of Nicholas Sandman, didn't you?
Yes, at some point after February 8th of 2021, I have reviewed that affidavit.
And so your state of mind from the time you reviewed it included that Mr. Sandman, Nicholas, said on July 24th, 2020.
Objection, Your Honor.
Why would his state of mind be relevant?
Sorry?
Why would his state of mind be relevant in 2021 onward?
Because of what he's accusing me of acting in bad faith. He's saying that I was acting in bad faith and he had knowledge in his own state of mind about the truth of what Nicholas Sandman has said in his affidavit.
Right.
Clearly relevant.
Ms. Brown?
No counterclaims in this case at all, and so Mr. Wilson's state of mind is irrelevant.
All right.
What he knew and didn't know is relevant. And that you call that state of mind. That I'm just referring to the fact, what did he know?
Yeah.
In his mind's eye, what did he know?
And I think when we get to 2021, the only thing that is an active claim for the jury is not his intent by that point. So I'll sustain the objection on relevance.
Are you aware at any time that Nicholas Sandman stated that his decision to not agree to the settlement split at that time,
Objection, Your
that,
Honor.
excuse me, Mr. Wood played no part in it?
Objection.
Yeah, Mr. Wood, it probably is going to come in somewhere else in this trial, but I don't think we just need to be going through all the exhibits through a particular witness if they didn't have anything to do with those exhibits.
He had everything to do with it. That's part of their case.
All right,
Your Honor,
I disagree,
Your Honor has
Mr.
ruled that
Wood.
it's admissible.
Yes, but not in this manner and not at this time.
Well, I don't know if it's admissible evidence or not entitled to cross-examine the defendant on it.
Well, the plaintiff here,
The plaintiff.
yeah, no, Mr. Wood, I don't think the reference to the affidavit is the way you presented it is
It's
appropriate right now.
admissible evidence in the trial.
Yeah.
And you're telling me, and I respect, if this is your ruling, I disagree with it, that I'm not allowed to cross-examine an opposite party on evidence that you have already ruled is admissible and relevant in this case.
That's right, unless the questioning is somehow relevant to a facted issue. So just his opinion on it, his thoughts on it, I don't find those relevant.
Not asking his opinion or thoughts. I'm asking him.
Just for him to read it? I mean,
I'm sorry?
just for him to read it?
No, I'm asking him if he knew.
Yeah. Again, so you are asking his thoughts on it.
He can only testify to what he knows. Every witness gives testimony based on their knowledge.
Yeah.
I'm asking him about his knowledge.
I'm just not seeing the connection here, Mr. Wood. I think it'll come up in some other form at a later date or day today. But so.
Thank you, Your Honor.
All right.
Just a stopping point? All right.
It
Members
is
of the-
any, and how does the clock work again?
Counts down.
Is the 1:57 me?
That's right.
All right.
Okay, members
Thank
of the
you, Your
jury,
Honor.
we've reached our afternoon lunch break. Let's try to regain some of that time. Let's be back at, that we missed yesterday when I excused you early. Let's be back at 1:30, okay? I'll remind you not to discuss the case with anyone, including amongst yourselves, and not to do any research about the case outside of this courtroom. Thank you.
Time did you tell us back, Judge?
1:30.
Can we get sort of a ballpark on how long he thinks the rest of his cross?
We'll check
will
in.
be?
We'll check in.
Because we've got another witness.
I'm under the clock, so.
I think they want to, well, let's wait till the jury leaves the room. Okay, I think Mr. Beal just wants to get an idea if you still believe that you're going to be needing the full 2 hours.
Remaining 2 hours?
That's right.
I don't know, Judge. I hope not, but I can't say I won't.
Okay, I think that's as good as you can get, Mr. Beal.
Require me to ferret out and get to the truth.
Anything else? I mean, that's going to put you with an hour and a half roughly of time still to fill this afternoon that we're going to need to fill.
Okay, we'll be all right.
Yeah.
Thank you.
May I step down here?
Just give me, well, yeah, you, of course, you can step down.
I'm sorry.
Give me, I think they're saying they have one more issue they want to raise. Just hang tight just for a second.
Council's,
Mine too.
my client's, wife is, wants to come and she is, member of the bar. And we're gonna tell the
Yeah.
folks outside that she wants to be able to bring her devices into the
Yeah.
office. Is that okay?
No, I mean, that's the prerogative of the sheriff's office. And they've essentially said, that they're the ones enforcing the rule that no devices other than a lawyer with the case or a party. Let me go ahead and amend with the seating. At this point, I think things have settled down somewhat. If we just keep them off the first row, I think that's fine. But otherwise, you don't need to be asking me for permission for where people are sitting. But no, I think we need to have it a blanket across the board on phones.
Thank you.
All right. Thank you all. We're in recess till 1:30.
Wait a minute. Literally 2:30.
Because Jay has our session.
4:35.
The beginning.
They-
Go.
what they say.
Let's talk about this out. We're so live.
Yeah. Deputy Scott, can I see you? Can you get him on?
So 5 days in recess until 13. So for room 5A, 5 now. He said until the rest 30 hours, show me on 27 now.
You've been asking me. Remember the date Jonathan was hurt? Kimmy sent us an email.
Yeah, she sent it in text. That's this question. Oh, wait, this is something that we asked.
Yeah, put it in there.
It isn't it?
Seated everybody. Yeah, why don't you go ahead and head on up. And when you check in, see if we got them all.
Drew, where's your notepad?
Oh, it's in the other room.
You did not know that.
I'll go get it.
Yeah.
Thank you.
Thank you, Michael.
It's against the wall. I-
Oh, cool. No, it's totally. All right. Pay me your money's.
I think there's some
Some
hope
your babies.
here.
It's nice.
I don't know where any of my stuff.
Oh, yeah.
I did find
Oh.
some.
It's a lot.
Maybe, I haven't seen that.
Oh, okay.
BP.
That's the worst, I think that's where the drinks are. Yeah.
Yeah. 222.
I mean.
I'm going to. In like 2 seconds. That's fine. There's a reason it's there. We don't have power. Yes, but.
Okay, do you want me to ask this or just?
Don't answer. Okay, good. Who produced this?
This?
We identified this. Skips back and forth.
Yeah, it is.
Yeah.
This is a pre-market. This is, yes, this is ours. We haven't introduced it, but we sent it and it's.
Hold on.
Oh.
This is not.
Thank you, Deputy Scott. Please be seated, everyone. Defense may proceed when ready.
May I proceed, Your Honor?
You may.
Afternoon, Mr. Wilson.
Mr. Wood?
Let me hand you, or you can take a look at it. If you have it in front of you, the agreement that you signed on March 17th, 2020.
Do you know which exhibit number it is?
102.
Oh, plaintiffs. Got it.
Go look at page 7.
Yes.
Is that a true and correct copy of your signature, Taylor Wilson individually and on behalf of G. Taylor Wilson LLC and Grunberg and Wilson LLC?
Yes.
And you signed this agreement on the 17th of March of 2020.
Yes.
At the time that you agreed to the terms.
Yes.
Whoever drafted it, it was finalized. And you signed it with the full knowledge of your lawyer, right? He knew you were going to be signing.
Objection to the extent that calls for attorney-client privilege,
I'm not
but
asking for
otherwise
the
the witness can
communications.
answer.
You were paying Andrew Bill to negotiate an agreement with Joey Burby and Chris Marquardt, right?
Yes, of course, Mr. Beal knew that I was signing the agreement.
And Mr. Bill and Joey Burby and Chris Marquardt finally came up with a final agreement. It was presented to you and you signed it on March the 17th of 2020.
Yeah, the parties through their lawyers came up with a final agreement and it was signed.
Right. At the time you signed that agreement on March the 17th, you put up a lot of testimony and the various text messages and emails and phone messages, voicemails, and those all predated March the 17th of 2020, didn't they?
I don't think every piece of evidence has, but I think the ones you're referring to that you were leaving from me in our conversations, those were before this agreement. Yes.
Have you put up any voicemails subsequent to that I left to you or text messages subsequent to March the 17th?
No, I was referring to the recording between Mr. McMurtry and I that was also put up, and I was just clarifying.
Right. Other than the recording of Mr. McMurtry, all of the text, the voicemails, the recordings of meetings, was Jonathan doing all the recording?
I should answer the second question.
On the meetings, who was doing the recording? Jonathan?
Mr. Grunberg and I each recorded Lynn occasionally.
And Ms. Wade doing the recordings?
Not to my knowledge.
So it was either you or Mr. Grunberg?
I believe that to be true.
So you knew March the 17th. You knew exactly what had been said in those meetings, didn't you?
Yeah, all the things we listened to are why we made the concessions that are shown in the.
Prior to March the 17th, all of the text messages, all of the voicemails, all of the meetings that y'all recorded, you knew about everything that was said in those discussions prior to the time you signed the March 17, 2020 agreement. True?
Yeah, I think that's correct, but I need to clarify that there were things going on and that you were doing that had nothing to do with us and that we knew nothing about.
I don't know what
Yeah,
that
our interactions, all of our interactions, I think the point of your question is that all of our interactions with you that dated March 17th occurred before March 17th, and I knew about them.
Right. So there wasn't, nobody was hiding anything. You knew exactly what I had said, whether you agreed or not, whether my language is inappropriate for whatever reason, I apologize. You knew I was angry at one point in time about what I perceived was your interference with my children. You knew that, didn't you?
There were things that were hidden specifically, such as the smoking gun emails that you had with Mr. McMurtry. And in fact, they remained hidden in this case despite discovery. And Mr. McMurtry himself failed to produce them to us under subpoena. And even though the subject of the emails, literally in the subject, and the whole body of those emails are all about Nicholas Sandman, Mr. Grunberg, Miss Wade, me, our specific compensation numbers, our settlement agreement, even though it was plainly obvious that they were critical evidence in this case, not only did we not know about them on March 17th, but both you and Mr. McMurtry kept them from us until we received them from a third party.
Objection and move to strike the characterization of what's critical evidence in this case.
It was in response to a very open-ended question, Mr. Wood. Overruled.
So Todd McMurtry deceived you. He didn't give you those emails that you say are smoking gun emails, right?
He did the second time.
He didn't ask you that. He didn't give it to you the first time, so he deceived you, you say.
Well, Mr. Wood, you asked me if he didn't give them to me. He did give them to me, just not until we already had them, but he did give them to me.
Where'd you get them from?
We got them from a lawyer in Nevada that you forwarded them to. You forwarded them to a third party named Nikki Baker, is a lawyer we've all worked with, and she provided them to us.
And so you had those before March the 17th?
Oh, no. We didn't receive those until sometime in spring of 2021, I think. We didn't know about those for almost a full, or probably more than a year after we signed this agreement, and several months after this litigation had been proceeding.
So you sued Todd McMurtry claiming that he had engaged in a conspiracy to defraud you, right?
We did not sue Mr. McMurtry initially.
Objection, Your Honor. He's answering the question. He's interrupting him again.
I have a limited amount of time. If he would just listen to the question and answer the question.
All right, you can re-ask the question,
Right to explain.
and I'll instruct the witness just to listen to the question and answer only the question asked.
Thank you, Your Honor.
Excuse me for having to bend over. My back's gotten worse this week. My question, Mr. Wilson, is you and Mr. Grunberg and Ms. Wade, you sued Todd McMurtry, contending that he was guilty of a conspiracy to defraud you.
Yeah, we did that after we found the emails, and not before then.
And then at some point, you settled with him, right?
Yeah, Mr. McMurtry and his law firm settled our claims with us. They did, yeah.
Did any money change hands?
Objection, Your Honor.
Sustained.
Sorry?
That's sustained, Mr. Wood.
Was there any part of that settlement agreement that was based on Todd McMurtry providing certain testimony in the case?
No, absolutely not.
So you don't want to tell the jury how much money you got?
Objection,
That's
Your Honor.
completely improper, Mr. Wood. I'll ask the jury to disregard that.
Well, I mean,
The rules of evidence are what they are, Mr. Wood.
so
I do not believe that that is an appropriate question. I've made the decision that that is not relevant. It has nothing to do with the witness's decision.
we won't know.
Mr. Wood, we stop there. We keep going.
I'll keep going. take back a look back at the settlement agreement.
Yes.
Page 1. Paragraph 1, fee split for legal work. You with me?
Yes.
LLWPC shall pay to WGW a portion of its fees for the following cases, and they're listed out, right?
Correct.
The agreement to pay WGW certain fees under this agreement was an obligation of the LLWPC. True?
Yes, and we've seen the emails on how that happened.
And you agreed to it.
I did. I actually don't know that I caught that. I don't know that I knew that at the time, but I certainly agreed to this agreement. I signed it.
Well, your lawyer looked at it, right?
We all looked at it, and we were given a short amount of time. We all looked at it. I signed it, and I'm living by it.
I'm sorry.
Yeah, this is our agreement.
You contending that you were pressured into signing this, or did you sign it on your free will?
Oh, you pressured us to enter into this agreement in so many different ways. And as a result, we made significant concessions to you that we just did not need to make. But again, we just wanted this to be resolved. And so, yes, I was absolutely repeatedly pressured into signing this agreement by you. But none of that, I'm not sure why the question, but I'm living by this agreement. I affirm the agreement. Everything in it.
Everything in it.
Everything in it.
Every word in it.
I affirm this settlement agreement.
Whether you were pressured or not, you signed it and you stand by every word in it. True?
That is true.
Ms. Wade, she signed it.
Yes.
Mr. Grunberg signed
Yes.
it. Andrew Bill, your lawyer, helped work with Joy Burby to get to a final agreement. True?
Yeah, your lawyers prepared a draft and we signed it. And Mr. Beal exchanged drafts with them.
Whatever they did back and forth, the bottom line is Andrew Bill, as your lawyer, knew exactly what he was asking you or allowing you to sign, didn't he?
Objection calls for speculation as to Mr. Beal's state of mind, which is not at issue in this case.
As phrased, Mr. Wood, I think that is troublesome. And I think we have covered this question. So you can either rephrase or we can move on.
Let me try to rephrase. I mean, Mr. Bill was your lawyer. You were, I'm sure, relying on him to help draft this agreement on your behalf, right?
I'm just going to answer it without getting into privileged issues. Absolutely, everyone was aware of what was going on and we all signed the agreement. And on our side of the V, we affirm the agreement and we abide by it. And we have abided by it the entire time.
And you continue to insist that it be abided by.
Yes.
That would include an insistence that the terms of the non-disparagement provision apply, right?
Of course, it's one of our claims.
That would include that the terms of the mutual general release apply, right?
Every single term of the agreement.
That would imply paragraph 5. No further money owed. The parties acknowledge and agree that except as set forth expressly in section 1 of this agreement, there is no further money owed by LLWPC and or Lynn Wood individually to WGW or its members, or by WGW and or its members to LLWPC and Lynn Wood individually. Have I read that correctly?
As of that time, that is absolutely true, unequivocally. We agreed to it, and you didn't owe us anything until you signed on the dotted line, committed fraud, and then didn't pay the monies owed under paragraph 1.
Just like that, Your Honor. Totally argumentative.
Members of the jury, again, as I've instructed you before, you will be the ultimate arbiters of whether a fraud was committed in this case. We can continue, Mr. Wood.
So what I've said is right. That's what that paragraph says expressly by its term.
You've read it correctly, Mr. Wood.
Now, are you trying to stand by part of this agreement and renege on other parts of it?
Objection, Your Honor. One, it's argumentative. Two, it's violating the court's motion in limine on which paragraphs of the release agreement have already been ruled upon this court to be upheld.
This is not the least of it.
Yeah, based on the question is asked, you can answer it. Overruled.
No, absolutely not. That provision has nothing to do with this case. It's entirely irrelevant. I affirm paragraph 5 and every word of it.
Paragraph 4B. Released by WGW. Nicole Wade, Jonathan Grunberg, and Taylor Wilson, and Wade, Grunberg, and Wilson, LLC, for themselves and itself.
Objection, Your Honor.
He can read a part of the settlement agreement. What question comes from it, we'll find out.
Following along with me, Mr. Wilson.
I trust you're reading it correctly.
Hereby irrevocably and unconditionally forever release and discharge LLWPC and Lynn Wood individually and their heirs, executors, administrators, and assigns, and their attorneys and representatives, and waive any and all rights with respect to all manner of actual or potential claims, causes of action, suits, judgments, rights, demands, debts, damages, or accountings of whatever nature, legal, equitable, or administrative, whether the same are now known or unknown, which WGW and its members ever had, now have, or may claim to have, upon or by reason of any facts or omissions of LLWPC and Lynn Wood individually up to the effective date of this agreement, including but not limited to all claims and liabilities arising from any acts, omissions, cases, or business relationships that have occurred or commenced, or allegedly have occurred or commenced prior to the date this agreement is signed. This is a general release of all such claims. Have I read that correctly?
You have read that entirely irrelevant provision correctly.
Move to strike that, Your Honor. Totally improper for you to do what's relevant and irrelevant.
Overruled.
So you don't think the agreement is relevant?
No, that provision has nothing to do with this. The only reason that provision has
No, not on this issue. I
The-
understand your objection. I overrule it.
the only reason that provision has anything to do with this is because we have not sued you for all the before the agreement, before this was signed. And in other words, we've entirely abided by it. And instead, we have appropriately sued you for the claims that are not released by this provision, which includes the claims pending before this jury for your breach by failing to pay, or your breach of the non-disparagement provision, and for your fraud in executing the agreement. This provision prevented us from bringing claims against you for the evidence that the jury has heard.
You've answered the
Thank
question.
you. Thank you, Your Honor.
Ask your next question.
Argument, I hope will not count against my time. So, Mr. Wilson, how many times have you sued them?
Objection, Your Honor.
Sustained.
Have you ever been involved as a lawyer in a lawsuit against an individual or corporation where you contended that someone fraudulently conveyed property?
Objection, Your Honor.
Yeah, I don't know the relevance of that line of testimony or where it could go.
I'm simply asking, has there ever been involved in a case where there was fraud alleged in the transfer of property?
And I don't know why that would be relevant.
Well, I can tell you, you know why it's relevant.
I don't.
Are you
If
aware?
you want to approach, you can, if you want to approach, you can tell me. I'll pause your time, guys. All right, let me ask you next question.
Have you seen at any time before today, have you seen the letter of July the 24th, 2020, that Christopher Marquardt of Austin and Byrd sent to your lawyer, Andrew M. Beal, regarding the Sandman settlement?
I've seen Mr. Marquardt's letter, yes.
And have you seen the letter of Joey Burby sent to Mr. Bill regarding the Sandman issues, dated August the 28th of 2020?
And that one's not as fresh in my mind, but if it was sent to my counsel, I've reviewed it.
I'm sorry?
That one's not immediate. That date doesn't trigger a specific communication from your lawyers, but if my lawyers received it, then I reviewed it.
But as we sit here today, you will admit under oath that you have never prepared an affidavit describing your work in the Nicholas Salmon cases. True?
I will admit only that I explicitly offered Mr. McMurtry to do so, as the July 24th, 2020 letter sort of asked us to do, and that he said, I don't need it. I'm not going to do anything with it. Nicholas is not going to approve a fee. It was never the idea.
I'm not asking you about that. I'm asking you plain and simple, as you sit here today, you have never prepared an affidavit describing your work, estimating the number of hours involved, and proposing a total fee based on an hourly rate. You've never done that, have you?
I've not done it despite my offering to do so, because Todd McMurtry says I don't want it and I don't need it, and I was never going to do anything with it. I'm not going to get into it with Lynn Wood.
What about Mr. Burby's request to your lawyer of August 28, 2020, specifically asking for such an affidavit? Were you aware that he asked for that affidavit?
I'm just generally aware of the requests, and we didn't at that time, including because you, Mr. Wood, possessed all of our files and all of our work. You had cut off access, I believe, to our work.
Is there anything?
You knew.
I'm sorry.
You knew Mr. Wood and Mr. McMurtry, all of the work that we had performed. And we, as it turns out, were entirely correct that it was.
Right, I think from there, you've answered the question.
Thank you, Your Honor.
Mr. Wood.
Can I move to strike that amendment? I've got to get response.
Well, then we've got to ask direct and leading
I
questions.
have been asking questions. And he goes off and he's a lawyer, so he has a tendency to want to.
Okay, well, we can go from here. I'm trying to be mindful of the balance of both sides. You can ask your next question.
So to be clear, you had never prepared any such affidavit certainly before August 31 of 2020, right?
I had not signed anything under oath, but we had absolutely provided you and your lawyers descriptions of our work.
I'm sorry, say that again?
I had not signed an affidavit as a sworn statement under oath, and I hadn't done that, but we had definitely provided you and your lawyers with a description of our work.
Who provided Joey Burby or Chris Marquardt with the description of your work?
Our counsel,
Is that in writing?
I believe it to be.
Do you have a copy of it?
I'm not the lawyer on this case. There's three.
Have a copy of
I probably do.
it? Was it a memo? Was it an affidavit? What did you provide Mr. Beal?
It was, I think it was correspondence between counsel saying this is the work the work that we performed on the Salmon matters.
A letter from Drew Beal to Chris Marquardt or Joey Burby?
Yeah, it's my recollection.
What's the number?
The D13.
Are you familiar with the original complaint that you filed against me? On,
To the extent that the first complaint has been amended several times, and that's not been
All right. Well, Mr. Wood, I think you can proceed.
thank you. Are you familiar with it's not D13. Where's my, excuse me one second, I've got the wrong notebook. So many notebooks flying around.
Yes.
Appendix 13. Verified complaint. You familiar with that complaint? Verified under your signature of August the 25th of 2020.
I am.
You testified under oath to this jury that you did not want our disputes to go public, didn't you?
I absolutely did not want them to be public.
But yet you filed this complaint verified under oath on or about August the 25th. And the first 116 paragraphs talked about all of the same things that you're talking about today in terms of February of 2020. Didn't it?
When you say all of the same
Oh,
things,
stop.
yeah, we had to substantiate and plead with particularity our claim for fraud. And we did that in order to meet the pleading standard, which you now know we did.
And you're aware that literally within 24 hours of the filing of this complaint against me and my law firm, that the allegations that you made against me went national in terms of the news. You knew that, didn't you?
Objection, Your Honor. 403, relevance.
All right, Mr. Wood, you want to tie that into a proper purpose?
The man testified under oath, Your Honor, that he didn't want this to go public. He didn't fall off the truck yesterday. He knew that.
Objection, Your Honor. We're
And
not
I
testing.
know you're saying you can just say it's for impeachment of that statement.
But it is for impeachment. Because
Okay.
of how this knowing is going to go public, and he had knowledge of my reputation that this was going to get spread all over the world.
Okay, and
Which is inconsistent with his testimony. He didn't want it to be public. So I think I'm entitled to it.
All right, I'll rule the objection if that's the sole thing you're asking about this.
You understand the question?
Yeah, I do. And my testimony was that I settled these issues with you twice despite your conduct so that we could do it privately and amicably. And then you failed to comply with the obligations in the agreement. And so we sued you for it. And we sued you in a manner that met the pleading standards of the state of Georgia.
And you knew, based on my national reputation.
Objection, Your Honor. It violates the court's motion and limiting order on harms.
Don't quite,
Can we approach?
sure.
It's offered to the beach.
There's no new avenue you opened up by saying you didn't want to break any of this public.
No, and what
And I
was
guess-
the difference? It's not impeachment, because he didn't say he didn't want this one.
Really concerned that I think it clearly is offered to show. I think it's clearly allowed to show. The jury will be clearly allowed.
All right, we're not gonna dwell on it long. So
Yeah, go.
go forward.
Before. Yeah. He knew based on his national reputation, he knew allowed us. For that, that was your last question, but you got cut. One before that. You were. Yeah, let's do that. You're aware of that. So oh, and you're aware that literally within 24 hours of the filing of this complaint is in my law firm, that the allegations that you made against me went national in terms of the news. You knew that, didn't you?
I can't say that I knew that it became news within 24 hours, and I didn't know what any third parties were going to do with this public proceeding. But you know, that you're upset that your conduct is in our public litigation. I mean, that's not I didn't commit the conduct. It's just not for me to.
You say that you entered into the agreement with me despite my conduct towards you, right?
I did that twice, on February 17th and March 17th, to avoid this. That was my testimony to the jury.
The only agreement is March 17th, right?
Well, the March 17th one took it, as a matter of fact, a February 17th agreement existed, and it was subsumed by the March 17th
Exactly.
agreement.
So there's only one agreement, March 17th. Whatever was done before that, as you say, on February the 20th, was subsumed or incorporated into the March 17th agreement, right?
Yeah, there's only one agreement that we're suing on because it subsumed the other one that exists. So there were two. It's just that as a matter of law, we're only suing on the second one.
And the first agreement that was, you say subsumed, it didn't deal with the issues on the lease, did it?
Yeah, I mean, there were no issues on the lease. We just agreed to do it because we didn't want this to be public and we wanted to resolve it.
Because you didn't want it to be public. Do you believe that when lawyers get into a public dispute about fees, that it demeans the profession? For the public to see two lawyers or more fighting among themselves about fees?
I don't think I have I don't like it. I mean, I don't think I have I don't think I can just agree with your general description there, but I certainly don't like it. And it was not an easy decision to decide to pursue our constitutional right to file this litigation. It was not easy then at all. And, you know, but
Are you familiar with the State Bar of Georgia's preference for lawyers to,
Objection, Your Honor. One, that what he's about to say is not true, and two, it's irrelevant.
To the extent you're just asking him for the law or legal positions, I don't think that
Let me
would be
withdraw
appropriate.
and say,
Okay.
consistent with what Your Honor has recognized I have the right to do after he said he didn't want this to be made public. You are aware that Joey Burby and Chris Marquardt,
Objection, Your Honor.
Oh.
Settlement negotiations.
I don't really know what the end of that question is going to be, but if it is regarding settlement negotiations, that wouldn't be appropriate.
it's going to go to show that what he just said to this jury.
Can we?
Okay. All right. Why don't we, you're going to hold this until you can come back to it, and
Well,
we'll
I just
discuss
want-
it outside whenever the jury can take
One
a break.
question, I think, and I'm done to move on to another subject.
Yeah, but I think it's one we need to discuss outside the jury's presence. So let's move on. We can come back to it when you let me know when.
Mark, it would, it's about. Mark, when you come back. ask about it. Yeah. Do you know what a 1099 is?
Sure.
Tell the jury what a 1099 is, to your knowledge.
It's a tax form issued to people or companies that one person or company pays for services.
As an independent contractor.
I can't say that I know that the 1099 is actually only about independent contractors. I actually don't know that. I think generally speaking, you would issue them to independent contractors. I just can't say that's the only thing they do. I just don't know that.
In a recent pleading you filed, you admitted that all of your tax returns, 2016, 2017, 2018, 2019, that you calculated your income off of 1099. True?
I'm sorry, which years?
Well,
Was it 20?
you got a W-2 when you were employed.
I got a W-2 from Ellenwood PC from when I joined, I guess, through March or May 1, 2018. And then Ellenwood PC sent me 1099s for the balance of my work for Ellenwood PC. And it just has nothing to do with the bar rules. It's a tax issue. It's not a bar, it's not a lawyer
Objection,
issue.
Your Honor. Strike the witness's legal conclusions about what he thinks a 1099 is and whether it has relevance to this case. He's not the judge. He's not the lawyer. He's a witness.
All right. That was the witness's opinion as to the question asked, and the jury will be the ultimate determiner of those facts. So overruled, you can ask your next question.
Whatever certainly when you submitted your income to the federal government based on 1099s, you knew what you were telling the government, didn't you?
I knew that I was telling the government that I had received this income, or my LLC had received this income. That's what I knew.
And it wasn't done on a W-2 employee basis after you were no longer an associate, right?
Yeah, right. It wasn't done on a W-2 basis, but you also, I mean, I'm not a tax guy, but you also declared me to be a common law employee for other reasons.
I don't know what you're talking about. Your Honor, I haven't declared him to be a common law employee.
That Mr. Wood, I've warned you twice now during this. I know, but just because you disagree doesn't mean you get to then tell the jury you disagree until you testify.
I object to it because it's not responsive and it's his opinion.
He's here to give his opinions. He's a witness.
For an opinion?
All right.
I asked him what he was.
The objection's overruled. Next question, Mr. Wood.
You didn't send, once you were no longer an associate, you never received a W-2 employee tax form, did you?
Not from Ellenwood PC during the relevant time frame you're asking about.
Did you receive one from some other organization?
Yeah, I think the G. Taylor Wilson LLC would have issued me a W-2.
Were you paid in part on a salary basis with G. Taylor Wilson LLC?
Again, I'm not a tax person, but I think part of the income that I was paid for my work at Ellenwood PC was categorized as salary, and part of it was categorized as profits or K-1 distributions. So
Categorized by who?
by a tax professional,
Working for who?
me.
Based on the documents that you had received from L. Linwood PC, which would have been a W-2 form when you were an employee and a 1099 after you were no longer an employee. Is that right?
Yeah, I didn't have any say. I don't know why I got 1099s from Ellen Wood PC. That's just what you sent me.
You didn't have any say with your accountant on how you prepare your tax returns that you sign yourself as being true and accurate before you submit it to the federal government?
I accounted for, I don't know what you mean. I mean, my tax returns account for my income. And I don't know why you started sending me 1099s, but that's what you did.
Sorry.
I don't understand the process. I just know I started receiving 1099s and I'm not disputing it.
How old are you? 43? And how long have you been practicing law now?
I'm 35.
You're 35. I got you confused, maybe.
And
So you're 35 years old. You worked with me. You have your own law firms now, 3 of them.
Objection, Your
I'm
Honor.
not
Assumes
through.
facts not in evidence.
Overruled.
So you've been involved in your own LLC corporations, at least 3. And you're telling this jury that you don't know what a 1099 form is in terms of being for an independent contractor?
it's
Objection, Your Honor. He's mischaracterizing the witness's testimony. Mr. Wilson has said repeatedly, asked and answered this question, that
All right.
he received 1099 forms.
All right, we don't need you to characterize it, counsel. It's overruled.
yeah, no, my testimony has been that I generally understand what a 1099 is. I can't say it's only for independent contractors, but I understand it's generally utilized for that purpose. There may be others. I don't know. I'm not a tax lawyer or a tax professional. And I received 1099s from you during the relevant time of May 1, 2018 to February 14, 2020. And I don't dispute that at all.
Thank you. You remember my asking you to go to London, take the deposition of Vernon Unsworth's ex-wife in connection with the lawsuit filed against Elon Musk.
Yes, I recall that.
You remember that you wanted your wife to go with you.
Objection, Your Honor. Relevance.
Overruled.
Yeah, Julianne came with me.
And do you remember that L. Linwood PC paid not only for your ticket, but paid for the ticket of your wife?
I don't specifically recall that, but knowing who you were to me at that time, I am positive that you did that for me.
Just like you're positive that I gave you tickets to a large number of Atlanta Falcons games where I had seats at the time.
I don't know about a large number, but
Well,
you had season tickets and you shared them with me on occasion. And as always, I was very grateful
Never
for.
charged you a dime for them. Did I?
No, I never asked to be paid
With
for
your
them.
wife. And sometimes your friend Elaine, remember him?
Yeah, I mean, I think so. I think so.
And I did the same thing for you and your family with respect to giving you tickets free to go to Atlanta Braves games, didn't I?
I specifically recall at least one instance of going to Braves games, and as always, appreciated your kindnesses.
And do you recall when, forget the background, do you recall when your wife expressed to me her desire to go to the SEC championship game in which the University of Georgia was playing?
I recall that you purchased suites and hosted a lot of people for really, really fun sporting events for the University of Georgia football.
Well,
And it was so fun.
let me see if this will refresh you, because I remember exactly where we were. I had 4 tickets. You get a ticket.
Yep. Mr. Wood, we're getting in that direction.
So I had 4 tickets to go to the game. Your wife
Say
went,
objection, Your Honor.
He's trying to correct it. I think you're getting all right, just continue. Next question.
so both for the University of Georgia SEC championship game, you and your wife attended at my expense as my guest, right?
Yeah, you gifted it to us and it was awesome.
And then with respect, that same year, I think, I gave you tickets to attend the national championship game involving the University of Georgia. Did I not?
I'm fuzzy on if it's, I think we lost that SEC game.
Did. Or
So it wouldn't have been
Georgia
the-
did. I'm not a Georgia Bulldog.
So I don't think it would have been the same year, but we definitely went to that national championship game against Alabama, and talk about fun until that dart in
And
overtime.
did I provide the tickets for you all to go?
Yeah, you gifted those to us as well.
Your wife is a big Georgia football fan, isn't she?
We love Georgia football.
So the answer is yes.
Yeah, we love Georgia football.
And those tickets, were not cheap. Cost a lot of money to buy a ticket to a national championship game. You know that, don't you?
Yeah, I don't know what they cost, but again, I mean, you gifted them to us because we were so close and we so appreciated it, and we just had a blast with you.
And then in your first year as an associate up in Marietta, you made something around $50,000.
It's in that neighborhood.
Sorry?
Yes, in that neighborhood. As I said earlier, it was more than that, but it was less than 60.
That would
That
have
was my
been the year
testimony.
2016.
No, that would have been between October. I got barred in October 2014. So, and I joined you in November 2015. So in that year, the 12 months preceding me joining you, I would have made somewhere between $50,000 and $60,000 at that law firm.
And then in the year 2019, you would have been a lawyer for less than 4 years, right? All right,
I
about
don't-
4 years.
Yeah, at some point it would have switched from 4 to 5 in 2019.
So in 2019, you had been a lawyer for somewhere between 4 and 5 years.
Yeah, I think that's right.
And how much money did you receive from L.N. Wood in 2019?
I think as was talked about yesterday, the Ramsey CVS.
I'm asking you for a simple question. How much money did you receive from L.N. Wood in 2019?
I don't remember a specific number. I think it was close to $800,000.
$800,000. That's a big jump from $50,000 as a first-year associate to $800,000 4 years later. Would you agree?
Oh, yeah.
Had you ever made $800,000 as a lawyer before that?
Nope. You did all those things for me. And I'm never going to be anything but thankful for that time period in my life.
Thank you for being being full of gratitude. I understand. I appreciate it. Even if I don't agree with it, strike that. So you're a good golfer, aren't you?
Objection, Your Honor.
I think I know where he's going with it, and we overrule.
Thank you.
Golf's a relative game, and so in my eyes, I'm really not all that good. But I play against the golf course, and
Sorry?
I play golf is a game you don't play against others. You play it against the golf course when you're an amateur, and it's a relative thing. Golf course usually gets the best of me.
what? Get the best of the pros. That's not my question. You're a good golfer. You know that.
Yeah, it's a relative thing. I mean, I'm just qualifying it to, as an amateur who plays golf occasionally, I generally agree with that statement.
Played more than occasionally when you worked with me. It was not uncommon for me to let you leave work to go with me out to the country club of the South, or even up to the golf courses at my then home in Lake Oconee. And we regularly played golf together, didn't we?
Yeah, I just don't agree with the let me leave the office thing. You invited me to play golf with you, and I was so happy to go, and it was awesome.
I gave you the time off. How about that? I could have gone and said, you
Yeah.
stay and work, I'm gonna go play golf.
Yeah,
I
absolutely.
gave you the time off. Weekdays.
Absolutely. You invited me to play golf with you all the time, and we had an awesome time.
And you brought your friend several times, Elaine was his name, right?
At least a couple, yeah.
And in all those years, in all those golf rounds, I paid every dime for you to do that, didn't I?
Did.
I'm sorry?
You did. Another one of your acts of kindness towards me.
So 2016, when I hired you, took you from 45 to or $50,000 a year to 75,000. That was an act of generosity and kindness, wasn't it?
No, I don't view my, that was a two-way street. I was very proud to get the chance to work with you, and I absolutely believe I deserved and earned that. That was no kind of gift, but nonetheless, I appreciated it.
So you have a position, and I'm not disagreeing with you, but as I understand your position is, you believe that you earned the right to be respected by me, right?
I don't think that's what I was saying. I was just saying I have enough self-worth to believe that I was good for that position, and that the compensation was absolutely fair. And I think you and I had a lot of mutual respect for each other. Did.
Yeah, you've lost respect for me.
Oh, yes. Not for all the things you did in your career and all the things you did for me before this space and time. I'll always respect you for those things. But as far as what you did to me, I don't have any respect for that.
Have you ever looked into how I feel about you and what you've done to me?
Objection, Your Honor.
Yeah, I think we're gonna need to. I don't see that line of questioning.
Let me try this. Do you believe, sir, that given what I had done for you as a lawyer, not just in compensation, but in experience, teaching you, do you think that as of September of or August of 2019, that I had earned the right to be respected by you in my law office?
Yes, and I did respect you, and I cared so much about you, and I was so loyal to you. And if it hadn't been that way, there's no chance we get to February 14th. The relationship would never have gone that far if I didn't care so much about you and I wasn't so thankful and have so much respect for you.
You remember that you said the problems seemed to start September, but really October, November 2019, right?
No, I said it was either August or September of 2019.
August, you and I were out in Los Angeles dancing and having a good time about the must deposition. Remember that?
In early August, that's the case. I just don't know if the event that I'm thinking of was late August or September of 2019. But you said it was October, November, and I'm disagreeing with that.
But we had a lot of problems. Certainly, you would agree during the month of November. So much so that I called y'all all to a meeting at my home at the time in Lake Oconee, and we had a sit down.
Let's break it up. So if you want to see if he recalls this meeting, then we'll go to the next.
You recall the meeting we had, Nicole and John, Ms. Wade, Mr. Grunberg, you, Mr. Wilson, my son, Matt Wood, You remember that meeting for a weekend we had at Lake Oconee?
Yeah, it was around Thanksgiving of 2019.
And we had been having a number of disputes in the office before that meeting, had we not?
I don't remember disputes prior to that meeting. I just remember you being very difficult and demanding, and I don't remember disputes. I took your direction as a general matter. I don't remember big disputes except for the one I'm thinking of in around late August or September
But you
2019.
weren't even a party of it, too. That's that alleged assault of Jonathan in California.
I was there for the aftermath.
Yeah,
And
and we have Jonathan and I have a dispute about what happened. You know that. He got his story, I got mine. I'm not here to talk to you about that now. I will go over and let Jonathan get upset and talk about it when he's on the stand. I'm going to stick with you for the moment. You and I had not had a dispute, had we?
yeah, because I wasn't disputing things with you. You started treating us differently around that time. You were different, but it was still a manageable working relationship for me.
Do you think that you started treating me differently around that time? Where it had reached the point that it was not a manageable relationship for me trying to get ready for the must trial?
No, and the thing you're talking about at that meeting is the proof's in the pudding, and I felt an absolute obligation to give you my view of what you were going to do for that trial and the claim that you were going to just dismiss. And that's what was upsetting to you. And
So you thought you had a better idea of how the case should be tried, and that became a source of controversy between you and me and Jonathan and Matt.
you got put on a witness list by Elon Musk's lawyers right before that meeting, and you decided to dismiss a claim for our client where Elon Musk had told the media that he was a child rapist who married a 12-year-old child bride. And we've been litigating it for a long time. And instead, your decision was to go try a case on Twitter where Elon said, "Never heard of this English expat guy living in Thailand. Sorry, pedo guy, but you asked for it." And I told you then, and I tell you now, that trying pedo guy on Twitter versus trying an email to the media where he calls him a child rapist who married a 12-year-old child bride was not a good decision. I told you that then, and you temporarily fired me because you were my boss. You temporarily fired me, and then you rehired me based on my passion for trying to protect that client's claim on that email to the media.
We're not going to debate the merits because the judge doesn't want us to do that now. Let's just cut to the chase. You disagreed with my approach to the case, right?
Yeah, and I did so specifically for the benefit of.
In your objections.
I was as kind and respectful to you in articulating my thoughts and opinion on that matter as I always was, and I absolutely agree with you that you didn't like that I wouldn't just follow or get out of the way. I agree with that.
You don't recall raising your voice and yelling at me and interrupting me and telling me I didn't know what I was talking about in terms of the Musk case in my very law office?
I never told you that you don't know what you're talking about. That is, and I also dispute that I raised my voice at you. It was never my place. As you have clearly conveyed, you were amazing and you had all the power, and you would have never let me raise my voice at you. I mean, that's just.
Or constantly interrupt me.
Objection, Your Honor. He wasn't done speaking.
But he'd gone, I think, and said his share. So continue, Mr. Wood.
So.
Yeah, well, he has to interrupt me. Question.
Let's go ahead.
All right, I think it's ready for the next question.
If I'm hearing you correctly, you were totally blameless. Everything that went wrong was 100% Lynn Wood's fault. Am I getting that right?
No, I don't know what you mean by what went wrong. If you're.
What led to all this litigation?
Oh.
in terms of what happened, you said the relationship changed in November or September, whenever you dated. At one point, you said that it went downhill and it never did anything but go downhill, but then that's not true, is it? Because by your own admission, in January the 23rd, you were thrilled by the opportunity to work at Wood, Wilson, Grunberg, and Wade. Which one is the truth?
So
Did it go downhill and never come back up?
Objection, Your Honor.
Or
He's
did it
asked
go-
three
or did it
questions now
go
and has not given
downhill?
Mr. Wilson an opportunity to respond.
Okay, that was a long question, Mr. Wood. I think we need to make it more direct. And
Thank you. I
Go
I
from
have to
there.
witness on cross-examination. Sometimes the questions get a little long.
Understood.
Look, you told this jury it went downhill and starting in September and it never went back up. It just kept going downhill. You told this jury that under oath, did you not?
I did, and I also explained that I considered our relationship to still be manageable until beginning January 27th of 2020. And no, I get to answer the question.
I didn't say anything.
And there's no inconsistency there whatsoever. And in this position that we were in, where we were trying to manage how much we loved and cared for you and wanted to be there for you and also for our clients, and make this work. And so, yes, it continued to go downhill. It never got better. But it was still a situation that I was willing to gut through and get through until February of 2020, when it became just, there's no hope of any kind that I could be in your life as of February 2020. But no, it never got better.
Well, why did you take all those referrals from me?
Sorry.
Did you not realize that I was trying to help you even after we'd had these disputes and had reached an agreement? And then I sent you 40 or 50 cases to try to help you in your new firm? I've got the text messages where you wrote me.
Objection, Your Honor. He's now asked two compound questions and he's continuing to testify.
Well, let's just take it one question at a time. Yeah, I think the question was, why'd you take all those referrals?
Yeah, so the firm ultimately, I think I said, took two of them, and you were referring us, generally speaking, matters that were in our wheelhouse, that being plaintiff's defamation work, generally speaking. And I didn't see any reason not to be taking them. At that time, we had signed the March 17th agreement, and new firm, needed business. And the second question you asked, in retrospect, I can see this just like the $500,000 line of credit. You are an amazing lawyer. You know how this trial is how this dispute would play out. And I just have very little doubt that you were doing that, because the same time you were doing that, sending us referrals, you were planning and working with your lawyers and then calling Todd McMurtry to figure out how not to pay us. And I know you want that evidence in this case, but I just see it differently than you.
I was working with Joey Burby and Chris Marquardt to not pay you? Is that your testimony?
Yeah, what you conveyed to your lawyers and what they.
All right, now we're getting into the opinion of
Okay.
evidence and exhibits. And I don't see why his opinion matters. Their opinion is what matters once they hear this
Someone
evidence.
said it, I didn't.
I know, but what I'm saying is I think we can move on.
But that's the answer to the question he was asked. Can he at least finish his response to this one?
I think the whole subject matter is at this point cumulative. It's been covered and irrelevant. Let's move to the next question.
Pinpoint the date for me where it became a disaster never to be recovered from in terms of our relationship.
I think in retrospect, it was probably February 10th. But as a matter of fact, it was February 14th. It was the moment in time that I walked out of your law office in my employment and worked for your law firm. It's February 14th.
February 14th. Have you ever gone back, Mr. Wilson, and taken a look at the text messages you sent me after that date? Have you ever done that?
Yeah, I'm sure I was very kind to you as I generally am, and because at this point, I'm just scared of you. I'm trying to appease you.
You're scared. You're scared of me physically?
Yeah, did you hear you say I'll fight you till you damn die and I'll beat your ass with a switch till you can't sit down for 20 fucking years? Did you hear that?
I did. I said it.
You assaulted me on January 27th.
There we have it.
Yes, I'm scared of you.
Let's wait for the question and answer. Mr. Wood, question.
Mr. Wilson, I was very upset with you.
Objection.
Yeah, that sounds like testimony, Mr. Wood.
Yeah, can we take a break just a second, Lord? Lord.
I think our relationship has changed, Mr. Wood.
That was less than,
Can you give me some idea of how much time you think you have remaining?
I think less than the 57 minutes I have left.
All right, how much time are you asking for?
10 minutes.
All right. I mean, I'm going to go I'll let the jury step in the back. You let us know when you want to pick back up. And when the light's on, we'll resume.
Thank you very much, John. Yeah.
All right, yeah. So this is a tight 5 minutes, all right?
Thank you.
What time y'all be usually going to? 5. Oh, cool. Have, 1200. What time they get out? They get out at 5, don't they? Upstairs? Well, they want to at least go up there and they can turn these waters in. They can fast it to me. No, I want to go up. They could be. Oh, okay. I thought you had somebody new. No, nobody. I give them the trust copy for 2 days. I mean, change the board. You know, I need to turn out there. That would. I guess I'd be set up for first appearance. I guess I got to legit for first appearance. Video. First appearance. I got the ball. Yeah. I saw how they might bring you back on TV. I'm sorry, like, then we got first appearance before you go to first meeting. Go to, pick it up. See. That's, you know, there, see, Yes, some are, so, like some that are office, they don't see them to them. That's. I had one line. I had to go there that night. Got them over here.
Oh, wow. First American Pope.
Yeah.
Whoa, that's huge. He was not the favorite, I don't think. Like the betting markets.
You want to tell them?
Oh, wait, we're live streaming, aren't we?
Yes.
Well, yeah, you can't hear you bad.
So I guess it's not going.
Yeah.
And you
Or water or anything.
Oh.
And well, I turn it off every time they come out. Yeah. Yeah. All right, there they are. We get the jury.
Oh. I think I picked up a.
Yeah.
Jules pen. And I think I picked up a Jules pen. Party committed blasphemy. I don't want to commit theft. But the Lord forgives me for it. Praise the Lord. I'm sorry, John. And I would have one issue to take up.
All right. We're on the record again. Mr. Wood?
It's my position that I have the right to ask Mr. Wilson to affirm that before the lawsuit was filed, that I offered to have it resolved by binding arbitration before a four-judge panel appointed by the state bar. Now, why?
Halt. Yeah, halt. Sorry.
So the immediate question is, well, wait a minute, that's settlement discussions.
Sure.
It is, but it's not. It's much more than that. It was interesting that a lawyer, I won't tell you who, but made the point to me. They're accusing me of fraud and that I never intended to pay them. The fact that I made an offer of binding arbitration goes to my state of mind to show that to refute the idea that they come up with that I never intended to pay them. If I never intended to pay them, why would I offer binding?
No, I understand the argument. And so, the first I've heard of that. So let me get a reaction from the plaintiffs.
Yes, Your Honor. The correspondence that he is speaking about that this offer was made in is pure settlement negotiations. And it was not even a full offer for binding arbitration on all of our issues outstanding. So this notion that Mr. Wood somehow gets absolved from liability because he offered to.
It's not about absolving liability. Y'all have brought a fraud claim. It opens the floodgates to so many of these issues. We wouldn't be talking about golf and football if you hadn't brought a fraud claim, but you did. And so now we get to explore all sorts of things about intent we wouldn't otherwise. And so we've got 408. It's got an exception paragraph. And so I'm wondering if it falls within the exceptions for 408. I don't know. I don't know the timing. I haven't seen this exhibit. First thing that comes to mind, though, is I don't know if this necessarily needs to come in through Mr. Wilson just to affirm something that he's aware of. I think it could.
Let me make, how about this suggestion? Certainly the lawyers that made the proposal, Joey Burby or Chris Marquardt, they could, if the judge finds that it's
I think we could defer the issue.
admissible, as if it's admissible evidence on the issue of state of mind, as I submit it very much is, and also on the issue of impeaching his testimony about not wanting anything to be public. So there's two issues. If you don't want it to be public, agree to the mediation. If Wood never intended to pay you, why would he offer binding arbitration? So I think it's relevant, but we can look at the law and address it before Joey Burby or Chris Marquardt take a stand.
So I'm open to that suggestion as to whether impeachment is an appropriate exception to 408. That is something where I'm honing in, and just by reference, I'm looking at Milich's courtroom handbook, and it's pretty definitively here saying that they are not admissible as prior and consistent statements to impeach a party in reference to 408 and compromise negotiations. So while there are certain exceptions to 408, it seems that solely for the purpose of impeachment is not going to be one of them.
Well, let's strike that one.
You have another option perhaps, but I think we need to flesh that out through argument.
That's the one about the fact that
through
it goes
intent.
to my state of mind to refute their allegation that I never intended to pay them.
Right.
Why in the world?
I get your argument, but we
Yeah.
got a jury waiting. And so it's not going to come up through Mr. Wilson, but it may later. Is there anything else we need to take up?
Not on behalf of plaintiffs, Your Honor.
All right. If not, if we could bring in the jury, we still got our deputy back there perhaps.
You know who the next witness is going to be?
I certainly do not, but
I don't either. God knows. He knows everything. Y'all know who the next
y'all
witness is
decide
gonna
on your
be?
next witness. Because if so, we also need to talk about the time I'm going to allot for the next witness.
Excerpts from Todd McMurtry.
Okay.
Going to be another live witness.
All right.
today.
We're bringing the jury.
I'll just send you on.
All right, for the jury?
Okay. Judge, they're going, when they get to the deposition excerpts, I may have to step out for 15, 20 minutes.
Is it just playing?
Sorry.
You just you're fine if they keep playing them though, right?
Oh, yeah. No, I'm not
Oh,
asking
okay.
to
I
stop.
don't mind that at all.
It's just not as necessary for me to be here while it may be necessary for me to be somewhere else.
That's fine.
I'm much better than I was, I'll tell you that.
All right, give us that kind of point.
Thank you, sir. All right, defense may resume.
Ready?
Yes, sir.
So you've defined your disagreement with me about the strategy in the Unsworth versus Musk case. Have you not?
In respect of your decision to dismiss the child rapist email, yes.
Right. But that went into evidence in the case. You knew that.
You dismissed the claim.
That evidence went in during the trial and you know it.
Yeah, just without a claim based on it. So we had an email. So yes, it went into evidence where the jury saw that Elon Musk called our client a child rapist who married a 12-year-old child bride, but then they didn't get to consider if that was defamatory.
You know what a pedophile is?
All right, Mr. Wood, I don't want to relitigate this entire, I don't know how long that trial was, but I think we've touched on these points. If you got new points to bring up.
Well, I was trying to cover this point, but let me try it a different way. With all due respect, Taylor, I listened to y'all ad nauseam. I gave you every opportunity to argue with me, including inviting you and Matt and Jonathan and Nicole to a weekend meeting at Lake Oconee so that I could hear you out completely. True?
No, I don't agree with that. And but it was your characterization of this meeting as being this big time when problems started. And I was just identifying what you consider to be the problem.
I didn't say that. Problem started earlier in that meeting. I'm focusing you on the meeting. You came up there and you know as a matter of truth that I gave you and Nicole and Jonathan and Matt a full opportunity to air out to me what you thought should be done so that I could consider whether to agree with you, modify your approach, or disagree with your approach. That happened, didn't it?
We absolutely had an opportunity to convey to you our sentiments about it. I don't agree that you were there to consider them and reason them out, but that's your state of mind. But that's not, I don't agree with that characterization.
I didn't waste, you think I wasted the time to hear you out? Strike that. So we had the meeting. I listened to you. And I said, this is my decision. This is what we're going to do. Either get on board or don't go to California. I said that to you, didn't I?
You said something along those lines.
You bet. I told you, I'm not going to get out there in front of a jury in California and tell my team to go left and sit there and argue with you during that trial because we need to go right. I told you that specifically, didn't I?
Yeah, you were very angry.
I was not happy.
No. Can I?
Yep.
So.
All right. So let's rephrase the question.
Mr. Wilson wasn't done speaking.
I think he's withdrawing the question, so he can re-ask the question.
So the bottom line is, you decided to follow what I wanted done, the way I wanted to do it, because you went out to California for a week under my leadership, right?
Yeah, I didn't have a choice in the matter.
You didn't have the experience to have a choice. How many lawsuits have you ever tried before a jury before the Elon Musk case?
I think I had only participated in one. And
Who?
At King and Yakland, and it wasn't much of anything.
Small case.
Yeah, and which is, you're right. And you know, you had me second chairing you, and then Saturday before, despite that inexperience, you had asked me to be lead counsel, and then the night before the opening at 10 p.m., you asked me to give the opening statement.
I wasn't, Taylor, you know that I was very.
Objection, Your Honor. He's
Yep.
testifying.
Let's make that a question.
Didn't I express to you, Taylor, I had concerns about whether I was going to be physically able to go because of the sickness I had, and I had to have somebody ready to go in case I couldn't because the judge had specially set the case for Monday morning. Didn't you know all that?
You did that on Saturday, and I'm articulating to you that despite my inexperience, you selected me to be lead counsel in your absence. That's all I was responding very much to your theme here.
I only had three choices. You, Mr. Grunberg, or my son, Matt.
Well, and at that time you weren't, sorry.
And because, strike that. And I asked you, could you do it if I ended up not even being able to get out there? Didn't I?
Yeah, but you were not planning on bringing Matt at that time. Matt Wood, you were trying to figure out whether you were even going to bring Matt because of other disputes that had nothing to do with between you and Matt.
Let's move to strike that. Matt was there.
Objection, Your
Well,
Honor. It's response.
I know, I denied the request. You can ask your next question.
Matt Wood was in the meeting.
Oh yeah, no, yeah, he was there, but it was whatever happened at Thanksgiving between you and your family. And then you changed your mind and Matt came with us to Los Angeles and was part of the trial team.
So you had to make a choice. You either were going to recognize that I was going to lead and you were going to follow, or I made it clear to you, get out of the way. Right?
Yeah, you were my boss.
I had 45 years experience as a trial lawyer. You had tried one minor case. How many trials had Jonathan Grunberg tried as of December of 2019? Zero.
Objection, Your Honor. He's answering
Let's
his
make
own
that-
question.
I know.
You knew he hadn't tried a case.
Objection.
I've already ruled he's rephrasing the question.
Listen, I don't know that, but if what you want, if I think the reason that you had me working for you is because I was reasonably capable and if what you're saying is I didn't want your input, I accept that. And you made the decisions. You were the man, you were the boss, but I'm not someone who I'm not just a yes person. And so I expressed to you my beliefs. It angered you, and the rest is history.
I'll be able to talk about why I was upset with you. Wasn't because you disagreed.
Okay, you don't need to go any further than that,
I gave
Mr.
you
Wood.
every opportunity to express your positions to the point of going up and spending a weekend at my then lake house. I wanted your input, didn't I?
Yeah. To the point of, we had not had this discussion about you dismissing this claim until we got to the lake and you told us all. And we expressed our immediate reactions and thoughts on that. And you became very angry and upset about it.
So we're not here, and Judge McAfee's not going to let us. We're not going to debate the merits of what I did and why I did it. But I had a good reason for doing it the way I did it, and I told y'all what it was.
Well,
I told you what it
If he doesn't
was.
like Mr. Wilson's answer,
I guess you can state that more in the form of a question, even though I think we've covered this already, whether he had an opinion, you had an opinion. I think it's
I
time
fully
to.
explained why I disagreed with you based on my analysis and experience, didn't I?
You offered explanations to us.
Just didn't agree with it.
And I also, I don't even think I agree that the explanations you gave or why you did what you did, but you certainly gave us your reasoning and we gave you ours. And, it made you mad.
That's your characterization.
Okay, we'll stop there. Next question.
Characterization is noted. I'll ask the next question. Thank you. You just told the jury a few minutes ago that you knew in November of 2019 that I was the boss and I could fire you if I wanted to, right?
You absolutely could have.
And yet, even though you claim I was so mad at you because I disagreed with your approach, I didn't fire you, did I?
You literally fired me for like 24 hours. Like you literally directly fired me.
When was that?
I think the day we left after brunch at Reynolds, you literally fired me for like 24 hours.
I don't recall that, but it wouldn't.
Okay, Mr. Wood, the wheels are getting real wobbly again, and the rest of the time is going to be forfeited. These comments, we can have the personal comments. We've covered this. So let's keep going.
So I fired you for 24 hours, is that your testimony?
Somewhere in there.
And I had the absolute right to do so for whatever reason I wanted to, didn't I? Because I was the boss and the owner.
Yeah, the reason you could fire me was because I worked at your law firm as a lawyer of your law firm. If I wasn't, you couldn't have fired me because
you
you
were.
can't fire people that that don't work for you. That's not how that works.
You can fire an independent contractor if they don't do what you want, can't you?
You know, I guess you can terminate their services.
You can fire an employee, salaried employee, if they don't do what you want, can't you?
I really would like to finish my answers if you would allow me to, Mr. Wood.
Are you making an objection? I'm sorry.
I'm just asking.
All right. I mean, the question is, you've answered it, and I think it was within the scope. I don't think there's much more to be added there. We'll move on to the next question.
January the 23rd. 2020. Pinch me. I must be dreaming. So your words, right? Your words, right?
I think that's what it says. I know it says pinch me. I don't specifically recall the dreaming part, but, and, you know, as always, I was 30 and got to be Linwood's partner. I mean, it was amazing. Please pinch me.
But it wasn't so amazing that at age 30, where you were my partner on a case-by-case basis.
Objection, Your
And
Honor.
my
He's
partner-
adding in his own testimony that the list.
I don't think it's gotten to that point yet, but we have covered this ground already, Mr. Wood.
I think we have touched on it, and
Okay.
I'll be able to go through why I used the word partner. I may have touched on it in the opening statement, but I'll do that in my testimony.
Okay, because we already talked about the pinch me, I think, at the very beginning. So let's find some new area that we haven't talked about already.
You said of the many cases I sent you, remember me sending you a case from Harlan Prater in Alabama?
Objection, Your Honor, to the extent that it calls for attorney-client privilege information of these potential referrals.
Okay, all right. Mr. Wood or Mr. Wilson, don't reveal any attorney-client privilege in answering the question.
Yeah, I remember, I actually thought that predated. I think you had Harlan deal with me on a matter, but I think it was before I left the law firm. But if it was a referral afterwards instead of you just telling Harlan to call me.
Syndrome until our case.
Okay.
All right. I'm sorry.
I know that Harlan, we worked with Harlan on the other thing, and then I just don't recall the content or the timeline of Harlan coming back into our lives.
That's okay. I've got it all on my phone and I can discuss it myself when it happened. You did say very clearly, you seem to say that you only looked at 2 of the 40-some cases I tried to send you all, or did send you.
Objection, Your Honor, misstates the witness's testimony.
The jury will call the evidence. You can ask the question and the witness will answer.
You said on one of the you only really looked at 2. Am I wrong?
No, we looked at every single referral that you sent to our firm. We only engaged, I believe, on 2 of them. That's my testimony.
One, you didn't make any money, you say?
Yeah, well, we withdrew from the case and we didn't try to have our clients pay any
Then
outstanding
you
bills.
say you resolved one for a reasonable fee. When did you resolve that one for a reasonable fee? I don't want to know the name of the client.
I want to say it would have been in 2022.
And what was the reasonable fee that you received from that case that I referred to?
Objection, Your Honor,
Yeah.
violates order and calls for confidential information.
I'd like to be heard on that if necessary, because it's an important issue and I think it's relevant.
Unless you can show Mr. Wood that you had some knowledge of the size of what the fee could be, the ultimate result of it, I think, is irrelevant.
I think I had a good idea what the fee could be. I don't
Okay.
know what it was.
Then I think that would be relevant, but probably not the way it's phrased.
In excess of a 7-figure fee.
Well, no, see, the point I'm making is the actual fee isn't what's relevant. It's what you thought it might have been at the time you referred it,
But
or
Your
what
Honor,
they thought it might have been at the time you referred
it
it.
didn't matter. What it came out was, here's somebody saying, this guy's trying to destroy me.
Well, I've ruled, so ask the question.
All right, here's
You-
the question. It's plain and simple. How much was, you testified that you got a reasonable fee. My question is simple. What was the amount of the reasonable fee?
I've explained how I think this topic could be relevant. And
Tell me now.
well, I'm not going to coach you, Mr. Wood.
If it could be relevant, let's discuss why it's not.
I thought I'd explain that. The total amount that he did end up getting, I'm not finding that that's relevant. If you think it's relevant to state of mind, then what you thought it was at the time of referral is relevant.
I think it's relevant evidence to refute their claim that I was out trying to destroy them.
I'm not disagreeing with you, but you have to answer the question, or excuse me, pose the question appropriately. So ask the next question.
I'm not sure how I can pose it other than ask him, how much was it?
And
Why wouldn't you tell me?
because I've already said he can't answer it because I found it's not relevant what it actually was.
But I'm suggesting, and I don't want
I know what you're saying, Mr. Wood. You're not listening to
not
me,
be
though.
relevant to refute the idea that they say that I was trying to destroy them.
Objection,
If-
Your Honor. He's
Okay.
If
denying
hypothetically,
all
I sent them a case worth a lot of money.
And I understand your point. What I'm saying is what it actually resulted in is not relevant. What you or what the other parties thought it was at the time you referred it is relevant.
What was the nature of the case? What type of cause of action was it?
Objection to the extent that it gets into attorney-client privilege information, but otherwise, Mr. Wilson can respond.
Okay, you can proceed, Mr. Wilson.
That you can.
It was a defamation claim.
Who was it against?
I believe it was against the Associated Press.
So without being able to ask you the amount, would you at least agree that it was a significant recovery by your new firm?
No, just.
You can answer the question.
No, we worked, really loved that client. We worked really hard for him. You know, we had to split the fee with another local counsel. And I'm not exactly sure of the amount, but it was nowhere close to what you've suggested to the jury, and I'm happy to tell you. Okay, I think it was about $100,000 fee, and we worked really hard for that client.
So now we've got $100,000 fee. So now we can go into it.
Well, you've gotten the answer that you wanted. The details where we go from here, whether it's worth going into, we'll see.
You split the fee, the 100,000 fee, or would you get 100 and some other firm get 100?
It's just thereabouts.
What do you mean thereabouts?
Yeah, I can't specifically recall the amount. I think maybe the total amount of the fee was about $100,000 is what I'm telling you. We worked hard to do that. It's not like you sent us the case and then poof. There's money there. That's not how it works.
Yeah, I agree with you on that. You don't just.
All right, Mr. Wood, I got you.
We all work hard for what we earn, don't you agree? We're supposed to.
I think it's good to have personal responsibility and to earn your way in life. I agree with that.
Reap what you sow, right?
I think that's a fair concept.
It's definitely a fair concept. It's in the Bible.
All right, Mr. Wood,
Your Honor.
that's going to be the end of this cross-examination. Thank you, sir.
Thank you, Judge.
All right. Any redirect?
Honor, briefly.
Take your time when he's cleared the table, but you do only have the 4 minutes for redirect.
Thank you. Hey, Mr. Wilson, why was WGW Wade Grunberg Wilson LLC incorporated in 2018?
Because at that time, Mr. Wood was contemplating actually disbanding the firm. And so the three of us were going to go out to create what created Wade Grunberg and Wilson specifically with his awareness. In fact, we had a discussion with him about whether or not he could be of counsel at our firm or we could be of counsel at his firm if we were going to go our separate ways. But then he got the Steve Wynn representation and decided to keep the firm together, as we've seen in the Happy Camper email where he says the firm will remain L. Linwood PC.
So Defendant Wood knew you guys set up WGW in 2018.
Absolutely.
And did WGW operate at any point in time from the time it was filed with the Secretary of State to the time that you left L. Linwood PC?
No, I think we just reserved the name and filed like the technical incorporation documents or something that you have to file to create an LLC in the state of Georgia. And then we didn't maintain it at all. In fact, I think we had to like repay and reactivate it sometime around February 18th or 20th of 2020.
So you didn't have a website?
No website, no clients, no engagements, no emails, nothing.
Y'all still just continue to work at L. Linwood PC because Defendant Wood decided not to retire. Is that right?
Yeah, or decided not to go out on his own. He's changed his mind and said the firm will remain L. Linwood PC. The only thing that's going to change is Taylor and Mr. Grunberg and I will be identified as partners on the website.
And were all the bar complaints that you've testified about that were filed against you and your partners, Nicole and Jonathan, were they all dismissed?
Yeah, to the best of my knowledge, they've all been dismissed. Yeah, pretty routinely, I think.
And did the dismissals make any sort of determination or postpone any sort of determination related to the outcome of this lawsuit or any other lawsuits that may involve Nicholas Salmon?
That's an entirely new concept to me. I don't believe that happened at all.
And have you discovered any other secrets that the defendants did during the time period where after you guys signed the settlement agreement until now throughout the course of this litigation?
Any?
You testified about some on your cross-examination with Mr. Wood about finding the smoking gun emails and then the recording with Todd. Anything else that you can think of in regards to the settlement money?
Without trying to be exhaustive, I learned that not for Sandman, but for some of the other clients that are subject of the March 17th, 2020 settlement agreement, Mr. Wood had already transferred the entirety of those fees from L. Linwood PC to himself before, weeks before we had even signed the March 17th, 2020 agreement. And also almost immediately after receiving the Sandman fees, Mr. Wood transferred all of those fees to himself from L. Linwood PC rather than holding in trust or anything what we may claim.
And I'm going to hand you what's been marked as Plaintiff's Exhibit 325. I believe you testified about this. And Your Honor, this is not in the link, but it is the text thread with Matt Wood that was talked about at length on Defendant's Cross. And I'd like to move to have it admitted into evidence.
All right, is there objection to 325?
Michael, it's the next one.
Mr. Wood, do you have an objection to
So
325?
325.
No objection.
All right, 325 is admitted.
Thank you, Your Honor.
Council, I'll give you a minute to address it, but
Yep,
that'll be the end of your time.
Thank you.
Right.
Why was defendant Wood's son, Matt, asking for an intervention?
Objection to the form of the question. That would require him to know what Matt's state of mind is. They can bring.
Yeah,
Matt
you can,
if they want.
well, you can rephrase the question.
Did an intervention ever happen?
Not to my knowledge.
And based on your conversation with Matt that we went through earlier, and that's depicted here at 325, what was your understanding of why an intervention was being brought up?
Objection, hearsay. They have to bring Matt Wood here.
This is the conversation it's already been admitted in 325. And so I think he can characterize his interactions. Overruled.
Go ahead.
Matt Wood was concerned about his father.
Objection, Your Honor. That's hearsay.
Well, it's already admitted. So I think that's already. So, all right. Are we done with redirect?
Well, he didn't get a chance to respond, but that's
Oh,
going to be
okay.
the last response. Yes, Your Honor.
What's your response to that question?
That Matt Wood was concerned about his father.
Okay.
I'm sorry.
That Matt Wood was concerned about his father.
Nothing further, Your Honor.
All right.
Briefly, Your Honor.
Yes, sir. You can on recross on those points raised in redirect.
Were you concerned about me?
I thought you were behaving in a way that it would be useful to bring it to your attention in the most safe and positive way possible.
Are you aware of the fact that Matt Wood never bothered to follow up?
Hearsay.
Very quickly, if I could.
Well, if he says his sole opinion was based on these texts, so I
Right.
think you're confined to these texts.
I'm trying to stay there. Do you have any knowledge of whether my son, Matt Wood, the concern you say he expressed, ever did anything about it to see how I was doing? Do you know one way or the other?
I think Matt Woods cut you out of his life entirely because of your behavior.
That's not the truth, and it's not responsive.
All right. No, I don't think that was responsive to the question. So
I'd ask the jury to disregard that.
disregard that question. Mr. Wood, you can ask the next question.
You said on redirect that we got the Steve Wynn case. That's not true. I got the Steve Wynn case. That's the truth, right?
He's testifying and mischaracterizes the witness.
Strike that. You knew that Steve Wynn hired Lynn Wood, not Taylor Wilson. True?
Yeah, I think I literally testified that when you got Steve Wynn as a client, you decided to keep the firm together and said the firm will remain L. Linwood PC and nothing will change except how we're identified.
And that the way I split up that fee with y'all on the hourly basis, you recognize that that was a very lucrative deal for you.
Redirect.
I don't think I remember covering Mr. Wynn in redirect here.
He mentioned it, I thought.
I mean,
He said we got the Steve Wynn case. That was on redirect. And it doesn't matter. I mean,
Okay.
he's acknowledged that Mr. Nguyen hired me and didn't know who he was.
All right. Do you have any further questions for recross? All right.
No.
All right. This witness can step down.
Thank you, Your Honor.
All right. Plaintiff may call the next witness.
Yes, Your Honor. Plaintiffs called Todd McMurtry by way of deposition video testimony. It's second to get set up.
All right.
John, if you want to. Please.
I'll ask the jury if apparently they got some tech issues or we can hold in place. Seems like I'm seeing it only takes one. They want to stay in place. All right. Is that a, okay, we did have one. There we have it.
Back here.
Oh yeah, feel free to stretch in place.
Judge, thank you. I'll be back in 3 minutes.
Okay,
And John will be here while I'm here.
understood.
Okay.
Did we ever decide, Judge, how the procedure was gonna be? They're gonna show a video.
It sounds like it. I don't know about the mechanics.
About putting the transcript out, and that's not, we talked that wasn't.
I don't remember us discussing that. I don't know what the,
They just play the video as if he was here.
I think they're playing the video. Are you showing scrolling text or anything like that as well? Okay, so it's just a video.
It has the text in the deposition.
Well, it's under.
Right, that's what I'm referring to. So just FYI, counsel, it is video and text underneath apparently. That's what they're telling me.
And for ours, we're gonna read the transcript part of this.
Yeah, however y'all want to do it.
They said they got and I'm gonna go change that real quick.
I got a present for you. Oh, the house owners.
You don't have to say.
But I don't know. I mean, don't they have to like re-raise? Sure. Yeah. I used those.
Yes, you okay? Oh, nice. I hope not.
Yeah, that would be helpful. Thank you.
Early.
Every time I look at
And so, and what are we doing with this exactly? These are going,
That's what we're going.
and these are going to the jury or what are
Yeah,
we?
he's gonna put them all into evidence one at a time.
Okay.
Deposition excerpts.
Okay.
And he identifies, puts these,
Oh, these are just the exhibits. Okay.
Right.
Gotcha.
I'm gonna be short here if you want.
Yeah. There you go.
Let me see. Mine.
Okay, well, let me, just members of the jury, before we actually get to the exhibits, let's keep these binders closed, okay? Just do that for me. We okay?
This week is going by pretty fast. Yes. I didn't have the brain. Taking the case off there.
That's why, because I didn't have it. Oh, I got you. Is this it? Oh, okay, perfect. Okay. Thank you. Thank you for your patience. I think we're trying to go back to this one. So then they just like change the input back to 2. Yeah, it's on 3. So it's definitely on the right thing. Your or extend display from the menu, it says. True.
Yes.
We may have to do your option. No, it's loaded, so.
That was my story.
Part three in the case of Nicole Wade et al. Versus L.
I guess it woke me up.
Close. We're definitely on the right hand side.
Hey. All right. Thank you for everyone's patience. Let's see if we can.
Right.
Thank you.
McMurtry in the case of Nicole Wade et al. Versus L. Linwood et al. Today's date is March 27, 2024, and the time is approximately 10:21 a.m.
Can we pause it for just a
My name
second?
is Irving Farkas, and I'm the videographer. The court reporter is Lynn Fullwood. All counts are present, and on the video conference, please introduce yourselves and state your affiliation, starting the noticing attorney.
Okay, Ms. Brown, can you pause it just for a second?
Rubio, I represent the plaintiffs.
I'm Madeline.
Okay, and then can counsel approach?
Yes.
Resignations, 8 months.
Taylor, what the parties that I represent Mr. Wood and Ellen Wood PC. Sorry.
John Exum, I represent Mr. Wood and Ellen Wood PC also.
There we go.
All right, members of the jury, as you may have gathered, the plaintiff is electing to publish a deposition that was taken related to this case, and you should consider this as if it were a live witness, the same as any other testimony of a witness. And I've been told that this will last approximately 2 hours, so we're not going to finish it today. We'll go right up to 5, and we'll finish the rest tomorrow morning. And so I would say that until the exhibits are being referred to or have already been talked about by the witness, you've all been provided a binder with these exhibits, but let's not look at them until the witness actually talks about them. And then from there, you can look at them. Anything else we need to take up before we proceed, or any other instructions on behalf of the plaintiffs?
We can tender at different times, but
I don't know if that's the most efficient way to do it.
we should do it all in.
Okay, how about that, Mr. Exum?
Sorry, could you please?
I think they just want to tender it in bulk, maybe at the conclusion of the deposition, or should we do it now so they can actually be referring to it during the deposition?
Well, we do want them to refer to it now. That's why we gave them the binder. So if you look through and see if you have any objections, you were at his depot.
I was.
Yeah.
And my recollection's not as fresh on the exhibits. I don't think that I'm gonna have any huge problem with anything, but I don't know that.
If you do, let's just make it
Okay.
in real time. We'll pause it and then you can make the objections.
All right, so tentatively, they're tendered, reserving your ability to object as they come up.
Right, I'm just a little bit hesitant to
Yeah.
give them the full binder before I've objected.
And so that's why I'm going to instruct you, members of the jury, don't look at any exhibit until the witness has referred to it and there's been no objection. All right? And so with that, I think they wouldn't be looking at anything and preserve your ability to stand up and say, hold on a second, let's not use that exhibit. But
Okay.
for now, as they come up, they're in, and at the conclusion of the playing, you can tender all of them.
Thank you.
Thank you.
Okay, with that, we'll publish, I don't know what you would refer to this as, an exhibit or just a deposition?
Position.
Okay, all right. Deposition of Mr. McMurtry.
Todd McMurtry in the case of Nicole Wade et al. Versus L. Linwood et al. Today's date is March 27, 2024, and the time is approximately 10:21 a.m. My name is Irvin Farkas, and I'm the videographer. The court reporter is Lynn Fullwood. All counsel are present, and on the video conference, please introduce yourselves and state your affiliation, starting with the noticing attorney.
My name is Drew Beal. I represent the plaintiffs.
I'm Madeline Brown. I also represent the plaintiffs.
Taylor, what the parties that I represent Mr. Wood and Ellen Wood PC. Sorry.
John Exum, I represent Mr. Wood and Ellen Wood PC also.
Doug Gilfillan, and I represent Todd McMurtry and his law firm Hammer Wessels McMurtry.
Thank you. Would the court reporter please swear in the witness?
Raise your right hand for me, please. You solemnly swear or affirm testimony you're about to give is the truth and nothing but the truth to help you God.
I do. This will be the videotape deposition of Mr. Todd McMurtry, taken for preservation of evidence and use at trial for cross-examination and all purposes provided under the Georgia Civil Practice Act. Mr. McMurtry, good morning. Can you tell the jury your full name?
Todd Vanderveer McMurtry, my mother's maiden name.
Thank you. You grew up in the area of Kentucky where you practice law. Is that correct?
Correct.
All right. And that's around the town of Covington, not too far from Cincinnati, Ohio. Correct?
Correct.
All right.
I don't want to sit over there.
And I believe that you've been practicing
I want to sit. I
about
can sit there.
35 years. Did I get that correctly?
Yes.
All right. And you specialize mostly in complex litigation, is that correct?
Yes.
And you've had various leadership positions with the Kentucky Bar Association and the Northern Kentucky Bar Association.
Correct.
And those are two different bar associations, right?
Yes.
All right. And in Kentucky, as in Georgia, the Bar Association promulgates the rules regarding ethics and the conduct of lawyers within that state. Is that correct?
They propose the rules. They're ultimately approved by the Supreme Court.
And they assist in enforcing those rules. Is that correct?
Correct.
Thank you. Let's talk about your relationship with Lynn Wood and the plaintiffs in this case, Nicole Wade, Jonathan Grunberg, and Taylor Wilson. Would it be okay with you if we refer to the three of them as plaintiffs or WGW?
Yes.
Okay, it'd save us some time. You were first contacted by Lynn Wood regarding, how did you first come to meet Lynn Wood?
I called him on the phone.
Because Nick Sandman had retained your services, is that, or indicated that he wished to retain your services. Is that correct?
Correct, sorry.
And tell us who Nick Sandman is and in general terms, what the claims were that he had when he first contacted you.
And I'm going to object based on attorney-client privilege and the work product doctrine to the extent that you're asking him to talk about claims or potential claims at that point and communications with Nick Sandman. Subject to that, go ahead.
So Nick Sandman, at the time that I met him, was a 16-year-old boy from, I believe, Independence, Kentucky, which is a suburb in northern Kentucky. And he was a student at Covington Catholic High School.
And had he been the subject of various news stories in Washington, D.C. regarding some type of exchange or confrontation with a group of Native American demonstrators?
Basically, yes. He was in Washington, D.C. An incident occurred. It went viral and national, and he was the subject of that.
And so when did you first?
I think we're good. He's muted his phone. That was Reyes' phone.
Okay. When did you reach out to Lynn Wood?
Within 3 or 4 days of being retained on the case. I would be the following week, so the week in the 21st timeframe.
I'm sorry, I didn't ask. What year?
2019.
Okay, so we're talking about January of 2019, and you reach out to Lynn Wood. Is that because he was a well-known defamation lawyer?
In part, a friend of mine called me, said that Lynn was a well-regarded defamation lawyer.
And did you discuss with Lynn a joint representation of Nicholas Sandman?
I did.
All right. Let's turn over to document 16 in your book there.
Got it.
Does this appear to be one of Lynn's early communications to you on January 21st, 2019, where he's talking about scheduling an initial meeting with the Sandmans?
Yes.
And does he refer to Taylor Wilson and Jonathan Grunberg as his partners in that communication?
He does.
And did you
gotta say
understand?
Objection.
Then pause the video.
Okay.
All right,
Taylor,
Mr. Exum.
Jonathan, and Nicole, I just did it again.
All right, and sir, I gotta have you on that trigger finger, okay?
Just one
Mr. Exum.
second. Did you admit this over this? I saw this earlier today, this very
It's
same.
admitted.
It's okay.
All right, objection
withdraw,
withdrawn, we can
excuse me.
So
proceed.
y'all can look at it.
And so again, we'll just say as the witness gets, or the exhibit name, the number is read, then I think Mr. Exum would know whether he objects because he's got this in advance.
Yeah.
But once he says the exhibit number, then y'all can look at it because by then I should have heard an objection, right? All right, let's press play.
Were Lynn's partners at that time?
By virtue of this email, that's what he told me.
But I mean, did you, when you met them, let's ask it this way. So the meeting took place the very next day, is that right? After
Correct.
this email, on exhibit 16. And did Lynn or the WGW folks introduce themselves or represent that they were partners in a law firm?
I recall that Lynn said that they were his partners at the meeting.
Thank you. Throughout your representation of Nick in 2019 and into the beginning of 2020, did Lynn routinely refer to the WGW folks as his partners to clients, the court, or other attorneys?
I only recall that in some of the pleadings, I believe they were referenced as partners. Some of the initial complaints that were filed, maybe they were on that line. That's my recollection. He and I did not discuss that. He didn't, when we spoke, he didn't say, my partners. We just didn't discuss anything one way or the other about their status.
Other than that initial meeting?
Correct.
And how about representation to the court? Do you recall any time when Lynn said, one of my partners, referring to either of the three plaintiffs here?
I believe he did refer to Taylor Wilson as his partner at a conference with the trial court judge.
Thank you. Let's turn over to Exhibit 18. Does this appear to be one of the three motions pro hoc vice that you filed on behalf of, one of the four pro hoc vice applications that you filed on behalf of Lynn Wood, Taylor Wilson, Jonathan Grunberg, and Nicole Wade?
Yes.
All right. And if we look at page 2, under memorandum, the first sentence of the second paragraph, you state under local rule 83.2A1, Mr. Grunberg is a partner with L. Lynn Wood PC.
I do state that, yes.
And did you make a similar representation? I'll represent to you that the other documents were produced regarding Taylor Wilson and Nicole Wade.
That's my recollection, yes.
Thank you.
Sure.
Let's look over at Exhibit 21. Take a second and look at Lynn's email back to you dated January 14th, 2020 at 5:58 p.m.
Your Honor. Pause. May I approach? I just
Sure.
need a follow-up question. I guess the challenge is Washington. Yeah. The big. You know, do I need to sort of, it's called the starts?
Yeah, but you don't want to be here. But you're gonna go, it's coming up because they say it's an order.
So that's. Yeah, okay. All right. Well, I think that's on solid. Well, I guess we have to go against the next graph. So it's enough stuff. Okay. Let's see how. But this is really about that position, so. Awesome. Yeah, so on the policy, it's like 7 lines on doesn't. That's all the direct. Yeah, from into the part that also. This is an evidentiary issue.
McAfee?
Yes, sir.
Can I? Ask- Yeah. Well, sorry. And that was it.
There is no. Nothing. There is no certain practice. That's people last every deposition you can. Eight fronts up and success in deposition. But there is no. I would ask the police. I would ask the James, brief issue. My first designation. Right. If you're ready to leave, stay with people. The beats became one side. It's third before we to which stop. No group. Let's see where we are. But am I getting just good research? But I got some. Yeah, so for yeah, so that's you care for us. Attack my fraternity school. She's just a place she plays and that's all. Not a number of found. Yes. Oh, okay, I'm sorry. I agree with you. That's not a cross. We're still gonna go to J2. I think it's let's go to
And actually, did they preserve an objection to 82?
I think what they did in privilege. But the privilege. Moved on. Said it's okay, answer it.
Well, they did.
Come on,
I'm gonna take a closer look at it.
Required to raise it.
Well, that's what we're about to find out.
I
don't know.
Disagree, and that's why we gotta
I
have
know.
time to look at it before Judge Mack.
Okay. We're gonna figure it out. All right. Okay, let's continue. We'll continue publishing, members of the jury, trying to make the best use of our time.
You want me to look at the email for 5? I see it. Yeah, you're pointing at it. I recall this email. Thank you. And in that email, does Lynn say, Taylor speaks for me unless or until I can speak for myself? He does. And did you understand that Lynn was directing you to Taylor Wilson whenever you had substantive questions about the Sandman case, and he was not available.
That was my understanding based upon reading that email.
Let's look over at Exhibit 38. And this is an email that you produced from Taylor to you and Kyle and Will of your firm, and copies to other people. Do you remember receiving that email?
Yes.
All right. And so Taylor's signature line is Wood, Wilson, Grunberg, and Wade. And that email is dated February 12th, 2020. Did you understand that sometime in January and the first half of February 2020, WGW had formed a partnership with Lynn Wood called Wood, Wilson, Grunberg, and Wade?
I did understand that to be the fact.
Thank you. Let's look over at 39. And is this a retraction demand dated February 13th, authored by Taylor Wilson with a copy to you, sent to Democracy Now! Productions, Inc., with a new letterhead of Wood, Wilson, Grunberg, and Wade trial lawyers?
Yes.
And that confirmed your belief that they were in a firm, at least at that point? Objection point.
Yes.
Thank you. And by February 13th, the Sandman settlement had been agreed to and executed by the lawyers for the various parties. Is that correct?
I think the initial settlement had been with CNN. I don't recall if the Washington Post settlement had occurred at this time.
I'm sorry, I should have been more precise. I meant the CNN settlement.
That's my recollection.
Thank you. Now let's look back at Exhibit 17. Ultimately, you entered into an agreement to represent the interest of Nicholas Sandman with Lynn Wood and L. Lynn Wood PC. Is that correct?
Correct.
All right. And this Exhibit 17 is that January 28th, 2019 agreement that set forth that agreement to hire you.
Correct.
Thank you. All right, let's look over at page 2. And I am on the 5th line down of the paragraph beginning on that page with the words "clients also understands." And I'll just read it into the record and we can talk about it. Clients also understands that the firm may associate joint and local counsel in the prosecution of this matter if necessary due to jurisdictional requirements, and that the firms have the right to select and or associate with additional attorneys as necessary with your prior approval. No additional attorney's fees shall be owed by client under this engagement agreement as a result of L. Lynn Wood PC and or Hemmer DeFrank Wessels P. LLC associating with local or other counsel in this matter. And L. Lynn Wood PC and Hemmer DeFrank Wessels P. LLC agree to compensate such counsel out of the contingency fee earned by L. Linwood PC and Hemmer DeFrank Wessels PLLC under the terms of
Recording in progress.
under the terms of this engagement agreement. Did I read that correctly?
Yes.
All right. So it was your understanding that this agreement gave you and Lynn the authority to hire other firms to assist you so long as the ultimate fee charged to the Sandmans did not increase.
I believe that's what it says. Yes.
Thank you. All right. Over the course of their of their work on this file, let's review some of the work that WGW did in this case. Would it be fair to say that the WGW folks reviewed all the social media reports or broadcasts of the Nick Sandman incident, which gave rise to his claim against CNN, and selected the target defendants? That was something they were in charge of.
I don't think they reviewed all of the social media, but they did select the target defendants.
And there was a huge amount of social media. Is that right?
Oh, yeah. I misspoke. I was referring to news reports on broadcast stations. I obtained all of those in the process. I think that the WGW people did review the internet for social media posts.
Recording stopped.
That's fine. Just we're still good, right?
I have no control on what other side will do.
We're good. Sorry. I interrupted you, or somebody interrupted you.
I think I completed my answer. I obtained the video. I got all the videos that were on broadcast television. I was able to obtain those, and I provided those to them. We would have looked at those as well. Everybody was kind of looking at this stuff. I think Taylor was doing the work on going on the internet and trying to find stuff.
And there were a lot of internet rebroadcast, republication, discussion of this event. Is that right?
Yeah, many.
And the WGW folks were primarily responsible for drafting lengthy retraction demands to various media outlets. Is that correct?
Yes.
And why are retraction demands to media outlets so important in a case like this?
Well, Kentucky had a retraction statute that would have affected how potential damages might be awarded. If you don't send a retraction demand under Kentucky law, then you may lose your right to seek punitive damages.
And were these kind of long, detailed analysis of how the publication was false?
Yeah, the length of the letter speak for themselves. The volume of the letter sent speaks for themselves, or speaks for itself. They were lengthy letters.
Thank you. The WGW folks also drafted the complaint in this case. Is that correct?
There were 3 complaints that they drafted. Yes.
Okay. And then on the motion to dismiss, they drafted the response to the motion to dismiss and worked with you in preparation for oral argument, which you conducted. Is that correct?
Correct. I mean, people in my office would have helped, but not on the substantive legal arguments. We would have proofread, we would have compiled, we would have filed, all that stuff.
And did you divide up the labor on that motion to dismiss in large part because the WGW folks had a lot of experience with large defamation cases?
That was my understanding that they did. I can't speak today to the level of their experience, but they represented to me that they were experienced and that they understood the law.
Thank you. And then they ultimately did a motion to amend the complaint and drafted an amended complaint.
That is correct.
Would it be fair to say that they were involved in and contributing toward all the written work product in this case?
They took the lead on the written work product while they were involved in the case.
Sorry, I could have given you a little heads up in that. Mr. McMurtry, I'd like to play for you an audio of a phone conversation you had with the WGW folks and ask you a few follow-up questions regarding it. I believe you've heard it before and they've shared it with you, but I'd like to talk to you about it. Takes a minute to get started. All right, pause that for a second.
This one's good.
Okay, so while we're waiting for that recording, let's look over at Exhibit 52. And if you look at page 2 of Exhibit 52, on the middle of the page, you'll see a February 24th email that you sent to Lynn at 9:22 p.m. in which you said, need your insights on campaign issue. Can we chat tomorrow? And can you describe for us what that is referring to?
Not specifically. I can't recall specifically that conversation.
But I meant the campaign.
Oh, sorry.
Sorry.
Yeah, I was running for Congress and I was engaged in a campaign starting in mid-January of 2020 and concluding in, I think it was mid to late May 2020.
And did Lynn Wood contribute to your campaign?
He did.
And did he contribute to a PAC that benefited you?
Yes, my understanding is that he did.
How much did he contribute to your campaign?
I think it was the maximum, I think it was $2,400.
And then he contributed $150,000 to your campaign or to your PAC. Is that correct?
I don't recall the exact figure. It was over $100,000, I was told.
No. Let's look over at Exhibit 91. Does that appear to be the report of receipts and disbursements for your campaign and for certain PACs.
I don't know where it says PACs on here.
Let's look over at Bates number WGW 1722.
Okay, I'm looking for a number.
On the bottom of the page. You're there. Right. Now let's look in the middle under B, Lynn Wood.
Okay, I see that.
And does that show $150,000 contributed?
It does.
Thank you. And that was by far and away the largest contribution to your PAC. Is that correct?
I didn't have any involvement with the PAC. By law, I was not allowed to speak with the PAC, but based upon this and what I was told by the campaign personnel, I believe that to be true.
Thank you. And Lynn also contributed about $75,000 to you for to help assist you in resolving a dispute, an issue that had arisen at your law firm. Is that correct?
He did not contribute it to me, no.
And to whom did he give that $75,000?
The law firm.
Okay. All right. Now let's play. If we're ready to roll. You're close enough. Just.
Yeah. Todd, thanks so much. Again, I think we just need maybe 3, maybe 5 minutes. We've been thinking about this, the idea of an affidavit, and in doing that, we're looking hard at what's actually required by Rule 115. Obviously, we talked about it ad hoc, and our position that 1.5 has nothing to do with it because we're lawyer development with PC. But for the purpose of this discussion, some background so that I can get to my point. We'll assume 1.5 applies here. Talk about it. And the rule doesn't require quantum error. It requires between Lynn and us, the fee is proportional to the services that we all render. And right. So if what you're asking us to do is meet rule, you want us to meet rule 1.5 so we can possibly get some kind of fee approved by the client. Don't be sure it's not approved. Well, if we're actually using a rule, yeah, this is not going to approve the fee. I'm not looking to do that. The key simply said that, that's what I wrote an email way back when, and that's the question being asked when the bill was presented. So if you give me anything, I'm just going to throw it back at you and say, okay, if this is quantum error, that's we determined that we have no objection to receiving a fee, but we can't make a decision as to whether or not it's quantum error or not. I don't want to make that decision. It's very simple. Yeah, okay, all right. So, and I think this is why we're having the call. And so putting quantum error aside for just a second. So we know from you that this Lynn whole position that Nick or his parents or whoever required our time sheets or contemporaneous time records, which is not true. Didn't happen. It didn't require it. But we know that Lynn similarly did not keep any time sheets. Right. And so our concern is, and maybe it's valid hearing what you said, is that if we're going to give some kind of explanation of our services, is there anything like that from Lynn, or if you can get from Lynn that's going to allow you or the client to assess the proportionality of our fee? No, I haven't thought about that. I'm not inclined to get into Lynn because it's just going to get me sued or worse. So, my thought is that if I'm helpful to you, fix that for you, this is the value of your time. I'm not going to be the judge of that, but if this is the value of your time, then I accept that. Okay. So, and this, I guess, I don't know the rule. I looked at the rule. I'm
you know, I'm not a Georgia lawyer, so I'm not gonna get into the facts of the law in Georgia. If you got a different rule, then it seems like it doesn't matter what makes sense. And, he probably doesn't need to be involved in it, because Nick is not gonna say, okay, I approve that fee. That was not the idea. The idea was only that the idea was only that, you know, I mean, it was a tumultuous period. There was all kinds of bad stuff happening. That time I said, we need it, you know, we're gonna pay, but it has to be, you know, fair value. You know, I mean, it appears the Georgia rule doesn't even apply, so maybe that's the approach that it doesn't apply. Well, yeah, and I think the rules are virtually identical, and that's the issue. It would be clear that there's no quantum merit analysis if there doesn't object or consent to our fee, and that it's proportional to limits, right? There's no quantum merit analysis. Where did the quantum merit analysis come from? It came from me when I wrote the email 2 years ago. But so we were taking our fee by agreement with Lynn, and so there's no quantum merit analysis. I mean, Lynn, we all were on. I'll get to the point, but I guess I really don't have anything to say or anything to do. So I'll go with no benefit I can provide. Okay, so the affidavit is not with some goal of you or the client assessing it and saying, yeah, this was reasonable to take your fee. That's right. Because, you know, again, what started out as a simple request to say that, you know, Lynn's state of mind at the time that things weren't going to blow up and everything can be paid fairly, that I said, you know, everybody needs to get paid on the quantity, or you guys need to get paid on the quantitarily, and that Lynn was the, you know, the time appeared to be the factor, you know, that persuaded these people to pay all the price. And so, you know, I was trying to explain the situation and say, you know, if they want heroin, for you guys, you take early. Yeah, well, look, it makes sense to me that the clients didn't want our time sheet, but it wouldn't require Lynn. And so that, you know, it's maybe not as reasonable if Lynn had been, you know, if his letter was accurate, that the client did want our time sheets. But look, I'm glad we called because from our reading, the only reason for us to submit an affidavit to you all, even though we don't think school about anything to do with it, is to make sure that our fee with Lynn is proportional to the services that he and me provided. And if that's not the goal, yeah, I think I'll just have to, then we're just going to be reassessing this whole idea of giving an explanation of our service. Because that's not, you know, I'm beating a dead horse. Y'all know what we did. I mean, you were there for it. You know that we produced virtually all the work product coming out of Ellenwood GP. This whole notion that we're only going to get paid quantum merit with, you said it came from you. Well, okay. You know, we're just getting a third, agree with Lynn, a third of what Lynn was receiving, and a third of what you receive, subject to any, whatever Lynn, you know, paid your firm for whatever on top. But that's fine. So we'll just reassess this whole thing about an affidavit, and we'll, if we want to, you know, if you get back to you, we will, otherwise, it's status quo. Yeah, I mean, Jonathan, am I missing a point here?
No, I think that's
About whether or not we should do this affidavit?
No, I think that's generally.
Okay. So now, it's Todd, last question, I'll let you go. Can you just get to us this email you're talking about in the settlement statement that was presented to the client about our fee? Yeah, if you email me to remind me, I'll look into it. I thought you had it. I don't know. I mean, I don't recall, but I certainly provided it to your attorney. We were not involved and never saw anything presented to the client about us receiving our fees to the client. You know, I'll grab an email about, okay, so, I think that's all. I'll try to remember to send you my email, just so that, you know, we didn't want to know for the first
first time what was provided, to the client. Now we understand. You think one marriage required it, yes, because you think the work order development with PCD. And no, I don't think any of that. I thought that it was an insane situation that I was getting. You know, the things, nobody was talking to me. I didn't know what was happening. You know, like this documented detail, all of the stupidity and insanity and craziness that occurred. And, you know, I simply said, not knowing, you know, wanting people to be paid fairly, you know, recognizing that Lynn is the name of the practice. You guys are workers of the practice, that, you know, I mean, Lynn for sure does that. And, you all, you guys can forgive them. I didn't know, but I just told you that you'll be paying a lot of heroin. And that was just to try to clear up the situation. So anyway, that's all I have. I'll do what I can to help. I'm sorry that everybody can have time. Thanks, Brian.
I'm not gonna do it right now. I'm just on. Sorry.
You're good.
This is exhibit 194, the audio recording. Do you remember this phone conversation with the plaintiffs? And I believe it was in early, it was in like May of 2021.
I don't recall the exact date. I don't think it was in May of 2021 because the lake where I was at is not warm enough to swim in. And I know that I'd been swimming in the lake. I don't think May was the date, that I would have said June, but I'm not
Okay.
sure.
All right, somewhere in that time period.
Yeah.
Thank you. So we can go into all the details of the letter, but of the conversation, but I wanted to just hit some of the highlights right now. The rule you keep referring to is Georgia Rule of Professional Conduct, Rule 1.5. Is that correct?
It's my recollection.
Right. And that is a rule that talks about division of fees of lawyers. Is that correct?
Again, yes, that's my recollection.
All right. Early in the audio recording, Taylor refers to, I believe, an earlier phone conversation which you had, in which you informed him that that your clients, the Sandmans, had not requested timesheets at that point. Is that correct?
At what point?
I believe Taylor says Lynn's whole position that Nick required timesheets is not true. And in response, you said, right.
That is correct.
Okay. So when Lynn asserted that the Sandmans, early in the dispute, that the Sandmans had demanded to see the timesheets, that was not correct.
That's not correct. You are correct. What you said is correct. The answer is yes.
Thank you. Got it. And you understood throughout this entire time period that Lynn did not want Nick Sandman to consent to a division of the fees in the Sandman versus CNN case.
I don't know exactly what Lynn thought. I mean, he didn't tell me exactly what he thought.
All right, we'll get into that. And you did state that you were not familiar with Rule 1.5.
Did I state that in the phone call?
Yes.
I've read it a few times now. At that time, it was not something I'd ever worked on before. So the answer to your question is, I was not familiar with Rule 1.5.
And by the time you had this recording, you thought that Rule 1.5 may not even apply. Is that correct?
Yes.
And is that because the lawyers were indeed lawyers of L. Linwood PC and perhaps even partners of that firm?
I think it's what you told me when you called me on the phone one time and said it doesn't apply. And I said, I accept your position that it doesn't apply.
And do you remember the underlying reason that the lawyers were lawyers of L. Linwood PC and or partners of that firm, and therefore Rule 1.5 would not apply?
You explained it to me.
And is that
correct?
Explained?
Yes.
Thank you. And I believe you stated that the whole concept of quantum meruit came in large part from you as a suggestion to resolve a dispute between Mr. Wood and the WGW folks.
I always thought that they should be paid fairly for the work that they did. The answer to your question is yes.
And yeah, let's look over at Exhibit 92. Let's look over 11 pages into that exhibit, and that brings us to page 7 of an Alston and Bird communication legal analysis provided to Linwood. Is that it? And I've got a highlighted section there on sorry, we're on the wrong page. We got to go back to page 6 of the memo. And under discussion, it quotes in the second paragraph under discussion on page 6, Georgia Rule of Professional Conduct 1.5E provides, quote, a division of a fee between lawyers who are not in the same firm may be made only if, 1, the division is in proportion to the services performed by each lawyer, or by written agreement with the client, each lawyer assumes joint responsibility for the representation, semicolon. 2, the client is advised of the share that each lawyer is to receive and does not object to the participation of all the lawyers involved, semicolon. And 3, the total fee is reasonable, period, end quote. Is that your understanding that that's a reprint of Rule 1.5 of the Georgia rules?
I believe it is.
And you'd agree with me that quantum meruit is not a subject that's addressed there at all?
Not in what you read.
Okay. And if we look at paragraph 1, the division is in proportion to the service, at the very beginning, a division of a fee between lawyers who are not in the same firm may be made only if, number 1, the division is in proportion to the services performed by each lawyer, or, so is it your understanding that 2 and 3 are an alternative to complying with paragraph 1?
I'm going to object to the form of the question. I'm not sure you're describing the text of this rule as it appears in this memorandum accurately.
I'm sorry, I can't, I'm here being deposed and I haven't read the rule or prepared to discuss it. It looks to me like it's not an alternative. Let's see. It looks like you have to do all three.
But you would recognize that at the end of the first paragraph, it says or.
Object to form, same objection.
I do see the or in there, yes.
Thank you. Let's turn over to the next page, page 7. And does that appear to be the highlighted part, note 8 of the Georgia Rule of Professional Responsibility, interpreting Rule 1.5, 1.5E?
I believe so.
Thank you. Note 8 states, paragraph E does not prohibit or regulate division of fees to be received in the future for work done when lawyers were previously associated in a law firm. And did you understand the WGW folks to be previously associated with the firm of L. Linwood PC?
Yes.
So is that why you stated in this phone conversation, it appears that the Georgia rule may not even apply?
Correct. My view was what you told me led me to believe that this didn't apply.
Thank you. And so the concept of quantum merit was an issue that you first posited or set forth as a possible resolution to a dispute, not an interpretation of Rule 1.5. Is that correct?
I had read some case law in Kentucky and I read Kentucky's rule. I really thought, in my view, Kentucky law should have applied. So, I thought that there was maybe more to the discussion than 1.5. But I'm sorry, I've lost track of your question. If you could have it reread or restate.
You posited or set forth quantum merit as a possible solution to a dispute rather than an interpretation of Rule 1.5.
Correct. I wanted WGW to be paid fairly. And I wanted to take into account the various factors that led to receipt of these settlements.
Now, yeah, and whether WGW got paid half the fee in the Sandman versus CNN litigation, half of Lynn's fee, would not impact in any way the total amount of fees paid by Nicholas Sandman. Is that correct?
That is correct.
And it wouldn't impact the amount of fees that you received for your representation of Nicholas Sandman in the CNN case, right?
That is correct.
And it wouldn't require the defendants to actually increase their settlement amount.
That is correct.
The only person who would pay something more would be Linwood and or L. Linwood PC.
Correct.
Thank you. All right, now let's turn back over to Exhibit 48. Bates number at the lower right-hand corner, 2867 and 2868 appear to be February 22nd emails from Lynn to you dated 2:42 a.m. Is that correct?
Yes.
And as you can, he says, as you can easily see from the late hour of this email, I'm spending entirely too much time dealing with the foolishness of Taylor, Jonathan, and Nicole. So you understood this email to be Lynn expressing his interests about fees or fee dispute with the WGW folks.
Yes.
And I recognize that you probably didn't read this at 2:42 a.m. Just as I didn't read a lot of Lynn's emails to me at 3 a.m. But eventually, the next morning, you read it. It says in the next paragraph, I can explain more to you tomorrow by phone, but I would like to ask you to consider preparing a letter from you to Beal, meaning me, and a letter signed by Ted and Julie, the Sandman parents, to you or Beal, making clear that there is express directive that no fees be paid to Taylor, Jonathan, and Nicole that exceed a quantum merit basis, regardless of any agreement I made or attempted to make to get rid of their foolishness to prevent it from harming my future efforts for Nicholas and others. Did I read that correctly?
Yes.
So earlier, I think you said you couldn't get inside Lynn's head to know what he wanted. And in general terms, that would be fair. But in light of that express sentence, it was pretty clear that Lynn did not want Nicholas to consent to anything but a quantum merit fee for the WGW folks on the Sandman versus CNN case. Is that correct?
Well, I think you a little bit mischaracterized my previous answer.
Okay.
When I said I couldn't get into Lynn's head, I was looking more in the July 2020 timeframe. You said, do you want Lynn didn't want you to approve the settlement. And I said, I don't know what Lynn wanted. We didn't discuss that. But with regard to your question on this paragraph, I agree that it was clearly stated that Lynn wanted approval of only a quantum merit recovery by WGW.
Thank you. Let's turn over the second page. First full paragraph starts with, would you please be willing to call me in the morning and let me give you the basic details of what is going on and exactly what I would like for you to consider doing for me, and what I would like for Ted and Julie to consider doing for me, which I believe will bring this foolishness to an abrupt and unhappy ending for Taylor, Jonathan, and Nicole. So did you understand that Lynn wanted you to do something for him, do him a favor, essentially?
Yes. And I mean, it also related to managing the case. This is part of the representation of dealing with their breakup.
Thank you. Last sentence of that paragraph. Worst case scenario will be that I'll be authorized by the clients to hold my PC's portion of the CNN fee in my escrow account pending final resolution of the disputes between me and WGW. That alone will cut off their ability to finance and publicize their BS claims against me. Did you understand that by that Lynn wanted to make sure that the WGW folks did not receive any money which might finance their claims for recovery of their fees against him?
That's what it says.
Thank you. Next paragraph. I will look forward to hearing from you, and I'm very much looking forward to seeing you, Kyle, and Will in Greensboro on Sunday morning. So you met with him shortly after this email.
We did go to Greensboro the following Sunday, and he was present.
And is Greensboro his lakefront house?
I think it's on that Reynolds property?
Reynolds Plantation.
Right, yeah, there is a dock access to the lake in the back of this house. It's on
Thank
the
you.
lake.
Thank you. All right, let's turn over to the next page, which is Bates number 2869. And I'm directing your attention to the middle of the page. Another February 22nd, 2020 email sent approximately 12 minutes later at 2:58 a.m. Subject line, all in bold, a good idea, exclamation point. Do you remember receiving this email?
Yes.
All right. It starts with, I'm very much looking forward to seeing you, Carl, and Will on Sunday morning in Greensboro at the airport, which he had said just 10 minutes before. The fourth paragraph on that page, second sentence, while there has well, let's start at the beginning of it. There was no oral or written agreement between me and any of those lawyers concerning any share of my firm's fee in the CNN case. Did you understand that to be an accurate statement?
The only thing I understood is what he said there. Let me read it again.
And remember, this is February 22nd.
I took Lynn at his word that there was no oral or written agreement between him and any of the WGW lawyers concerning any share of his firm's fee in the CNN case.
Did you later come to understand that there was actually a written agreement on February 17th between Lynn and the WGW folks for an equal sharing in the CNN fee?
I believe only through this litigation did I discover that.
Thank you. Next sentence, while there has historically been such agreements documented in writing in the past, absolutely no such agreement was made orally or in writing with respect to any of the Sandman cases pending or to be pursued in the future. Then we turn over to the next page and tell me if this doesn't seem to contradict his prior statements. I have tried to negotiate with Taylor, Jonathan, and Nicole about a fair percentage of payment for their efforts in relation to the CNN case. Those efforts on my part have varied between offering an hourly quantum merit payment to a demand by them for 35% of the fee, to which I confirmed to them I would pay them 50% of my fee. So did you ever talk to him at or around this time that he had confirmed to pay them 50%, not that there was no oral or written agreement regarding sharing the fees?
I did speak with him. My recollection is that there were a lot of issues that were to be determined. I didn't perceive that a final agreement had been reached, but I would have read that sentence at the time.
Thank you. Second to last paragraph on this page, starting with I need for you and Ted and Julie to state in writing that Ted and Julie do not and shall, I believe it means shall, not agree to any fees due to my PC be divided with any other lawyers except on a quantum merit basis. Presumably he means quantum merit basis. I am confident that they have the right to control the fees. I am confident that their right to do so exceed my right, if any, to be coerced into paying these greedy lawyers 50% of my fee. Did I read that correctly?
Yes.
So you understood the next morning when you read this that there were two urgent 2:45, 2:55 a.m. emails urging you to get Ted and Julie to refuse to any fee sharing that did not include quantum merit.
That's what he wrote, yes.
And then on the last page of this email, it says, will you help me? I will be up early and driving over to Reynolds tomorrow and look forward to hearing from you on my cell phone to further discuss any additional details which you need to know, etc. So he was driving over. Does this appear to be the meeting that was scheduled for the right after that at Reynolds Plantation with you, Will, and Carl of your firm?
It'd be actually Kyle, but yes, Kyle, Will, and I flew down there for that meeting, and I believe that's what he was referring to.
Thank you. Now, if we turn over to Exhibit 45. Does this appear to be another 2/22/2020, in other words, February 22nd email, this one at 3:30 a.m., 3:31 a.m.?
Yes.
And it states, and the subject area is one last email. He states, it just dawned on me that in addition to hitting Beal with a letter from you and Ted and Julie tomorrow, you should also notify him tomorrow in writing that you will be dispersing all settlement funds through your firm's escrow account. You can inform him that you shall not disperse any funds for all caps fees to L. Linwood PC until all issues are resolved between me, my PC, and Jonathan Taylor and Nicole, or a court of competent jurisdiction orders otherwise. That alone will screw these greedy lawyers to the wall. You will be able to disperse your own fees and expenses to my PCs and my PC's expenses, but you can hold my share of the fee until you are ordered to disperse it or until there is an agreement by the parties allowing for payment of L. Linwood PC fees. Did you understand that Lynn was insistent upon having you agree to hold fees in escrow as part of his request regarding the division of fees in the CNN v. Sandman case?
That's what he wrote, yes.
And then the third paragraph states, in combination, our efforts on Saturday will deliver a knockout punch to Taylor, Jonathan, and Nicole.
Is there a question?
Did you understand that to be Lynn's desire to prevent receipt of any money by WGW that would assist them in funding their claims or litigation against him?
That's what I took when I read this. That was my understanding.
The next paragraph says, game, set, match. If you agree with me, I hope you do. Quantum Merowith is all these greedy will get, despite my coerced agreement to pay them 50% of a fee that at a time when their mutiny and wrongdoing was unknown to me. So did you understand at that time that Lynn wanted WGW to only be paid in quantum Merowith?
That's what he said.
Let's look over at Exhibit 46. When you spoke to Lynn after he wrote these the next day, either on the phone or as you were flying down to Reynolds, did Lynn ever express a concern to you that WGW might file suit against him to recover a portion of the fees that he may or may not have agreed to in writing?
I'm sorry, could you reread the question?
You want me to just phrase it again?
Yeah,
Did he ever say
I wandered a bit, sorry.
Did he ever say he thought WGW might resort to litigation over the CNN v. Sandman fees?
I don't recall that specifically. My best recollection is that he would have said that. he certainly implied that in these writings. And otherwise, I would have expected that they would have resorted to litigation were they not paid for their work in the case.
And did he ever express to you any concerns that the WGW folks might sue over fees in other cases?
That I don't think so. I don't recall that. It may be in here, but I don't recall it.
Any other cases that you were working on, such as the other Sandman cases?
At this time, I think there were only 3 cases filed. And I knew that WGW had worked on all 3 cases, and I would have expected that they would have sought fees there as well. I don't know that I quite answered your question, but that was what I was thinking.
Thank you. That's fine. Let's look over at Exhibit 46. Is this the letter that you wrote me about, let's see here, 9 hours after receiving the 3 emails from Lynn?
Yes.
All right. And you start off, it said by email to me at my old firm, and it says, I write as counsel for Nicholas Sandman and his parents, Ted and Julie Sandman. And you understood as of February 22nd, 2020, that the WGW folks had left L. Linwood PC, and that there was a dispute regarding the Sandman fee. Is that correct?
Yes.
And then in the third paragraph, the third line down, you say, I have advised the Sandmans that there may be a dispute between Lynn and his former colleagues. Is that correct?
I'm going to object to the extent you get into the content of any communications with the Sandmans, but if you're just asking if that's what his email says, then of course he can answer that.
Yeah.
That's what my email says, yes.
And you had done that, is that correct?
Again, I think the fact of communication is he can testify to that, but I'm going to instruct him not to answer to the extent you get into the subject of any communications with them.
Well, when did you advise the Sandmans that there may have been a dispute between Lynn and his former colleagues?
I think this dispute had been bubbling for a while. Not that morning, but somewhere along the line.
All right. And we saw the email where they had formed a law
Why don't we stop here?
together as of February 13th, and this is
Can we pause it for
February
just a second?
22nd. So is it?
Just think. This one, to the end of 49, page 49, or is he still mid-exhibit?
I thought so.
Okay. All right, I missed that. All right, you can continue.
Your understanding that wording or that explanation would have occurred somewhere in that 9-day time period.
Correct.
Thank you. And you state, to that end, I wish to advise you that upon a court's approval of a minor settlement, I will deposit the CNN settlement monies into my firm's escrow account, distribute monies to Nicholas Sandman, distribute fees to my firm, and pay to L. Linwood PC its costs and expenses. I, however, will not distribute monies to your client or Linwood for fees owed absent an agreement among the parties or an order by a Kentucky court directing me to disperse the monies in a particular manner. Did I read that correctly?
You did.
And is that essentially what Lynn had advised you to offer to me regarding the WGW fees?
Well, I made an independent evaluation of this. Lynn was not well at this time, and I thought that it made sense to make sure that we protected the money and that it could be distributed by agreement at the time that an agreement was reached.
Thank you. But you would agree with me that the verbiage that you have used here in this email to me is identical to what Lynn had stated to you.
It's identical in substance. I don't think it's verbatim identical. There may be overlaps in there, but I certainly did consider all these points independently.
There's nothing in this language that I read that was contingent. Is that correct?
I don't know what you mean by that.
That you would hold the money under certain circumstances. The statement there is that you categorically will hold the money. Is that correct?
I think absent an agreement among the parties is my intent. I will not distribute monies to your clients or Linwood for fees owed absent an agreement among the parties.
So if there's an agreement among the parties, you would distribute the fees according to the agreement. If there isn't an agreement, you're going to hold the fees until a court of competent jurisdiction tells you what to do with them. Is that correct?
Correct.
Thank you. Okay. Next paragraph. Further, it is my opinion that the
I don't, we at the stopping point? Okay, we're getting close.
Sandmans control the fees to be paid from the CNN settlement and at best are obligated to pay your clients in quantum merit for their services. Now, this statement that it is the opinion of the Sandmans that they have control over the fees is also a sentence that is virtually identical to what Lynn wrote to you.
I'm going to object to the form of the question because I think you said it is the opinion of the Sandmans, and the letter or email says it is my opinion.
All right, let me rephrase the question because I'm not trying to trick you with it. I just misstated. Further, it is my opinion that the Sandmans control the fees to be paid from the CNN settlement. You would agree with me, would you not, that that sentence is another, or that clause is another statement that Lynn Wood expressed to you in his late night emails?
It is. I think it's also correct, but it is what he said, yes.
Thank you. And then you go on to say, and at best are obligated to pay your clients in quantum merit for their services. Is that correct?
That's what I wrote, yes.
And so the subject of at best pay quantum merit for their services is also something that Lynn stated repeatedly in his various emails.
It is.
And is that the statement about quantum merit that you talked about in the audio recording when you said, I'm the one that introduced the subject of quantum merit way back when I wrote that email as an attempt to work out a dispute?
I can't recall exactly what I said on the audio, but I agree in general that quantum merit was, I mean, it would only make sense that people would be paid for their work in a fair manner.
All right. If we could pause it there, members of the jury, thank you for your attention today. As always, please don't discuss this case with anyone, including amongst yourselves, and don't do any research about this case. If we could see you back at 9 a.m. tomorrow, leave the binders in your chair. Take your notes back inside the jury room, though. All right, we'll see you back tomorrow morning.
Laughing here. Oh.
All right, counsel, unfortunately, I've only got about 4 or 5 tight minutes here for childcare issues. I got to run, but I want to flag 2 issues for you. One, I want to give the jury an update tomorrow of whether my time frame is still accurate. So for that, I'm going to need kind of a rundown tomorrow morning of the plaintiffs of just generally how many more witnesses they expect to call, how many more depositions they expect to tender, same information from the defense, so I can still kind of estimate where we think what day closings fall.
Yes, Your Honor. Plaintiffs intend to call one more witness via deposition testimony. It's a lot less than.
It's real short.
Mr. McMurtry is examined. Then we will have one witness, who is a very short witness, will be on the stand for less than 30 minutes. And then Mr. Grunberg and I anticipate that his testimony will be a lot shorter than this way, Mr. Wilson's.
Okay, we'll get to the timing and the clocks because I'm going to continue to utilize those when we get there, but I appreciate that update. On behalf of the defense, are y'all ready to make any kind of a ballpark estimation? I know Mr. Wood has promised to testify, so we've got one there, but anything else?
Before I do, man, just to remind the court, we're going to look at this issue about the admissibility.
Oh, absolutely. I'm going to tee that up. I'm going to tee it up and then I'm going to run. So we're going to do that, but
May have, sounds like, I just don't know if will they finish tomorrow.
that doesn't sound like it. Oh, you think you will? Okay.
We'll be done tomorrow.
Sounds
All
like
right.
maybe early afternoon.
I hope so.
Your Honor, if that's true, then I would like to ask the court if we could adjourn early so that I can drive. I've got to drive
Yeah.
back to South Carolina.
There's no point in me making the decision now because I have no idea if that's actually going to stick, right?
Yeah, but I also have Chris Marquardt and Joey Burby, who are lawyers. They've been in limbo all week, and I'd like to be able to tell them, come in Monday morning, we'll be ready to go. But I would like to, instead of putting me on the stand tomorrow.
I mean, if we end at 2, I mean, if they rest at 2:00 on Friday, that's a good 3-hour chunk. Maybe we could get one of those lawyers over with.
Well, I know we can't get Chris Marquardt because he's got a conflict. We told him we would accommodate it. Whether we can get Joey, probably. But I've got to drive back to South Carolina. And then I've got to drive back to Atlanta on Sunday. And if I could get an earlier start tomorrow, it would be orderly to bring Chris and Joey in on Monday morning. Then I'll get on the stand. And then I think we're pretty much done.
I want to, if we could, I think we just need to play this out tomorrow morning or as we see how things progress, because I could see us getting bogged down again. Depends on what objections come up. Depends on how many times we got to send the jury out. I just can't make that promise today.
Please consider it.
I'll consider it. But again, the paramount is going to be me trying to stick to the jury's, the promise that I made to them. All right, let me just, again, I'll take argument in the morning and we can hear it, but the issue raised is whether the defendants have waived objections because this deposition, okay.
They can just make objections to the testimony as it's coming in or the exhibit. And I think getting into this waiver thing is going to complicate and slow us down. So
It's complicated. It's not as clear cut as
That means we'll have to stop his deposition and argue it each time.
But, well, that's not so much as what he's saying is he's giving up this waiver argument, which we can get academic on it, but I guess apparently that's going to be saved for another day. So as designated, those are the objections that I'm hearing defendants are raising to the it's okay. To the testimony that's coming up. To that end.
We'll just make those at the time.
Well, I mean, you can, at the same time, I think I'm actually ready to rule on most of these. The only one I'll say that I think at this time, I'll look at them again tonight and tomorrow morning. The only thing that I think is on 403 grounds would be cutting 8314 through 8413. If we could write that down. Of course, 8314 through 8413. And that's just going into all the reasons, the specific reasons that they felt that Mr. Wood no longer should be involved with the representation of Sandman, the hanging of Mike Pence, all these really specific statements. It literally skips to his representation became untenable.
Pence still alive?
You'll have to ask him.
I don't think I can.
All right. So that was, so other than that, I would say we'll go from there. All right. I'll have rulings for you in the morning on the rest of it.
Judge?